Hello guys, what's up? I hope all of you are doing good. So here we are. Let's start with what you guys have been waiting for, your company law marathon. In this video, people, I'll try to take you guys in depth, try to cover every topic as much as in detail possible. In addition to that, if you guys have any questions also, feel free to ask. Use the comment box below. If there is any other video you guys want me to go in detail about it, I'll be more than happy to do it for you. So yes, without any delay, let us start with today's company law marathon. So first things first, the most asked question will be, sir, what will be the weightage and which one to cover? I've already given something like a 12-day strategy, people, how to cover entire company law. You can find it on the same channel where you are seeing this particular marathon. So I've given how to cover the company law in 12 days using the marathon as well. So you guys can please go through that. And this is the weightage along with the order you guys can follow. Sir, is this the order which we will be doing now? Answer is no, but this is something which you can follow in terms of your preparation. Yeah, this is the highest preference. This can go as a least preference. Yeah, and in the marathon, I'll also try to cover the amendments if there is anything applicable for your attempt, even including that, I'll be trying to cover it. Yep. So, yes, this is minimum marks. This is maximum marks. That is what, of course, people, I've taken it based on the statistics and the past data. This cannot be completely accurate. Of course, there are attempts where they have not asked marks at all from some of the chapters. So I just have to put 0 there. Agreed? So I've just taken it as a based on a statistical data. What has been the minimum marks that has been allotted and what has been the maximum marks? And I always tell people this part is always a crap. It shouldn't be considered at all. But because a student asked me, sir, tell us the weightage, ABC analysis, whatever, only for your satisfaction I do it, but you cannot consider it at all. Because people, see, there has been one attempt where they have asked 15 marks from general meetings chapter. There has been an attempt where they have asked just 4 marks. So, no, there has been now, if I say people, this is very important, and if you just believe that you are going to get some 14 marks out of it, and if you go, and if it ends up coming as 4 marks, versus you would have left some chapter here, and from this, if they ask some 4 marks, it's gone. So it cannot, statistically, it cannot go wrong. I mean, it cannot, whatever we have taken is statistical data, but practicality is something different, right? So you should always give your senses to that. Remember, all of you. Okay. So with this, let us start your company law marathon. Okay. Now people, first things first, I'll be using one material here, something called as chart book. Please don't ask for it because of certain IP issues. We have seen people taking it, editing it, just printing it, private circulations, all of that happens. This particular document here has taken immense effort to work about and to bring it to your table. What I would suggest is whichever the books as of now you guys are using, please continue to use that. Yes, if you guys want hard copies, it will be available on Arivupro website, and I'm not promoting for you guys to buy it. But as of now, whatever you guys have been using it, you guys can continue to use that itself. Clear? Okay. So let us start the first chapter, sir. Company law and practices. Okay, fair enough. Okay. We'll start with which one? We'll start with the nature and characteristics of company only. Easiest one. Okay. What is a company, people? A company is a separate personality having a corporate existence of its own. So company is different from its members. We have various case laws. One is Salomon versus Salomon, the most popular case law in itself. A company was incorporated and the company had 2 debts. One is belonging to Salomon and one was outsiders. So, whom should we try to prioritize first while we are repaying? Is it Salomon or the outsiders? Remember, Salomon had a secured debenture while outsiders did not have secured debentures. So the company prioritized repaying Salomon first. Outsiders questioned this fact. How can you repay your own shareholder or director first and outsiders next? Who would do that? So in this case, they went to court. Court decided, remember, for a company, whether you are a shareholder or you're a creditor or even you are an outsider only to the company. The shareholder and the company are not one and the same. Once the company is incorporated, they are two different identities. Same thing happened with Lee versus Lee Air Forming Limited as well. So next one is artificial person. That is, it can hold property, it can sue, it can be sued in its own name. Yeah. There is a question here. What is that, sir? There was a case law called as Union Bank of India versus Kather International Construction. In this case, what happened? There was a case that the company had to file, but the company did not had any money left with it, not even a single rupee. So whenever you do not have money, people, can you still fight a legal case? Answer is yes. There is a provision under Indian law, just that you need to file an application called as pauper application. What is pauper? If you guys remember, we used to file, we used to play in carom, right? You pay that pauper, the person who becomes insolvent, a person who has no money left. We generally call it as a pauper. So you need to file something called as a pauper application. You can also call it as people indigent person. That is, you can file it as a pauper application. Now, what is that? Pauper is nothing but an insolvent. So the question is, under Indian law, we have a provision. If any person becomes a pauper, you can file an application saying that I don't have money. Can you please help me fight this case? And can you please accept our case? If you are an individual, you can still go to the court, because the law has given you a right. Any person who doesn't have money can file a pauper application. Now the question before the court was whether a company can be considered as a person. Is that coming under a pauper application, or is it only for an individual? That was the question. Now people, in this case, it was decided that even a company can also be considered as an indigent person. That is, you can be considered as a poor person and you can file a pauper application, because even it is a person only, but not a natural person, but a artificial person. That was the case law. Simple, clear. Okay, the third characteristic of a company, sir, company is not a citizen. However, there is a case law called as R.C. Cooper versus Union of India. In this case, what happened, people? Try to remember the judgment. That's sufficient. Remember, the fundamental rights are only given to the citizens of the country. Yeah, like right to speak, all these things, right to movement and all, it's only given to the fundamental cities. I mean, the citizens of India. The fundamental rights are given to the citizens of India. Now, the question before the court was, people, let us imagine if at all any fundamental rights are affecting certain shareholders of the company. Now, can they file a case with the court saying that our fundamental rights as shareholders are affected? In this case, it was decided, remember, a company cannot be considered as a citizen of the country. A company does not have citizenship. However, because of anything, if the shareholders are getting affected, they can always fight a case saying that their fundamental rights are affected. In this very well case, what happened? There was I'll tell you on the face of it, there was bank nationalization that was happening. So the center was taking over all the banks. So that time all these privately held banks were there. So during 1980s and all, what happened? Due to lot of frauds and all that was happening, the center decided to take control over all the banks. So what did they started doing? They started acquiring all the shares. So let us imagine there was a company called Company A. There was a company called as Company B. I would need some more time. Okay. No issues. Sure. So let us imagine there was a Company A. There was another person called as Company B. Now Company A had certain shareholders. Company B also had certain shareholders. Now what happened? the center started acquiring company A, company B. Like this, there were many other companies that the center started acquiring. But the price paid for them was different. The price paid for them was different. The price paid for the company C shareholders was different. So there was one shareholder who went and said, how can you pay a different price when we never wanted to sell our shares? Whatever you're paying to him, the same should be paid to me as well. It's not the right to equality. You have to treat all of us equal. That is what this shareholder said. Now, what did the center reply? The center replied is right to equality and all is applicable only for a citizen. It's not for a company. This and all will not come under the company at all. So the matter went to court. In this case, it was decided that I'll not say whether they win, they lose. I'll not say about that. But whether can the case be even accepted by the court? Because it is coming under fundamental rights. The court in this case declared that people, whenever anything is affecting the interest of a shareholder, something is happening to the company, correct? That is, the center is acquiring the companies. That is true. Whenever something is affecting the, the interest of the shareholder as a citizen, then people, he can always come under the breach of fundamental rights. He has a right to come and file a case as a citizen. So remember, the company cannot be treated as a citizen, but if the shareholders' rights are affected, you can always go under this particular thing. Next one is company as nationality and residence, that we all of us know. In your situation clause, your registered office clause, you do have this right. It always communicates to which state does that particular company belong to. It will always tell you the jurisdiction. Tomorrow, if someone wants to file a case on the company, now which state will be the main jurisdiction for us to fight the legal battles. Second one, now whenever you will be filing your forms, to which ROC do you belong to? The registered office, where? Now, whenever you want to conduct your meetings, it also decides where your registered office is. All of this is communicated in that situation clause of the MOA. So, a company has a domicile or registered office clause. Next one, sir, the company's liability is limited. But people, this can be a possible question. In certain cases, the company's liability can become unlimited. When is that? The first one, people, when the number of members are reduced to the minimum number required, that is in public can be 7, in private can be 2. If it reduces below that, and whosoever are the members who are continuing the business, cognizance of the fact, that means you are aware that the minimum number is less than what is prescribed under the law, and you are still continuing the business, you have 6 months time to bring back the number to the minimum level. So in a public company, if it is 7, your number has come down to 5, you have to increase it to 7 within 6 months. If you do not increase it to 7 within 6 months, people, then whosoever are the members who are aware of the fact that you are continuing the company with less than the minimum number, in our case, say 5, they will be unlimitedly liable for all the contracts entered by the company after the 6 months. So for the 6 months, you are limitedly liable, but after 6 months, you will become unlimitedly liable. That's the case 1. Second scenario, when, sir, in the case of unlimited company, when you choose yourself to be an unlimited company, your liabilities will become unlimited. The third one, when the company itself was incorporated by furnishing people the incorrect details. So if you have tried to hide any facts, people, if at all anyone files an application with the tribunal, and if the tribunal is convinced, the tribunal can make all your liabilities as unlimited. Next one, if at all you have carried on the business for any fraudulent purpose, the liabilities can become unlimited. Next one, sir, this you will be seeing it in the share capital chapter. Whenever you have issued prospectus, you guys will be seeing civil liability and criminal liability. If you remember, that is also one of the case where unlimited liability will come. Whenever a prospectus is issued with an intention to defraud any person, if at all you have done any wrong there, sir, there is always a civil liability. Remember, every director, promoter, any authorized person or any person who has signed it as an expert, all these people may be personally unlimitedly liable for issuing a prospectus with an intention to defraud the applicants. Unlimited liability will attract. Okay, next one, sir. The company fails to repay the deposit. This is what you would have seen in section 74. What is that, sir? You have taken the deposits, you do not repay it within the timelines scheduled, then people, whoever are the concerned officers, those officers will be personally liable. And the last one, sir, this is, we had it in the previous thing. In recent amendment, you guys know that the inspection inquiry chapter has been removed. So there you had this. Whenever any inspector conducts any investigation, inspection, and if it is proven that you have done a fraud, if you remember your inspection chapter which was there, so if it is proven that you have done a fraud, then whatever is the illegal gains you have made, people, we will pass a order, and the entire illegal money that you have made, we will take away all that money you have made by passing an order. That order is called as a disgorgement order. That means all the profits that you have made illegally will be taken back by the court. And this money will be transferred to IEPF, if you remember. Yes, remember and go these 7 instances when the liability of the members or directors or the people concerned, when can it become unlimited? Okay, next one, sir, perpetual succession. A company can go on forever. Transferability of shares. In a public company, the shares are freely transferable. You cannot restrict it. But in a private company, restrictions are allowed. You have to first ask for the existing shareholders. If they deny the fact, then people, you can go for a outsider. You can transfer it to an outsider. Next one, you cannot go beyond your MOA. Ultra vires transaction will come. Separate management. Company is always owned by shareholders, managed by directors. It's a voluntary association for profit. Exception is Section 8 company. Termination of existence. You can either terminate due to insolvency, or it can even be voluntary winding up, as the case may be. Agreed. And the next part here is definitions. We'll look at it in the chapter 2 because we have anyways different types of company. We'll take it up there. So we'll take up the MCA 21 part. Okay, so MCA 21, what do we have in this for us? That is important. This types of companies, will do it in the next unit only. Okay, MCA 21. Okay, agencies under MCA 21, important from exam point of view, know and go. Who and all comes under MCA 21? The first person is people, ROC. What is the role of ROC? People, register of companies as defined in company law. Now, whenever you guys are filing any e-forms, whenever you guys are, so for example, any records to be maintained, if at all you are not carrying on the business properly, any inspections to be done, any investigations to be done, the first authority, people, that is concerned to take care of the company is ROC. Sir, what is a guarantee that an ROC is conducting their business properly? A person is situated above ROC also to supervise the activities done by ROC people, and that person is called as people RD. What does they do? They supervise the working of the offices of the registrar of companies and official liquidators. And not only that, people, remember a lot of power of central government. Now in various cases you will be seeing that while it can be for shifting of registered office, it can be for conversion of one company to another company. In all these cases, for example, a duplication of name, in all these cases we will be filing an application to central government. Central government is so busy, central government has delegated all this to people RD. So even that work will also be taken care by RD only. Yes. See, certain powers of central government under the Act have been delegated to regional directors. They have also been declared as heads of the department. So that's one of the thing that comes under MCA. Next one is people, official liquidators. I need not even tell you, whenever a company is being wound up, a person will be appointed by the courts as an official liquidator. What do? They sell all your assets, they realize it, and they repay all the debts that the company has to pay to the outsiders. Next one is SFIO. Unfortunately, this went back. It has been removed in our syllabus. What is SFIO? SFIO stands for Serious Fraud Investigation Office. Remember, in India, whenever there is any financial fraud that takes place, there are various ways to deal about it. In certain cases, ROC deals with it. In certain cases, the governments deal with it. There are different ways we deal with it. But whenever the frauds become very serious in nature, only those frauds will be referred to this department called as SFIO. For example, if I have to tell you, SFIO had been given the duty to take care of Satyam scam, Kingfisher scam, all these things had come under SFIO. So the big names came under SFIO only. Once SFIO takes up a case, any other institute or department cannot touch the case. It can even be CBI. It has to transfer everything to SFIO. That's the beauty of SFIO. As the name suggests, Serious Fraud Investigation Office. Next one is NAFRA. NAFRA is here to recommend accounting, auditing standards, to oversee the performance of the professionals. Especially we are speaking about the chartered accountants. Correct? Huh? Next one is people NCLT or NCLAT. These are the two tribunals that are set up under company law to take care of company related matters as a judiciary system. So if I have any problem, I'll have to go and file a dispute on a company. I'll not go to High Court. I will rather go to tribunal, that is called NCLT. Now, whenever NCLT passes a decision, if you are not happy with the decision, you think still there is an injustice to you, you can always go for a appeal. That is, you can go for a DRS. Sir, on-field umpire is not okay. He's not seen the main thing. Can the third umpire look at this particular wicket in detail? In the same way, NCLAT comes into picture. What does NCLAT do? It's a National Company Law Appellate Tribunal. All the appeals from NCLT goes to NCLAT. Important exam point of view, agencies under MCA. Okay. Next one, sir. Important aspects of MCA 21. We have technically 4 aspects. That is front office. What is front office, people? Front office is nothing but whenever you open MCA 21, whatever you guys can see, that is called as MCA front office. Next one is called as virtual front office. What do you mean by virtual front office? Now, there is one thing, today's date, there is no difference between front office and virtual front office, of course. But there is that slightest thing. What is that? I'll tell you here. What is that? Virtual front office is one of the various channels available to stakeholders to enable them to do the statutory filing with ROC offices across the country. It merely represents a computer facility for filing of digitally signed e-forms by accessing the MCA portal through internet. It also presupposes availability of rated facilities to convert document into PDF, scanning of documents wherever required. Now, what is this, sir? Now, in short, it is nothing but people. Now, say for example, whenever we converted first we used to follow everything in a physical format. So we used to go and submit everything, your financial statements, incorporation documents, all of this we used to go and submit it physically. Now with time, what happened? Of course, everything got digitalized. So when they say virtual front office was, earlier what used to happen, there was a reference. That is, whatever we can go and do personally with ROC, we used to call it as a physical front office. Whenever this digitalization happened, when we started converting everything to the systems, that is your digital mode, they started calling it as virtual front office. As I said, today's date, there is no difference between front office and virtual front office. They both are same. Okay. Next one is called as registrar's front office. Now, what do you mean by registrar's front office? Is nothing but people, when the conversion happened, earlier we used to form, you imagine in the year 2000, 2005, 2010 and all, we used to follow everything in physical format until in 2008. People, if it is an annual filing season in Bangalore, there used to be queue for kilometers because you had to go and personally submit the records. So if it's the last day, there used to be a queue for a kilometer. Now, you imagine the mindset of a person who is 55, 60, 70-year-old CS or a CA. If you have to go and submit these documents, now from today we are telling people you should not come physically, you have to submit everything digitally. Can a 70-year-old person adapt himself to a computer? Was it so easy? To facilitate that change, what did they do? In the ROC officers, they nominated a certain people who could help you file the documents. It's like you go to a airport today, there is a self check-in counter, but you are not able to do it. There will be a person from that particular airlines who will be helping you to fill that form or fill that check-in details. Technically, you can do it yourself, correct? But not everyone can handle. So whenever there is a transition, people, there is always a person who is giving you that helping hand, and they were called as registrar's front office. As I've always said also, there was a person, now I don't know if that person is still there. There was a person called as Vivek in Bangalore's registrar's office. He was appointed by Infosys. If anyone had any problem with regards to any tech issues, sir, I'm filing the form, I'm not knowing why it is not getting accepted, he used to help it from the back end. Yeah. Okay, next one is called as back office. What is back office? Whenever you file the form, you're filing incorporation forms, annual filings, strike off, as the case may be, you're filing everything with the registrar. But do you think everything is handled by the registrar only? There is only one person. Now, for example, when you take admissions with Arivupro, what does happen in back office? Now, they coordinate with different teachers. In the same way, incorporation goes to a different person. Mergers goes to a different person. Now, that is only called as back office. So, behind your system, it gets, generally in the industry, we call it as case workers. So, the mergers goes to a different department like that. Understood? Yes, sir. Next one is called as certified filing center. Today's date is not important, but when the transition happened, I told you, we had something called as registrar's front office. In the government office only, there used to be one person who used to help. But you tell me, is it sufficient? Now, he used to work free of cost for us. But is it sufficient? All of them, he'll be overburdened. So, what did our institutes do? That is ICSI, ICAI and your CMA, all three institutes, they set up something called as certified filing centers. So whoever could not manage the transition, you could come to these officers, they used to help. Of course, this was for money. Over a period of time, now this has been waived off. Of course, now today you do it like a client. But back then, the institutes used to have that. That is only called as certified filing centers. Clear? Okay. Benefits of MCA 21, sir. Elimination of interface with the offices of ROC. So today you can do everything electronically. Effective use of database. There are so many forms you are filing, right? What is ROC doing? What is MCA doing with all that data? They are collecting that data and they are further creating various database with that. Example, people, website for investor and protection fund, IPF. Today you want to claim your shares back, dividends back, everything can be done. Next one, awareness to investors. Look at the website itself. Watch out, investors. These people are frauds. These directors have done this. Vijay Mallya has not paid the money. It is for your public notice. Someone who has done a violation, non-compliance, they will publish their details in this particular website. Next one is CSR portal. How much each company is spending? Where are they spending? You can monitor everything. This is from where have you taken? The companies are filing with MCA. MCA has created further websites using that. Next one, security clearance online portal. What is that? I would have told you also. Whenever you guys are coming from any country who is sharing land border with India, who is sharing land border with India. We do not want them to directly come into our country. Example, it can be China or it can be Pakistan. If you are coming from such places, then we do not want you to come and control the companies here. So if you are coming from a country, if you are sharing a land border with us, you need to come under this particular route. Now you need to apply here. You guys will get a clearance. That is only called as people. E-Sahaj, mcaservices.nic.in. From this, you guys have to, it's called as E-Sahaj services, E-Sahaj Seva. So you guys have to take an approval, NOC here. If you guys get an NOC, you will be allowed to invest in Indian companies. If not, you cannot invest at all. You cannot be a director at all. So to get that approval, this is what is the place where you guys have to apply. Okay, next one, better supervision and monitoring of compliances. We are able to monitor it pretty well. Mutually beneficial system. It is beneficial for government, us. Speed, transparent, efficiency, everything is done within days. The number of days taken for incorporation has predominantly reduced now. Effective due diligence, that is, we are checking the forms and documents thoroughly today when compared to physical form. Efficient services by professionals, we are also able to do a very good job. It is environment friendly because papers are being less utilized. Next one, under MCA services, what and all we can do, sir? You can always get your DSCs, apply for DIN, you can apply for DIN, and what else? You can check the master data. If you guys remember in our class, we would have opened this 100 times. You can check any details about any company. All of that will be available under master data, index of charges, all the details of the different charges filed by different companies. The MCA maintains everything under something called as index of charges. Same website even for LLP as well. E-filing, all the documents digitally filed, it will go under e-filing. Company services, LLP services, both come under MCA only. If you have any complaints, you can file that complaint also on MCA website itself. Document related services, what is this? This is what you guys would have studied as Doctrine of Constructive Notice. What is Doctrine of Constructive Notice? Today, every company is a public document. Any document of a company, most of the documents is a public document. So whatever are the documents filed with ROC, we maintain it, right? You can download them. That is what is called document related services. You can download by paying some nominal fees. Okay. Fees and payment services, you can know what is the fees for different services. Public search, I told you, today if you want to apply for a trademark, whether the trademark is available or not, how would you know? You can do a public search. If there's someone has already applied it, you cannot apply the trademark. All those features are also available on MCA. Next one, investor services, your IPF. Next one is track the status. I have applied for incorporation. I don't know what is the status. I can track that as well. Next one, sir, MCA 21. Remember, we used to follow 2.0. Today we are going to 3.0. We have almost 99.9% migrated. Now, what are the benefits of MCA 3.0? The first one is people. E-scrutiny. What is E-scrutiny, sir? Nothing but people. Sir, there is something called as STP forms. MCA in the process setting up which will scrutinize certain STP forms. What is this, sir? Now, people, there are two types of forms. The first type of forms, ROC will, now you are filing your, let us imagine if you are filing incorporation documents. You are filing SPICE Plus. ROC will check all the details you have filed, only then he will take it on record. Now, these are checked. There are other forms on the other hand. Let us take for example PAS3. Now why do we use PAS3 for? What is the reference? PAS3. Allotment. Correct? Prospectus and allotment of securities. Whenever you are allotting shares, you will find form PAS3. PAS3 is a STP form. What do I mean by STP? It will not be checked by ROC at all. It won't be checked. ROC will directly take it on record. Now you tell if it is not checked, will you guys file genuine details? No. then don't you think how is government allowing it? Because ROC is not checking it, but someone else is checking these forms, and someone is telling, sir, I have seen, you don't worry. Now who is this person? This can be a CS, this can be a CA, this can be a CMA. Now they are telling we have checked, so it's okay, sir. Now because they are telling we have checked, ROC will not check it directly, will take it on record. But don't you think people, even we can do fraud? So ROC cannot say that if you check, I will never check. So people, for that we have a cell that is only called as E-scrutiny. What do? Even though PAS3 forms like this is STP, I will pull up once in a while. I will do like a random audit. If you get caught, that data macha, you are liable under a section called 447 and 448, false certification. You can be imprisoned. Remember, sir, this process where we are certifying the form and ROC is blindly taking it, this is only called as pre-certification. Important exam point of view. To reduce the burden of ROC, there is a process that is introduced that is only called as pre-certifications. Hello? I hope this is clear. So this is the advantage in MCA 3.0. Next one is E-adjudication. What is E-adjudication, people? Today's date, whatever hearings, people, you have a dispute, you are fighting with ROC, RD, even tribunal. Today, nothing is physical. You can do it electronically. All the hearings today is E. That is the meaning of E-adjudication. So we are helping you save time, energy, resources, everything. Next one is E-consultation. What does E-consultation mean? Sir, we are proposing certain amendments. Small company, we are proposing to make 4 to 40. We want to make 4 to 10, 40 to 100. We want to propose this. First, people, we will ask our members, is it okay? Now that is only called as E-consultations. You can give your comments, you can give your suggestions, you can give your changes, anything that will be taken up by the MCA version 3, E-consultation. Next one is compliance management system. What is compliance management system? Simple, people. Now today's date, I will wait for certain time. My financial statement should be filed within 30 days of your AGM. So I did not get it. Automatically the system itself will throw a notice to the company. You have failed to file annual statements, your annual returns, financial statements. Why? So that system which automatically triggers notices is called as, people, CMS. Next one is called MCA Labs. What is MCA Labs? It's nothing but one system where it checks whether all the other systems are working carefully, properly or not. That system is called as MCA Lab. It consists of, people, corporate law experts. Now they will check whether MCA 21, that is the MCA entire system, is functioning properly or not. Remember and go, exam point of view may be important. Okay, E-forms we have seen. As we go by in the next chapters, I'll be telling you more also. Today's date, any communication is directly using E-forms. There is no physical forms. What are the prerequisites for using MCA 21? I don't know whether we have to tell this also. You need a computer, OS, latest browser, Adobe, because everything is PDF, scanners and Java runtime. Okay. I already told you what is necessity for pre-certification. Pre-certification is done by an independent professional. Why? To reduce the workload of ROC. So once we check it, the documents online without the approval of ROC, it is just taken on record. If you do any fraud, you will be liable under the punishment section 447, 448. Clear? Huh? Okay, that's your first chapter. Yes, people. So let us start with the second chapter. The legal status and types of registered companies. Again, a easy breezy chapter. Let's not take much time in finishing this. Okay. So yesterday we were seeing the characteristics of a company. In that we had seen a lot of characteristics. In that the predominant one was, people, your corporate personality. That is your corporate wheel. That is separate legal entity concept. in general, what is the scenario, people? A company is always different from its shareholders. So there is always a cloth in between the company and its shareholders. That's the general scenario, right? But whenever there is any such scenarios where if at all the shareholders are doing something fraudulent, or if the shareholders are doing something not right, in such cases, the judiciary has a right to lift the corporate veil, that is like a mask that the shareholders are hiding behind the company form of business. They can remove the mask and they can see who exactly is hiding behind this curtain called as company. So, sir, this concept only is called as what, people? Lifting of corporate veil. Whenever a company is used for any unlawful purpose, then the lawmakers, that is, at the judiciary, will lift the company and see who exactly are doing these activities in the name of the company. So now, sir, when does the judiciary has the right to lift the corporate veil? When will they do it? They will do it in these scenarios, people. What is that? The first scenario is where the corporate veil has been used for commission of fraud or improper conduct. Corporate veil means that separate legal entity concept. So you are using a company to do some fraudulent purpose, fraudulent act. If you have done that, sir, so to know what is the truth, we have a right to lift the corporate veil. Now, in this case, what happened, people? There is one a simple case. I'll tell it to you in a very simple language. A had agreed to sell his land to B. They had entered into a contract. All of that was done. But meanwhile, people, because of some reasons, A did not want to sell his land to B after a certain point of time. But he has entered into an agreement that I will sell my land to you. So to escape this liability, what did A do? A formed a dummy company, a duplicate company which has no other activity, and he transferred all the land, documents. He went to the registrar office, got the documents also registered in the name of the company. So when B came asking for the land, A replied, I'm so sorry, the contract is already done. That particular land is no longer in my name. Hence, I will not be able to give you the land. Now, B wanted to file a case on A saying that you have done all of this just to escape my liability. B actually filed a case as well. He is using the company form of business just to hide a obligation from me. So, it's just an improper conduct. It's a fraudulent thing that he has done. The court also lifted the corporate veil and said this company and this shareholder, they are one and the same. He's just using that corporate mask to do this fraud. And it was held that people, A has to give this land to B. Yes, that is this case law, Jones versus Lipman. Okay, next one. Where a corporate facade is again a mask, is only an agency in instrumentality. What are these people? A very famous case law called Merchandise Transport Limited versus British Transport Commission. Again, in short, I'll tell you, there was a company called A. Company A was into some logistic business. So they had a lot of heavy motor vehicles like trucks and all of that. So they wanted some license to do the business. So what did they do? They applied for the license with we have RTO office, right? Like that in the UK, they had something called as British Transport Commission. So this company A applied for a license from British Transport Commission, saying that this is our business, we want license for so many vehicles. The British Transport Commission felt there is something unusual and they rejected the license. What did company A do? Company A knew if I again apply for the license in the same name, they have noted me. They know that this is me. They will definitely reject my application. So what did they do? They opened another company called as Company B as a subsidiary. Now what was the whole purpose? Now because I could not directly apply, they used a corporate mask, another company's name, to apply the same license again. Now, British Transport Commission saw this. They said, sir, in reality, there is no difference between the company A and company B. They both are one and the same. They are just using the corporate facade, meaning mask, as an agent. They want to do something indirectly which they cannot do directly. Sir, this also the license was rejected. That is this case law. Merchandise Transport Limited versus British Transport Commission. Done. Next one, where the conduct conflicts with public policy. Public policy means what, people? If at all you are using the corporate wheel to, somewhere public policy means what? Something not in the best interest of the public. You are doing something immoral activities, unlawful activities. It will be considered as void. Next one, in Daimler Company, what is this, sir? Basically to find out if you are dealing with a alien enemy. In this case, what happened, people? There was a company A. The company A was selling tires to another company called as company B. They both had almost a 5-year contract. That company A will sell the tires to company B. All of a sudden, people, after 2 years, the company B said, we don't want your tires anymore. After 2 years, they want to cancel this particular contract. Company A said, nothing doing. We have a contract. You have to buy with us for the next 5 years. Company B said, no boss, so sorry. We do not want to go ahead with your contract. Now, what did company A do? Company A filed a case on company B for breaching the contract. Now, company B said in the court, Your Honor, you know why we are not buying the tires from company A? Why? Because they are our enemies. They are our alien enemies. What do I mean by alien enemies? Alien enemies means those people with whom our country has a war. Company A said, sir, how can we be their alien enemies? We are also situated in UK. They are also situated in UK. We both are from the same country. With our country, how can we have a war within us? So they are saying something and all. Company B proved, people, no sir, you are wrong. Who are the shareholders in company A? The shareholders in company A were people, German citizens. All the Germany people were the shareholders in company A. When all this entire case was going on, it was during the time of World War. So UK and Germany had declared each other as alien enemies. But people, company A said, sir, we are different from our shareholders. We belong to UK. We are not belonging to German. So it's okay. Shareholders is in German, but we are in UK only. But people, company B said, sir, let us imagine we do this contract with company A. That means what? We give them good money. When good money is given, what happens? The sales goes up. Their profits goes up. That means what, sir? They will declare a dividend. The dividend is declared to the German citizens. Sir, their income goes up. Sir, then that means, sir, indirectly, we are only giving this dividend to this particular citizens. No, sir. Technically, that means we are breaching the alien enemy contract. Now, the judge also said, yes, that makes sense. This both companies were declared as alien enemies. Yeah? Because what they proved is right only. That is this case law. Daimler Company versus Continental Tires and Rubber Company. Yes. Next one, when the company is formed to evade taxes, again corporate wheel can be lifted. What do you mean by evade taxes? There was a person called as Mr. Dinshaw. What did he do? This fellow, he had, let us imagine, say 1 crore rupees. With that 1 crore, he formed three dummy companies, shell companies. They do no other activity. Then what do? He gave everyone some money, say 30 lakh, 40 lakh and 30 lakh. With that money, they further invested into other companies. I'm just giving an example. Say ITC, Infosys, Tata Steel, they invested into further companies. Now they are all doing good. They started giving returns. In the form of dividends, in the form of interest, they all started giving returns. Now, sir, for company A, it's a profit because you are earning money. Now, what did this fellow do? He took all this profit back to his pocket in the form of loan. He took it as loan. Now, because of that, what happened? He took it as a loan. He never repaid this loan to this company. Because of that, what happened, people? In the company's books, this eventually became bad debts because it was never repaid. And this fellow started taking everything as a loan. You tell me, will anyone pay tax on loans? Is loan taxable? Answer is no. Now, because of that, people, what did he do? He framed a plan in such a way that not even 1 rupee was getting taxed. Of course, people, in this case, the Commissioner of Income Tax got to know that one person was doing this. So they lifted the corporate wheel. It was it was held that people, company A, company B, company C are one and the same. He and him, that is, he and the companies are one and the same. Whatever profits were made by these companies, this fellow had to pay tax on it. That's the case law, people. Dinsha Manekji Petit. That's the case law. Re means people in the case of. So, in the case of Dinsha Manekji Petit, the complete case law is called as Dinsha Manekji Petit versus Commissioner of Income Tax. That's the complete case law. Yeah. Okay, what else? Next one, sir. Avoidance of welfare legislation is as common as avoidance of taxation, and the approach in considering the problem. What do you mean by that, sir? Imagine, people, if at all there is some other law in the country, if at all through this corporate wheel, if you're trying to break that law, even then also they can lift the corporate wheel. That's the case law of this. Yeah. There was a case law in our syllabus. It's not there. That's why I'm not taking it. Yeah. Okay. Next one. Last one, sir. Unjust and inequitable purpose. Unjust and inequitable purpose, people, I can just tell it's nothing but etc. I cannot write down every point. No. So the law says if there is any other purpose also, they can lift a corporate wheel. Understood? Yes, sir. Simple. Okay, done. That was lifting of corporate companies wheel. Okay. Okay, next one, sir. Let us do the types of companies. The types of companies, people. The first one is the basis of liability. Classes of company. On the basis of liability, the first type of company can be called as, people, company limited by shares. What do I mean by company and limited by shares? If at all a shareholder has purchased, say, 1000 shares, I am liable until I pay 1000 shares, and whatever is the face value. Imagine if the face value is 10 rupees, my liability will continue until I repay the entire 10 rupees. So 1000 into 10, until I pay my 10,000 rupees, my liability will be there. If my liability is completely repaid, my liability will come to an end. So once I repay 10,000, my liability comes to an end. Such type of companies are called as company limited by share. The next type of companies is called as company limited by guarantee. What do I mean by company limited by guarantee? Company limited by guarantee means, people, we start a company. In this, there will be, say, 3 members. Now, what does these 3 members do? These 3 members will give a guarantee to this company. What? You start to do your business. You enter into contract with outsiders. You start doing your business. Imagine one day when you are not able to pay your debt. You don't worry, the company, we will repay. This fellow says, I will give you a surety of 30,000. If you are not able to pay, I will pay 30,000. This fellow comes and says, I will pay 40,000. This fellow comes and says, I will pay another, say, 30,000. Now, people, the company will start functioning until the last day it will function. Now, imagine when the company decides to shut down. Now, when there is any liabilities we need to repay, first we will use the company reserves, its savings, whatever is there. We will use that money to repay the liabilities. Sir, what if that money is not sufficient? That day, on the day of winding up, if the money with the company is not sufficient, that day these members will come and contribute this money to the outsiders. Such type of company is called as company limited by guarantee. Is this clear, all of you? Yes. Okay. Company limited by guarantee. So the members agreed to contribute at the time of winding up, not on the day one. Here you will bring in the money on the day one. Here you will bring it on the last day. That's the difference. Okay, last one, sir. Unlimited company. What do I mean by unlimited company? A company in which the liability of the members is unlimited. Yes, hello. But remember, if at all a company goes for winding up, if any creditor has to receive money, he cannot directly go and file a case on the shareholder. He needs to file a case on the company only. Company will recover it from the shareholders and that will be given back to the creditors. The creditors cannot directly file a case on the members. Remember, creditors cannot directly sue the members. Okay. Next one, on the basis of control, a company can be classified into holding company, subsidiary company, okay, and associate company. What is a subsidiary company? A company in which a holding company controls composition of board of directors. What do I mean by that? Let us imagine there is a company called as company A. There is a company called as company B. In this company, there are 5 directors. In the 5 directors, the company A is controlling the composition of majority of the board in the other company. That means what, sir? Out of 5 directors, the 3 directors are appointed by company A. They remove them, they reappoint them. End of the day, the entire control over the 3 directors are with company A. In such case, we call this company as a holding company, this company as a subsidiary company. This is clear? Simple? Yes. Okay. Next one, controls more than one half of total voting power. What do I mean by half? 50. More than one half. Remember, 50.1 is also more than one half. Example, sir, when there is company A, there is company B. When company A holds in company B 50.1 share, not even 51, even if they are holding 50.1 share, this becomes a holding company, this becomes a subsidiary company. Sir, or imagine there is a company called company A, there is a company called company B. In company B, company A holds 51%. There is another company called as company C. In company C, company B holds 30%. In company C, company A holds 25%. Now we call company C as a subsidiary of company A because you need to add this 30 plus 25. That's the meaning of together with its subsidiary companies. Example number 2, example number 3. If you guys want, make a note somewhere. These are all the examples. Yeah. The third ones are deemed subsidiary company. That means what? So there is a company called company A, there is company B, there is company C. It's nothing but people like a chain. If this is holding 51%, if this is holding 51%, then people, we call this as a holding company, this as a subsidiary company. Correct? Huh? And this is also a holding company, this is also a subsidiary company. Correct? But remember, ultimately, this is a deemed holding company and this is a deemed subsidiary company of company A. Because ultimately I control B, B control C. That means A is only controlling C. Yes or no? Hello. I hope this is making sense. Abba, Yenada market. Market is doing wonders. Okay. Third one, associate company. A company in which other company has significant. What do you mean by associate company, people? Associate company means, people, nothing but a company in which other company has a significant influence. What do I mean by significant influencer? People, see here, this is very important. Till date, they have not questioned this, but someday they can definitely question this. What do you mean by that? Now, I'll show you one thing. MGT 7 of Tata Motors, we'll just see. generally students will get confused in one part. What do you mean by associate company, people? What do you mean by associate company? Whenever one company holds at least 20% in other company, no, significant influence, yes or no? But I'll show you one thing, see. These are the list of subsidiary companies of Tata Motors. Yeah, Jaguar, all of that is there. Correct? And you can also see associate companies are also there. Can you see? Associate companies, 26, 49.77, it's an associate company. Up to 50 are an associate company. 50 is also associate. 50.1 you become a subsidiary company. 39 associate only. Yes sir, 20% means associate only. I'll tell you, there is one exception. What is this? Tata Motors is holding 50% in this company called as ARCV Limited. But this is a associate company. How come? What is our definition? Definition says what? Definition says 20%. But how come this can become a associate company da? Macha, remember, what is the definition of associate company? Section 2 clause 6. A company in which other company has a significant influence but not a subsidiary company. Now what do I mean by significant influence? Significant influence means control of at least 20% the total voting power, or that's not the only way to become a associate company. Control of or participation in business decision under an agreement. That means if I have any control over the company in business decisions, it might not be significant, but I have some control, I will still be considered as what, people? I will be considered as associate company only. So 15%, yes, that might be a significant decision making in a company. Hello? Now I cannot tell you what is that significant. It can even be 13%. It can be any number. If you take SBO, it says 10%. Hello? Are you getting the point? All that you need to see is whether I have a right to control you in your decision making or not. Hello? Clear? Okay. So why did I tell you this is because remember, that's not the only way to become an associate company. Not only 20%. There are other ways. That's why I emphasize that point. Okay. Next one is joint venture is also considered as a associate company only. Okay. Next one, sir. On the basis of number of one more thing. Yes, a subsidiary company of a government company is a deemed government company. A subsidiary company of a public company is a deemed public company. On the basis of number of members, a company can be classified into public company, basically a company which is not a private company. What do you mean by private company? Section 2 clause 68 says a company which by its articles of association, it should definitely have these 3 points. What is that? First one is it restricts the transferability of shares. You cannot freely transfer your shares. That means what, people? You need to first ask your existing shareholders. People, I want to sell my shares. Are you interested in buying? If they say no, then you can sell it to an outsider. Directly you cannot give it to an outsider. This restriction cannot exist in a public company. Remember that. Okay, next one. Limits the number of members to 200. A company which limits its number of members to 200. So in a private company, you cannot have more than 200 members. Remember, the word members here includes equity and preference. Can I have 500 debenture holders? Is it possible? Think possible. Yes, people, 500 debenture holders is possible. There is no doubt, because the limit is on members, not the debenture holders. Debenture holders are not the members of the company. Hello. Sir, in this 200, remember, the joint holders are treated as one. That means if 3 people together are opening one DMAT account, you count them as one only, not as 3. Next one, sir, if there are any past and present employees to whom you have given shares, then please don't count them in the limit of 200. Yes, hello. Okay, third one, people, prohibits. That means a private company can never go for a IPO. So the next ones are based on number of members. The next type of company is called as OPC, one person company. What do you mean by a one person company? A one person company means a company which is established by a natural person a citizen of India, whether a resident in India or otherwise. What do I mean by resident in India or otherwise, people? Basically, there can be two types of Indian citizens. One, like you and me. Birth year, death year will be here only. The next type of people who go abroad for work, they work there for 3 years, 4 years and then they come back. We generally give them a tag as NRI. You are earning outside India. After probably 3-4 years, you may come back to India. Correct? So until 2022, such NRIs could not start OPCs in India. You could neither become a member, nor could you become a nominee. Now people, it is relaxed. What is that? If you are a resident like you and me, who is not traveling abroad for any employment or anything, then people, for us, there is a condition. What is that condition? You should have stayed in India in the previous year for at least a period of 120 days. In the previous financial year, if you have stayed, you will become a resident. So if I have to start a OPC, now technically I am a resident. Because in the previous year, people, I have stayed in India for 120 days. I have been in India. I did not go anywhere. Now people, I will be considered as resident. Now I can start a OPC. Now let us imagine, sir, I have one of my cousin who is in US for the last 2 years. He's been working there only. Now, can I make him as my nominee? Now my question is he a resident or a non-resident? He is tagged as a non-resident because he has gone abroad for some employment. We tag him as a non-resident. Sir, how can we know whether he is a resident or a non-resident? If at all a person is going for some temporary short-term purpose, people, you will still call him as a resident only. For example, I go for a foreign trip and come. For this 10-15 days, I do not become a non-resident. I am still a resident only. But when a person is going for employment, studies or things like that, you are going for some uncertain period, you will be called as a non-resident. If you are a non-resident, people, then I need not check this 120 days condition. That's what is the meaning. If you are a resident, I have to check 120 days condition. If you are a non-resident, I need not have to check 120 days condition. Clear? Yes, sir. Most the people will find that part difficult. Remember and go. Okay, next one. Nominee. Of course, the same condition. A person has to be a natural person, Indian citizen and resident or otherwise. Only they can be a nominee. Remember, you cannot be a member in more than one OPC. At the same time, you cannot also be a more than nominee in more than one OPC. But the same person can become a member of one OPC and a nominee of another OPC as well, provided wherever I am a nominee, if that member dies, next I become a member, then people, I need to choose between two OPCs in which OPC I need to continue within 180 days. Clear? Okay, next one. Remember, a OPC can never be converted into a Section 8 company. Not possible. Neither can Section 8 company be converted into OPC. Next one is, people, minimum number of members in OPC is 1. Maximum is 1 only. Minimum number of directors in OPC is 1. Maximum is 1 Allah, 15. They can have up to 15 directors. Remember that. Sir, OPC cannot carry on certain activities like they cannot do non-banking financial activities. Not possible. OPC cannot further invest in any other body corporate. They cannot buy any other company ka securities. Prohibited. Remember these conditions. And nominee, I can change the nominee whenever I want. Possible. Nominee cannot be a minor. Whenever there is a change in nominee, it is a duty of the company to intimate it to the ROC that the nominee is changed. So the nominee can resign himself, or I can only change the nominee. There can be a death. So in all these cases, yes, you have a right to change your nominee. You have to intimate the nominee to the ROC. Clear? Okay, done. Next one, other type of company, sir. Government company. What do I mean by government company? Where not less than 51% of the paid up share capital. This is technically paid up share capital, but having voting power. That means equity only. So at least 51% of the paid up share capital is held by central government, state government, central and state or state governments. Remember people, to become a subsidiary company, even if I hold 50.1, I can become a subsidiary. But to become a government company, I need to hold 51% at least, not 50.1. In these 2 points, don't get confused. Lot of people get confused here. When you're writing subsidiary, you need to write more than 1/2 of the total voting power. When you're writing government company, you need to write people 51%, not less than 51%. That's the condition. Okay. Next one, foreign company, a company which is incorporated outside India, which has a place of business in India and also carries on business activity in India, whether in physical or electronic mode, personally or through an agent. Such companies are called as people. What? It is called as foreign companies. Next one is called as a Section 8 company. What is Section 8 company? A company which is formed for the purpose of promotion of charity, education, sports, research and development, as the case may be, education, charities and things like that. And remember, they can earn income, but they have to put it back for the furtherance of their object only. It prohibits payment of dividend. You can never pay. It always functions under a special license given by the central government. This power has been now delegated to ROC only. So ROC will only give you the special license to function as a Section 8 company. If at all you contradict it, if you are not following the rules properly, then the central government can also revoke your license. And what else I can do? I can convert you into a private company or a public company, or I can order you to amalgamate with some other Section 8 company, or I can even tell you wind up your affairs with the company. Anything is possible. So they need not use the words limited or private limited in its name. That's your Section 8 company. What else? Different types of company. Most important things are small company. What is the definition of small company, sir? Sir, recently we saw somewhere the small company has changed paid up capital to 10 crore, turnover to 100 crore. I have told this in the class only. The amendment came in the month of December. I told in the month of what? July or August. People don't wonder if these limits are again further changed. This was expected. Yeah. Sir, but for our exam, what do you mean by a small company? Remember people, this amendment came in the month of December. The December month amendments are not applicable to you. Whatever comes until the November 30th alone applies to you. So this particular amendment does not apply to the people who are writing in the month of June. For those of you who are writing in the month of December, so the small company definition will be a company which is having a paid up capital not exceeding 10 crores, turnover not exceeding 100 crores. For the people who are writing in the month of June, you need to read it as 4 and 40 only. Whatever you have read now, please continue that itself. That is the meaning of what? Small company. A small company means a company other than a public company which is having a paid up capital not exceeding 4 crore, turnover not exceeding 40 crore. What are the companies which can never be considered as small company? One is public company. Next one is subsidiary company, holding company, Section 8 company, statutory company. These 5 companies can never be considered as a small company. What are the 5 companies? One is public company, holding company, subsidiary company, Section 8 company, statutory company. These 5 companies can never be considered as a small company. Section 2 clause 85. Okay. What else? What is the dormant company? A company which is formed for the purpose of okay, anyways, dormant company is there. We'll see when we're doing dormant company. What are the advantages of small company, people? Important. Once you read the complete company law, come and revise this. What are the advantages of small company? The first advantages is while you're filing annual return, who has to sign your MGT7? Remember, it should mandatorily be a CS. Sir, what if I don't have a CS? Then I need to get it certified by a PCS. That's for a normal company. But if you're a small company, if you don't have a CS, then you just get it signed by the director, more than sufficient. So a practicing company secretary signature is not mandatory. Next one, people, board's report. Generally, we prepare a very detailed board's report, just like annual return. That is also one of the thing, right? That can also be mentioned here. For a normal company, you file a detailed annual return called as MGT7. If you're a small company and OPC people, you will file a abridged annual return, like a summary. In the same way, same applies to board's report also. You file something called as a abridged board's report. That means in a summary form. Okay, and board meetings. Normal companies will conduct 4 board meetings in a year. Small company can conduct only 2 board meetings in a year. The gap between 2 board meetings should not be less than 90 days. Cash flow statement. Remember, a private company which is a small company need not prepare cash flow statement as part of its financial statements. Remember, cash flow statements in the financial statements definition, every company has to prepare P&L, balance sheet, statements of changes in equity and cash flow statement as well. But if you are a OPC, if you are a dormant company, if you are a small company, or if you are a private company who is a startup, they need not have to prepare cash flow statement. So a small company need not have to prepare cash flow statement. Reduced penalties, that means whenever there is a penalty for doing any non-compliance, remember, for a regular company the penalty can be a little more, for a small company the penalty can be little less. Okay. Holding company, types of holding company. First one is called as pure holding company. What do I mean by pure holding company? Company A holds, say for example, say 100% in company B. What does company A do? Nothing. The company A has no other job of its own. Company A just holds company B. Company B will function. Such type of holding companies are called as pure holding companies. They don't have any activity of their own. Next one, it's called as mixed holding company. What do you mean by mixed holding company? Mixed holding company means, people, nothing but I can give you an example of, say for example, Walmart holds 82% in Flipkart. Now Flipkart carries on its business. Walmart also carries on its business. Tata Motors is a holding company of Jaguar. They also carry on. Such type of companies are called as mixed holding company. That means I have my activity also, I have your activity also. Next one is, these both are same. Immediate holding company or intermediate holding company. What do you mean by immediate holding or intermediate holding? Both are same only. That means, people, there is a company A, there is a company B, there is a company C. The company B here is called as, people, immediate holding or an intermediate holding. See, the definition applies for both immediate or intermediate. So a company which is a holding company as well as subsidiary company is called as a intermediate or a immediate holding company. Then what are the maximum layers, people, we can have? A can hold in B, B can hold in C, can C hold in D? According to India, the maximum we can have is 2 layers, not beyond that. So you cannot have a company D as your subsidiary company. Remember that. These are all simple things. I hope you guys can manage. See, no company other than a company belonging to a class can have more than 2 layers of subsidiaries. So you cannot have a D. But however, some companies can have subsidiaries more than 2 layers. Who are they, sir? One is banking company. Next one is systemically important NBFC. What do I mean by systemically important NBFC? Systemically important NBFC means, people, nothing but NBFC is a non-banking financial company. Systemically important means people, you are very important for our ecosystem, for our system, for the country. That means you are having a net assets of somewhere around 500 crores. Imagine a company of this size, if they fail, the entire country will shake a little. So we are considering you as an important company. So when compared to a normal NBFC, for them the restrictions will be little more, because we cannot afford for you to fail. Like Manappuram, Muthoot, Bajaj Finance, they are all systemically important. An insurance company being a company, technically an insurance company, they can go beyond 2 layers. Third one, fourth one, government company. So for all these 4 people, the layers are not applicable. Banking company, systemically important NBFC, insurance company, government company. Remember and go, important, may ask from the exam point of view. Associate company we already seen. Dormant, inactive, government company we have seen. What are the exemptions for government company? You can either see it here only, or you can even see it as and when that section comes. Yeah, I would rather suggest, once the entire chapters are done, you can come and read this point. It will make sense. Yeah, because if not, now it will not make any sense if I just keep reading this. Still, I'll just try to tell you some points, but we'll see. Summary of the exemptions given to the government company. What is that? Name. Remember people, whether a government company is a private company or public company, their name will always have the words limited only. They can have the word state. State's name can be used, but they will always have the word limited in their name. Next one, transfer of shares. Remember people, if at all, now let us imagine there is a government company. Let us take example of ONGC. So Tamil Nadu is holding some shares, Karnataka is holding some shares. Tamil Nadu wants to transfer the shares from them to Karnataka. They need not have to file form SH4, not required, exempted. Just intimation is sufficient, all of this is not required. Next one, sir, the declaration of dividends out of the accumulated profits of the previous year. What is this people? When you are declaring profits, dividends out of your free reserves people, then whatever the conditions are not applicable to a government company. Next one, deposit of a dividend in a scheduled bank account within 5 days from the date of declaration. What happens in the case of dividends? Within 5 days, you are going to deposit in a separate bank account, in a scheduled bank account. Within 30 days of declaration, you guys are going to make the payment. They're telling people this 5 days rule is not applicable to a government company. You can keep it in the same bank account. Not so important from exam point of view. Next one, sir. Appointment of, okay, what is the maximum number of directors in any company, people, whether you're a private, public, small company, OPC, the maximum number of directors you can have is people 15 directors. If you're a government, if you're a public company, if I want to have 18 directors, can I have? Yes, provided you need to pass a special resolution. Remember, if you're a government company, this special resolution is not required. You can directly appoint 20 directors, it is sufficient. Absolutely no problem. So next one, sir, place of AGM. Generally for any company, where should I conduct my AGM, people? I have to conduct it in my registered office, wherever my registered office is, or within the same city, town or village, wherever my registered office is. If you are a government company, you can have it anywhere in India as the government decides. That's all. You can have it at the registered office or at some other place as government decides. That's all. Next one, appointment of director. What is this, sir? Whenever we appoint a director, the director will give us something called as DIR2. DIR2 is nothing but consent of the director. I'm okay to be a director in your company. As and when we appoint him, we file a form called as DIR12 with ROC. If you are a government company, both are not required for you. Exempted. Sir, retirement of directors by rotation and filing of vacancy. Directors by rotation. We'll see when we're doing directors chapter. Not applicable. Next one. Right of persons other than retiring directors to stand for directorship. Again, not applicable. Section 160. Register of directors, KMP and shareholders and its inspection. 170 and 171. Not applicable. That is maintenance of register of directors and KMP. And, the shareholders coming and inspecting them. Not applicable. Loan and investment by company. Now what is this? Your guilds provision. Not applicable. With beyond the limits they can go. No special resolution and all required. See, that's what I said. Here I cannot make you more sense when that particular provision comes. When you read the whole provision and then you come and read here, it will make more sense to you. Yeah, a related party transaction. First provision, second provision will not apply in the case of government company. What is first provision? Whenever you are going beyond the limits, you have to take the shareholders' approval. Without that, you cannot do that transaction. Not applicable. Second one, if there is a related party, you are taking the shareholders' approval. Such related party cannot vote. That provision not applicable. So you can disclose and you can still vote. Appointment of managerial person. What is, we will see section 196 when we are doing KMP, we'll do it there only. Provisions relating to auditors. Who will appoint? CAG will appoint. Annual report of a government company. Let us always remember, people, if you are a government company or a government entity, all your financial statements will be audited by CAG. After audit is done, they prepare something called as annual report. Yeah, when will we prepare this annual report? We generally prepare this within 3 months of AGM. And this annual report will be forwarded to central government. The central government will place that annual reports, the audit reports and the financial statement in both the houses of parliament. That is Lok Sabha and Rajya Sabha for the members' approval. That is what is given here. So the government companies, accounts, the reports, it will be audited. There will be an annual report prepared. It will be submitted to central government, which will be again forwarded to Lok Sabha and Rajya Sabha for their adoption. Done. Done, sir. That's your chapter 2. Yes, people, let's start the next chapter, that is chapter 3, MOA and AOA. So for our ease of understanding, I've divided the chapter into 2 parts. One is part 1 about MOA, AOA doctrines, part 2, the alteration part. Okay, so coming to the part 1, that is Memorandum of Association. We all know what does MOA signify. MOA majorly has people 6 clauses. And what are the 6 clauses, people? One is name clause. The name clause always indicates the name of the company, specifically whether it is a private limited, public, OPC, as the case may be. Okay, remember, whenever you are having your name, it should always, you have to keep in mind Rule 8, Rule 8A, Rule 9. You cannot use the words which are similar to the existing companies, LLP, registered trademarks. It should not be undesirable. It should not be prohibited. It should not be similar. It should not be phonetically same. Yeah, all these have to be kept in mind while choosing the name of the company. Next one, people, is situation clause. What does situation clause signify? It just says where, in which state the company is registered. This is very, very important. It does not have the complete address. A lot of students has a misconception that it has complete address. No, it will just have the state where the company is registered. Okay. Third one, it indicates the object clause of the company. What do I mean by object clause? Object clause says what is the purpose of the company. Now, for example, Arivupro can be education. If you take up any banking company, it will be written as a financial sector. So a company cannot go beyond that particular object clause. If at all a company is going, it becomes ultra vires, which we'll be seeing in the doctrines. The fourth one is called as people, the liability clause. What do I mean by liability clause? In this clause, it will clearly say people, whether the company is limited by share, limited by guarantee, unlimited company, you will get to see all of that. Now, for example, if you want to see, you can see any of one companies. Let us take Infosys MOA. You will get a fair idea. See, the first certificate of incorporation of Infosys. This was given in 1981. That time the company was Infosys Consultants Private Limited. Yes, later they changed to Infosys. That is, they became a public company when they were ready to go for IPO. Yeah. So many times they have changed their name. All of this is change of name only. This is the MOA. See, the first clause says the name of the company is. Second one, the register of the company is the state of Karnataka. The object, you will be seeing object clause now. Next one is the fourth one. The liability of the members is limited. I hope you are able to see. The liability of the member is limited. That is the liability clause. The fifth one, people, of course, that is your capital clause, which speaks about the authorized capital of the company. What is the authorized capital of the company? This is the authorized capital of the company. How much? Rupees 2 divided into 480. So it is technically 2,400 crores. That's the authorized capital of the company. That's all, sir. People, they are assuming the shares are 5 rupees each. Market price of Infosys share is somewhere on. Don't take that as market price. That is face value. Market price means the company's the money will go somewhere. Okay, understood? This is your liability clause. This is your capital clause. What is the last clause? What is the last clause? Subscription clause. Remember, this clause will never change with time. What do you mean by subscription clause? When the company was incorporated, who were the initial shareholders who agreed to buy shares in the company? Who were the first set of people? Now, these are the first set of people. You can see them. Who is that, sir? The first person is, who is this person? Nagavara Ramarao Narayana Murthy, popularly called as people, your Narayan Murthy, NRN Murthy. Yes, see, it was a private company, so 4 people have agreed to buy the share. And one more thing, remember, how many shares should we buy? Remember, 1 share is also sufficient. You need not have any minimum paid up capital. Is clear, all of you? And one more thing, people, can a company have only equity shares? Yes, possible. Can a company have only preference shares? There is no equity at all. But can a company have only preference share as its capital? Without equity, is it possible? Think. Remember, that is not possible. It is not allowed under the law. Yeah. So only preference is not allowed. You can have equity. The reason is also simple, right? Now remember, whenever you have equity and preference, what do you mean by the word preference? That means you are giving a priority. When equity itself is not there, then to whom are you giving priority? So there has to be always the other share that has to be existing. So only preference cannot exist. There has to be equity plus preference. Okay, I hope you guys got a fair idea. Okay, now sir, where did that go? Liability clause, capital clause, and subscription clause. That says whoever first shareholders are. Okay, next one is there were some case laws for if there is any similar name people, of course, you will be told to change your name. That's always the case. Okay, the next one is called as people articles of association. What is articles of association? A document which basically defines the internal rules of the company. Basically a document which binds the insiders, the members to the company. MOA binds the outsiders to the company. It's always, remember, there are 3 circles. Section 6 says what? Always there is a first circle. The first circle stands for AOA. Then comes the next circle. The next circle stands for MOA. Then comes the next circle. The next circle stands for the Companies Act. That means, sir, the AOA is always subordinate to MOA and Companies Act. You cannot override it. MOA is always subordinate to Companies Act. This circles always remember. If AOA goes beyond MOA or AOA goes beyond Companies Act, it becomes ultra vires. If MOA goes beyond Companies Act, it becomes ultra vires. So it should always be within the power. Okay. Next one, it is a document that consists of internal rules and regulations in the company. What do I mean by the word entrenchment, people? Entrenchment means making the provisions more stricter on the company. That means what, people? Now let us take, for example, to say, for example, if I want to shift my registered office from one state to another state, I need to pass a special resolution, correct? Imagine in my AOA, if I say, no, you should take 90% to the shareholders' approval, that is only called as entrenchment. Now, for example, what is the quorum? If at all your company has up to 1000 members, the quorum is 5 members. I will say, no, there should be 10 members present. Now, that is called as entrenchment. Making the provisions, rules more stricter on your company is called as, people, entrenchment of articles. Now, sir, how do we entrench the articles? It depends, people. If it is a new company, that's the easiest way to do. During the incorporation of the company itself, add whatever are the conditions you want in the articles. Easiest way. Sir, once the company is incorporated, so if you are already an existing company, then it depends upon what type of company you are. If you are a public company, then entrenchment of articles can be done by a special resolution. If you are a private company, then entrenchment of articles require all the members' approval. You need to pass a unanimous approval. Remember this and go, important. If you want to make a note of it, make a note of it. Next one, contents of AOA. It talks about allotments of shares, calls, transfer transmission, forfeiture rules, buybacks, proxy related provision, quorum. Yeah, all of this can be, people, your contents of articles. Okay, that's my AOA. The next part, sir, doctrines. The first doctrine is called as, people, doctrine of ultra vires. What do I mean by doctrine of ultra vires? Whenever you enter into a contract to do something which is beyond your object clause, we generally call it as, people, your ultra vires transaction. Remember, if it's a ultra vires transaction, people, it is a void ab initio, meaning it is invalid from the beginning. For such thing, the directors will be personally liable. The company will not be liable for any contract done. Not only that, sir, it does not create any creditor and debtor relationship. What do I mean by that? Let us imagine there was a company called as Company A. This company was into education as per its object clause. But the directors of this Company A, they went and they borrowed money from a creditor. Why did they borrow this money from a creditor? They borrowed this money from a creditor to do a cafe business. Technically, as per my object clause, it's an education business is what we can do. Now, if any money is borrowed, people, Company A is not liable to repay this to the creditors. We will not be liable because it does not create a debtor and creditor relationship. Then who will be liable, sir? The directors will be liable to repay. Sir, where is that written? That's your fourth doctrine. That is only called as doctrine of alter ego. Whoever is basically the wrongdoer, he will be liable. I will not be liable. The other person will be liable. That is the meaning. In Latin, it's called alter ego. In English, I can write it as the other I. That is that the other person is liable, not me. That is, in our case, the wrongdoer, that is the directors will be liable to repay that particular loan if you have done it as a ultra vires. Sir, if at all you do an ultra vires transaction, which the company itself has no powers. Remember, even if the shareholder wants to change this decision, even they cannot do. because it is an ultra vires transaction of the company. The company itself does not have power. So the shareholders do not have a right to make it valid. However, at times it so happen, let us imagine in our AOA, we have said our directors can borrow up to 5 crore rupees. In our AOA, we have written that the directors can borrow up to 5 crore rupees. But in reality, let us imagine our directors borrowed 7 crore rupees. Is this ultra vires? Answer is yes. Why did they borrow? Let us imagine they borrowed for the purpose of education itself. Correct. They borrowed for the purpose of education only. Agreed. Now, sir, you tell me, who is liable to repay this 7 crore? Remember, people, up to 5 crore company is liable, but for this 2 crore, the directors will be liable. However, now what happens after the contract is done? The directors goes and they explain to the shareholders, people, do you know why did we take the 7 crore loan? They clearly make them understand it was need of the business we had to do. And the shareholders agree to it. Now remember, people, whenever you are going beyond the power of the director, the shareholders have a right to approve this. When you entered, it was invalid. 7 crore was invalid. But later on, the shareholders have a right to make that contract valid. This process only is called as ratification. What do I mean by ratification? Ratification is nothing but, people, making an invalid act valid. Who can make it, sir? Shareholders can make it. So always remember, sir, what is the maxim? The maxim is simple. The maxim says, which is any act which is ultra vires the company cannot be ratified by the shareholders. Cannot be ratified by the shareholders. Sir, what if it is ultra vires? That means beyond the power of directors, not the company. Ultra vires the directors, but intra vires the company, meaning within the power of the company. Ultra means beyond, vires means power. Intra means within, vires means power. So within the powers of the company, this can be ratified by the shareholders. Remember this. Hello, simple, done. Okay, next one, sir. Members can get an injunction. That means if the directors are doing any ultra vires act, the members can go and bring a stay order from the court and they can prevent the directors from whatever they are doing. Okay, such transactions are void and does not bind the company. Okay, next one, sir. Next doctrine is called as, people, doctrine of constructive notice. What do I mean by doctrine of constructive notice? Yesterday, in the previous chapter when we are doing, in that itself I told you, people, that is, what is that? All the documents in a company, we are doing something called as e-filing. So every document of a company, it's a public domain document. So when you're entering into a contract with the company, it is assumed that you have a knowledge about the company. You have read all the documents. Sir, what if in reality I haven't read? Whether you read or not, people, it is assumed that you have read it. That is only called as doctrine of constructive notice. Always remember, in doctrine of constructive notice, we always protect the outsiders or the company. We always try to protect the company from the outsiders. Doctrine of indoor management is the opposite of it. We protect the outsiders from the company. What do I mean by doctrine of indoor management? Now, for example, in one of the case, what had happened is, for example, they had written in the articles of association, for any contract to be valid on behalf of the company, the document has to be signed by one director and one company secretary. So accordingly, one document was signed by director and company secretary, and they entered into a contract with a third party. Later what happened, people, they got to know that the company had not properly appointed the directors and CS. Properly means a proper consent was not taken, a proper intimation was not given, and hence it was considered that their appointment was invalid. Now the question is, whoever they enter into a contract with the third parties, what will happen to those contracts? It was held, people, under doctrine of indoor management. You just have said your contract to be valid, it has to be signed by a director and a CS. My obligation is just to check whether a director and CS is signing it. I cannot know whether they were properly appointed or not. That is indoor. It is internal affairs. How will I know as an outsider? So it was held, people, that this contract is valid. Is this clear, all of you? Yes? Okay. Doctrine of indoor management. Doctrine of indoor management, of course, has certain exceptions. What is that? First one is outsider had the knowledge of irregularity. What do I mean by knowledge of irregularity? I am telling all of this in short because we have much more broader, wider, deeper topics. You also know, I also know, these are all very basic stuffs, but I still am trying to cover it on the face of it. Outsider had a knowledge of irregularity means if you knew that something was still irregular, if you still entered into a contract, meaning in our previous case, yes, the appointment of CS and the director was not done properly. Even you were aware of it. If you are aware of it, the law will not protect you. Second one, no knowledge of MOA or AOA. That means, people, you never referred MOA and AOA at all. Then you cannot take the shelter under doctrine of indoor management. Third one, forgery. Remember, anyone if they fraudulently sign. In our case, imagine director and CS. Someone else signed as a director and CS. It will never create a valid contract. Forgery will never give you a right. Next one, negligence. Negligence means, people, when you are entering into a contract, it is your duty also to be a little careful. If you guys have studied in your foundation levels and all, you would have seen something called as caveat emptor. Let the buyer be aware. So you should also be aware on what you are doing. So don't be negligent. Third one was existence of agency. That means, sir, you do not even know that you are entering into a contract with a director or not. You don't even know that he is a director in that company. So if you don't know that fact only, company will of course not be liable. The last one, sir, preconditions not satisfied. That means, people, if any of the for example, in the AOA they have clearly written, if at all company needs to borrow any amount beyond 5 crore rupees, it has to be supported by a special resolution. So one of the case, what happened, the director goes and borrows 10 crore rupees. The bank, people, gives the loan without asking for special resolution. When the AOA clearly says you need to have special resolution, it is your duty to demand for that. You cannot assume that the special resolution was passed. It is your duty to see that. That is the meaning of precondition not satisfied. Done. Last one, sir, doctrine of alter ego. As I said, a wrongdoer will be punished. Okay, that's a part, sir. Next one, sir, alteration of charter documents. So MOA, sir, the first one is name change. It can be voluntary, it can be mandatory. Mandatory comes under section 16. When will this come into picture? Whenever any registered company or registered trademark holder or an LLP who thinks that some other company LLP has been incorporated with the name similar to theirs. Now what can they do? They can apply to people, central government. Technically RD has taken over that power. So you will apply to central government. The central government, if they are convinced, yes, what you are saying is right. Now my name is, let us take for example, RCB Limited. Inge promotion. No? Sir, simply now some other company started in this name. You tell me. Now we are telling, sir, our name and their name is same. Is it same or not? It's same. This is called phonetically same. So, sir, we file our application to central government. If central government is satisfied, they will send a notice to this RCB Limited, sir, and they will tell them to change the name. Whenever they pass an order, within 3 months, people, the duplicate company will have to change its name. They need to intimate it to ROC. ROC will allot them a fresh certificate of incorporation with the new name. Remember, sir, RCB Limited has to apply to central government within 3 years of this company getting incorporated. If at all you go beyond 3 years, sir, then you lose a right to go. You will not have any protection under the law. Clear? Yes, sir. Sir, what if within 3 months, if this company does not change its name, then central government only will allot a new name to this company on its own. So moto. Done. Okay, done. Okay, sir. Now, what if we are voluntarily changing name, or the government sent us an order within 3 months I need to change? How do I change the name? The procedure, sir, first you have to call a board meeting, check the name availability by filing an application called as run application. The name will be reserved for a period of 60 days. Now, in this 60 days, you have to call for board meeting. You have to pass board resolution, call for a general meeting, pass a special resolution. Sir, this is our new name. Tell the shareholders why we are doing it. File MGT 14 with ROC within 30 days. And remember, whenever you want to change your name, you need to take approval of CG. So you need to take approval of central government by filing the form INC 24. If everything is satisfied, ROC issues a new certificate of incorporation. Sir, effect of change in name. Remember, people, all the cases will still continue. There will be nothing changed to your cases and all. But remember, if anyone wants to file a case going forward, it is always advisable for them to file the case in the new name and not in the old name. Even though if they are filing a case in the old name, it is not an incurable defect. They should be given a chance to amend their plaint and refile their complaint again. Okay. Next one, name of listed company. Remember, very important. What is that? With regards to the name clause, with regards to the listed company, there is some additional things it seems. What is that? As per regulation 45 of SEBI LODR, you can't keep changing the name like every month or every 2 months. From one change to another, people, there should be at least 1 year cool off. I change it today, again I can change it only after 1 year. Next one, sir, 50% of its total revenue in the previous year should be from the activity suggested by new name, or amount invested in new activity is at least 50% of the total assets of the company. When will this apply, people? Try to understand. For the year 24-25, let us imagine the company's, our name is Arivu, our actual name is Arivu Educational Consultants Private Limited. That's the name of the company. Now we want to change this name to Arivu, say for example, food and probably, I don't know, food and say, okay, let us imagine Arivu Food and Consultants Private Limited. We want to change our name to this. It's change in name only. We are indicating a new activity now. They're telling people, of course, I cannot say private limited because it's a listed company. Now, what is that they're telling you? If your name indicates any activity, if you want to change the activity, then first, now from 24 to 25, now if at all I'm doing it in 25, 26, if I want to change the name, in this year if I want to change, then they're telling you, in the previous year, you should have earned from the food business at least 50% of your total revenue. That means if we have earned 10 crore, in that at least 5 crore should have come from food business. Or, sir, just 1 year, sir, how will we earn 50%? Okay, then you at least invest 50% in that business. So instead of investing in the building, in the whatever infra for education, you invest into the hotels, the food business. At least 50% of your total assets should be in the food business. If yes, you can have the activity in the name. However, remember people, if your name is generic, for example, recently one company changed their name from Zomato to Eternal. Now Zomato is not an activity, Eternal is also not an activity, and hence this condition itself will not apply. Hello? Okay. Next one, sir. Old name and new name both has to be disclosed on the website of the stock exchange at least for a period of 1 year. Next one, sir. If listed company changes its activities, it shall also change its name in line with the activities within 6 months. So that means if Zomato is going from food business into, I don't know, some other theater business, they have to change. If their object clause is changed, they're telling you have to change your name also in line with your objects. That means you cannot have in name, you cannot have education, and in business you cannot have food, the way we changed in our case. So if you change your name, if you change your business from education to food, your name should also be changed within 6 months. That's what they're telling you. That's the last line. Here. Okay. Next one, sir. Shifting of registered office clause. How do we shift people? If it is within the same city, town or village, now within Bangalore, if Arivu's registered office is within Bangalore, if I want to change within Bangalore, a simple board resolution is sufficient, nothing else is required. I have to intimate ROC, of course, in the form INC 22. Done. The most simplest one. Next one, change within state. That is, let us imagine we are in Karnataka, but we are shifting from Bangalore to, let us imagine we are going to Mysore. So we are going from one city to another. Then what is the procedure? They're telling you, I need to take board, one more will add, special resolution, still the same, I have to file it with INC 22 ROC. Because I pass special resolution, MGT 14 will come into picture. So the third one, sir, within same state but one jurisdiction of ROC to another. This will only come in two scenarios, where one in the case of Tamil Nadu, one in the case of Maharashtra. In Tamil Nadu people, it is from Coimbatore to Chennai. In Maharashtra people, from Pune to Mumbai. So if you are shifting from this jurisdiction to here or here or here or here, then the third condition will apply. Board still same, special still same. Only additional thing that will come into picture is people, you need to take the approval of regional director. That's condition number 1. And in addition to that, I also have to take the consent from my creditors. If I have any loans, they should be okay with it. No, till today I was in Chennai, now I am going to some other jurisdiction altogether. They should be okay with it, right? So I need to take the approval of the creditors as well. How will I take the approval of RD? By filing a form. Which form? I need to file a form called INC 23. Hello. Now what does that see here? So board, special, I have to file form INC 23. 1 month before filing INC 23, I have to publish a notice in the newspaper. I have to give an individual notice to the debenture holders, depositors and creditors to intimate RD. If at all you have any problem, then please come and intimate within 21 days. You guys have 21 days time. Hello. Okay. So attachments. Now once this is done, now if these people have a problem, let them come to RD. If they are coming, then there will be a hearing. Whosoever RD thinks is fair, whosoever RD thinks is reasonable, they will win the case. Okay. Now when we are filing this application to RD, we'll be filing along with the application, we will be filing board resolution, special resolution. This is important. Exam point of view, remember and go. We'll be filing a declaration given by KMP or 2 directors that we have not defaulted in paying any of our employees and there is no default in creditors. Either completely repay them or take their consent that we will repay you, don't worry, and they should be okay with it. So if they don't give consent, you cannot change. Clear? Okay. Next one, sir. Whatever your ongoing cases are, promise us now only that you will not ask for change in jurisdiction. You're undergoing a case in ROC Chennai. It should go there only. You should not ask for ROC Coimbatore. So if you're okay with all of that, then we don't mind. So application to RD, within 30 days, RD will pass an order. Upon the approval, we will file that copy with the ROC and we'll also intimate the new address to ROC. So the last change is, sir, one state to another. More or less the same thing will come into picture, people. We have to take central government's approval. Central government has delegated the power to RD. So RD only will come into picture. So application form is still the same, INC 23. Approvals is first board plus a special. Again, creditors will come into picture. Another person that will come here is people, your, of course, RD. One additional person is people, chief secretary will come. What do I mean by chief secretary, sir? Nothing but people. In the fourth case, we are shifting our registered office from Karnataka to, say, for example, Kerala. Now people, I need to make sure, now our office was in Karnataka till now. Now why am I going to Kerala? What if I am removing all my employees from the job? People, remember, shifting of registered office should not cause any harm or removal or retrenchment in the jobs. If they want to leave, that's a different story. But remember people, you as a company should not remove them. So regarding that, you need to give an acknowledgement to the chief secretary of the state that shifting of registered office from one state to another did not result in removal of any employee. We offered jobs, everyone. If they are not okay to continue, that's their personal life. Hello, clear? And always remember people, whenever there is a shifting of registered office beyond the city, that is except the first scenario. In all the other three scenarios, people, the approval should be by postal ballot. Remember that. Hello, clear? Acknowledgement, chief secretary that proposed shifting does not affect the interest of employees. Hello. Okay, postal ballot outside the city. What are three cases? Cases is nothing but people. Can the central government object the shifting of registered office on the grounds that, imagine Karnataka government says, hey, if you go to Kerala, there is a loss of SGST that you are paying us, hence we will not give you. No people, loss of revenue to one state is not a ground for objection. And what if one government had given you all freebies, free land, free electricity? Now you have taken all the benefit. Now you want to go out of it. It's still okay. Those are all not the grounds for, stopping the shifting of registered office. Hello. And remember, if at all employees have an objection, they need not come and fight personally. An employee union, trade unions are allowed to come and fight the case on behalf of employees. That is the case law. All three done. Alteration of object clause. How do we alter the object clause? Simple. Call for a board meeting, pass a board resolution, call for a general meeting, pass a special resolution. If it's more than 200 members, then it has to be through postal ballot. There is one more section called as section 27, which says, imagine if a company has gone for IPO by issuing prospectus and we have raised money. In the prospectus, we have said we will use the money for education. And we have raised around, let us imagine, 1000 crores. Now we were able to achieve our object within 600 crore only. We achieved it. We still have 400 crore. Now the company decided, why can't we use this 400 crore for some other purpose? Let us imagine we can start some financial services with this. Or PG services. As students, you guys anyways want it. We'll decide to start PG services with that. Now the question is, just like that, can I use this 400 crore? No. There is a procedure. What is that? I have to call the shareholders for a meeting. I have to pass special resolution. And if any shareholders are not okay with it, I have to give them something called as exit opportunity given to the dissenting shareholders. I am not okay if the company invests in this. Okay, you as a shareholder, you are entitled for your money back. So we have to give you, we have to buy the shares of you, we have to give you an exit opportunity. Clear? Hello? And remember, using this 400 crore, the company can never invest in any equity shares of any listed company. This is prohibited. You can invest it in any other object, but you can never use that money to invest in any other company equity share. It is disallowed. Yes, sir. So that is something. And you have to give a you have to publish an advertisement in a newspaper that this is what it is in English and vernacular. Always remember. Done now. Next one, change in capital clause. We will do it when we are doing section 61. That time we will cover it. Alteration of AOA, which I already told you. That's all. What is this? Alteration of articles of association. Always remember, whenever you are altering your AOA, there are some points you need to keep in mind. That is, the alteration must not exceed the powers given by MOA. I always told you, AOA should always be subordinate to MOA. Whenever there is a conflict between AOA and MOA, always MOA only will prevail. Next one, the alteration must not be inconsistent with any provision of Companies Act. So I should not override the Companies Act also, or any other act for that matter. I cannot make something illegal as legal for my company in my AOA. The articles must not include anything which is illegal. The alteration must be bona fide for the benefit of the company. If not, people, you cannot simply alter anything in the articles. If you are altering, it should be for the benefit of the company. The alteration must not constitute a fraud on the minority by a majority. The articles must not compel an existing member to take or subscribe more shares. I cannot compel you. Every shareholder should have at least 30% of shares. All that is bullshit. A company cannot escape from its contractual obligation with any person. That means, imagine we have entered into a contract with a person called as Mr. D. Through our AOA, we are telling that all the contracts entered by the company with Mr. D is void. No, you cannot affect anything. And always remember, any amendment you make in articles of association, it should always be prospective. It can never be retrospective. Always remember that. Not possible. The alteration must not be inconsistent with any order of the court. There are so many case laws. That means it is like a decision of the court. Your alteration should not be against that. Remember. Alteration of MOA to be noted in every copy. That means what, people? Now MOA, OA, whenever you are altering them, it should clearly say that, people, this is an amended copy. If at all you give the old copy, or if you give an unamended copy to anyone, you are liable to pay a penalty of, people, 1,000 rupees for every copy you have circulated. That is section 15. Next one is, people, pre-incorporation contracts. What is pre-incorporation contracts? The contracts entered by the promoters before the company's incorporation. Now the first question is, does that contract bind the company? Answer is no. By default, it does not bind. So to bind it, what should we do? To bind it, people, there are certain things you need to satisfy. First one, people, in your object clause, MOA, it should clearly say people that the company will ratify the pre-incorporation contracts. We have the power. You have to give it in the object clause. Next one, in your AOA, you have to clearly give the power to the directors to what? Ratify the contracts. That power has to be given in the AOA. Third one, people, as soon as the company is incorporated, in its first board meeting, you need to adopt. Meaning you need to ratify all the contracts. If you do all of these, people, then yes, pre-incorporation contracts will be binding on the company. If it is not done, people, then the promoters will be personally liable. That is what is this. Hello. Clear? That's all, people. Yeah, for this chapter, this much revision is more than sufficient. We have more in detail monsters about to come. We will focus more in that particular chapter. That's the end of your chapter 3. Yes, people. So let's start our next chapter. Till now we have done around 3 chapters. So what I would always suggest you is, you guys do not watch the entire marathon at a stretch. How you guys have to plan is, have also given you a 12-day planner for company law, how to plan your studies. So watch one chapter of the marathon, read the complete text, whether from whichever material you guys are using, read it and then solve all the questions from that particular chapter. So get a good scanner. That's how you guys have to do it. And that's the most effective way as well. Yeah. Okay. Yes, people. So the biggest chapter is here. Okay. So divided into 5 parts. Let us see how quickly and how deep we can do it. Okay, so share and share capital concepts. Okay, the meaning and definition, the types of capital. There are 5 types of capital. That is authorized capital, the maximum capital. Out of that, how much the company has issued, that is called as issued capital. From that, how much has public purchased is called as subscribed capital. Out of the total face value, how much has the company called to pay is called as called up capital. From that, how much the shareholders have paid is called as paid up capital. That is the 5 types. Types of shares, there are 2 types of shares majorly. One is called as equity, one is called as preference. Equity can further be classified into 2 types. One is equity shares with normal voting rights. Next one is equity shares with differential voting rights. So to issue DVR share, what are the conditions that the company has to satisfy? The company has to satisfy some conditions, right? Now what is that? If a company has to issue DVR shares, you need to satisfy the rule 4 of companies share capital and debenture rules. Every condition is important. Try to remember word by word. The first one is you should have authorized by AOA. What if we did not authorize by AOA? You have to alter your articles of association, pass a special resolution, file form MGT 14, and only then you can issue DVR shares. Next one is ordinary resolution is sufficient. See, this is where maximum times we will think it is special, but ordinary is sufficient. If you are a listed company, then postal ballot becomes mandatory. Next one, the maximum of DVR. How much DVR shares can we issue at any given point of time? The maximum DVR shares cannot exceed 74% of your total voting power. So if you have total 100% of votes, in that DVRs cannot have more than 74%. The 26% should be normal shares. Yeah. Okay, next one, the conditions. What is that? You should have not defaulted. Defaulted in what? Defaulted, you can classify that into, I can classify that into 1, 2, 3 and 4 defaults. What is that? The first one, you should have not defaulted in filing your financial statements and annual returns in the last 3 years. So your last 3 years has to be clean. If it's clean, you can go for DVR shares. Next one, this is important. See, what do I mean by no subsisting default? Subsisting means when I'm issuing DVR today, On today there should not be default. What if there is a default yesterday? That is okay. But today there should not be any default. Default in what? Default in people, if you have issued any preference shares, debentures, you should have not defaulted in redeeming them, repaying them. Next one, if you have declared any dividends, you should have not defaulted in paying the declared dividends. Next one, repayment of deposits. If you have accepted any deposits, there should not be any default. Next one, you should have again not defaulted. See, here it is no subsisting. Subsisting means yesterday you have done a default. That's okay. Today that should not be there. But here, sir, you should have not made a default. If you have made a default, people, first you have to make good the default. You have to repay that default. And after that, you need to wait for a period of 5 years. There is a cool off period. Now, what is that, sir? Now, if at all you have declared any preference dividend, in that you guys should not have made any default. Next one, you have taken any loans. There should not be any default in repayment of loans. Next one, there should not be any default in repayment of statutory payments like employees, provident funds and things like that. Sir, we have to 7 years IPF. We have made a default there. If such any default happens, then people, there is a 5-year cool off period. 5 years cool off will start from when? Imagine if we have made a default in the year 2014, we did not pay loan. In the year 2016, we repaid loan. You have to leave 2016. Start from 2017. 1st April 2017 to 31st March 2018. Like that. 19, 20, 21, 22. So on 1st April 2022, you guys can issue DVR shares. That's how you calculate. Clear? Okay, next default is you should have not been penalized under these 4 acts in the last 3 years. You should have not made any default. What are the 4 acts? One is RBI, SEBI, SCRA and FEMA. So under these 4 acts, you should not be penalized, sentenced to any imprisonment, sentenced to pay any penalties. You should have not been penalized. Sir, always remember, you cannot convert the existing shares into DVR, DVR into existing shares. They are entitled to all the other rights. For example, a normal share is entitled for financial statements, entitled for dividends, entitled for copies of annual returns or notice of general meeting. All those rights will stay intact. That will not change. Remember that. Yeah. Just a second. Summer studying in summer is crazy, huh? I don't know how you guys are managing. Keep yourself hydrated. You tend to become more and more dehydrated, and that will have an impact on your studies as well. Okay, that is your types of shares. Okay, now coming back, sir, DVR. Okay, next one is people preference share. Now we know preference share, sir. There are different types of preference share. Does preference share has right to vote? Section 55. Preference shares generally do not have a right to vote. But when will they have a right to vote? Whenever people, if there is anything that is concerning their rights, they have a right to vote. During the winding up of the company, the preference shareholders will have a right to vote. Agreed? Yes, sir. And also in the case of reduction of share capital, they will have a right to vote. In these 3 scenarios, the preference share capital will have a right to vote. Except these 3 scenarios, generally they do not have a right to vote. However, whenever the preference dividend is not paid for a consecutive period of 2 years, then people, the preference shareholders will have a right to vote on every motion that has been placed in front of that particular meeting. So they can vote on everything just like equity shares. However, the law is silent whether how long will they have this right. See, if I don't repay for 2 years, I will have this right, correct? But will it be there for 5 years, 10 years? How long I can keep voting? Now, for that people, the law is silent. Now, what can we assume that? See, when there is a default, you have a right to vote. When the default is made good, the right to vote will come to an end. Yes, that is a understanding, but it is not written in the law. Okay. Preference shareholders right to vote. Okay, next one, sir. What is the maximum period of preference shares, sir? The maximum we can issue the preference shares for people 20 years. Sir, can we issue more than 20 years? Not everyone, but a few people can issue for more than 20 years. Who are they? They are the companies who are into infrastructure projects. If you are into infrastructure projects, you can issue preference shares for a period of more than 20 years, but not more than 30 years. So those companies who are into infrastructure projects, they can issue the preference shares for more than 20 years, but not more than 30 years. However, with the condition that from the 21st year onwards, you have to start repaying 10% of your total preference shares at the option of the preference shareholder. So minimum 10% you have to start redeeming from the 21st year onwards. Clear? Okay. And the preference shares can be of various types. One is what? Cumulative, non-cumulative, convertible, non-convertible, redeemable, irredeemable. Remember, irredeemable preference shares cannot exist. So it has to be convertible or non-convertible. Convertible which gets converted to equity, non-convertible which will be redeemed. How will you redeem, sir? How will you repay? You will repay people out of your profits which is available for dividends. You will repay it out of the profits of the company, and the premium on redemption can also be used. You can use your securities premium account to repay the preference shares for a premium price. You can use that. Correct? Yes. So preference shares shall be redeemed out of the profits of the company. Premium on redemption, you can use your securities premium as well. Sir, what if I don't have my profits, sir? Remember, you can use issue of equity. You issue equity, new shares, you raise money. That also you can use to repay the preference shares. Proceeds of fresh issue. Clear? Okay. Whenever you are repaying the preference shares from the profits, in such case you will have to create something called as capital redemption reserve account. I hope you guys would have seen this in accounts also. I would have explained this to you in the class as well. Yes, so remember and go. So remember, we have issued preference share with 5 years maturity, but in the 5 years we were not able to repay. Now, can we add another 2 years, sir? Can we please tell our shareholders, people, because of some reasons we are not able to repay the preference shares immediately, can you give us another 2-year time? Can we do this? Answer is yes, you can do it. Now, this process is called as rollover. What do I mean by rollover? Technically, I should have repaid your preference share within 5 years, but I need an additional 2-year time. Now, how to do this? Simple. Call the preference shareholders for a meeting. Take 3/4 of the preference shareholders in value. You have to take their approval and submit your application to the tribunal as well. And if tribunal also gives you a consent, then you can go people and convert whatever your 5 years, you can do it additionally. You can extend it by another 2 years. Clear? Okay. What is the procedure for issue of preference share? It is same like equity only. What is that? You will first call for a general meeting. You will pass a special resolution. Because special resolution, you will file form MGT 14. Within 30 days of allotment, you need to file form PAS 3. See, this is same only, no? Whenever you are allotting shares, people, equity, preference, anything, if you guys are allotting securities, you will have to file PAS 3 within 30 days to ROC. And you will have to give the share certificates within 2 months. During the incorporation, again 2 months. But if you guys are issuing debentures, you will give the debenture certificate within 6 months. And whenever you're transferring the share, A transfers the shares to B. In such case, the B will have to get the new shares. No, that will be given within how many days? Within 30 days. That is within 1 month. Remember that. Whenever we are redeeming the preference share, we will have to file form SH7. SH7, when else you will file, people? You will file it in section 61. You would have seen what is that? Alteration of capital. So you will file SH7 whenever you are doing anything in section 61. The 5 things: alteration of capital, increase of authorized capital, share split, consolidation, conversion of share into stock, or cancellation. When you're doing those, or reduction of preference share, redemption of preference share capital, you will still file form SH7 with ROC within 30 days. Okay. That's all. That's your part A. Like that, people, in your chapter 4, you have 5 parts. Technically, why is because if you don't have those parts, no, you will feel, my God, how much is there in this particular chapter? So it's so vast. So it is there from the scratch. So it is there from the types of capital, and it goes on up to the transfer and transmission. Correct? Okay. Next one, sir. Part B. In part B, what will we see? We'll be seeing more into prospectus and public offer and things like that. Okay. The next chapter, sir, is part B, the basic terms related to the allotment of securities and as the case may be. The first thing you guys need to know is called as prospectus. Now, what do I mean by prospectus, sir? Prospectus is nothing but whenever a company is going for a public offer, the company will have to mandatorily issue something called as a prospectus to the public. A company can never do a public offer without prospectus. A prospectus, people, can be of various types, but 3 things you guys have to know. One is called as shelf prospectus, one is called as red herring prospectus, the third one is called as abridged prospectus. What do I mean by abridged prospectus? Abridged prospectus means nothing but, generally remember, the prospectus will be very lengthy document. That is, the prospectus itself will be around for 300 pages. And you are expected to read this 300 pages. Of course, you guys won't read. You guys are not reading a deciding factor of your life, your career. That one book only you guys are not reading. Will you guys read all this prospectus and all? You will not read. So to help you, what they have done, the company has to prepare something called as a summary of this prospectus. That summary is only called as abridged prospectus. Abridged is nothing but summary. Clear? Yes, okay. Is abridged prospectus important? Answer is yes. Is it mandatory? Answer is yes. But exceptions are there. Whenever you're going for underwriting or whenever you're giving it to the existing members, you need not have to give abridged prospectus. In rest of all the cases, abridged prospectus becomes mandatory. Okay. So what do I mean by shelf prospectus? What do I mean by red herring prospectus? What do I mean by red herring prospectus, people? A prospectus in which all the details are mentioned except 2 details. What is that, sir? It does not include all the details, people. It has all the details except the quantity of the shares that you're issuing, or the price of the shares that you're issuing. These 2 details, any of these 2 details will not be mentioned in the prospectus. When will a company issue red herring prospectus? Whenever they do not know the firm price of the share. Should I price my share at 200 or 300? I'm not sure. So what do? We do a process called as book building, like a bidding. We will allow the public only to decide the price. We will give you a band like 200 to 240. In between this, you guys decide. Whichever price you guys vote, the maximum, that will be our price. So to do such type of bidding, the prospectus that we issue, the prospectus we use is called as, people, red herring prospectus. Is clear? All of you? Yeah. Okay. So it is always issued prior to the issue of prospectus. Remember that. And it is filed with the registrar at least 3 days before the opening of the subscription list and the offer. That is, if your IPO opens today, you will file this at least 3 days before to the registrar. And remember, you will start doing the bidding. If finally, if people decide 220 is the price, you will do your IPO at 220. And after the entire IPO is done, we will file one document with the final number of shares issued and what was the final price. We will file this document with the ROC and also people with the SEBI. And now this becomes a complete prospectus. The next type of prospectus is called as shelf prospectus. Now what do I mean by shelf prospectus? A prospectus generally, now imagine there is a company who would, imagine like this. I do not want to raise all the money at once. The company needs around 4,000 crores, but I don't need everything today. So what does the company decide? The company will decide to do multiple offers, like 1, 2, 3 offers. Now what happens? Whenever you do a public offer, you need to issue prospectus again. That's a time consuming and also money consuming process. So what do you do? What you can do it as an alternative, what you can do is you can file a prospectus called as shelf prospectus with the SEBI. Now the validity of the shelf prospectus will be 1 year. So if you are doing your first offer today in the month of Jan, now this prospectus will be valid up to the end of this year. The entire complete 1 year, this prospectus will be valid. Now what happens? If you want to do the second, third, fourth offer, you need not have to issue the prospectus again, because once you have issued a prospectus, this prospectus will have a validity period of 1 year. Generally, whenever you buy any product, you generally ask shelf life. That is how many days we can use it. In the same way, people, the shelf life for this is called as 1 year. That's why the name came called as shelf prospectus. How long can you keep this prospectus in the shelf? After you have to dispose it. Correct? So, from the day you do your first offer, you can do any number of offers, 5, 6, 8, 10 in the duration of 1 year. Hello? Clear? Hello? Sir, what if in the month of Jan we issue the prospectus? In the month of August, there are some details that has changed in the company. We have created further charges. We have taken more loans. Now that is not there in the prospectus. Now what to do? Remember, any change in the financial position of the company, any charges created. So if any such changes have happened, only that information you will file it again. Now sir, in which document we will file it, sir? You will file it with ROC in a document called as PAS2. That is called as Information Memorandum. What will be there in Information Memorandum? Information Memorandum shall consist of any new charges created, any change in financial positions of the company will be intimated to ROC in the form PAS2. Clear? Done? Done. That's your shelf prospectus. And remember, if anyone who has given advance money, that is, there is a shareholder who thought I would want the second offer, third offer as well. So he has given entire money at the time of first offer only. After, if the company come up with PAS2, if the shareholder thinks the company is not fit now, you should be given an opportunity to withdraw the advance money. You have to refund. If he is not interested to buy the shares in the second offer. Not the first offer money, second offer money we have to refund. Clear? Yes sir. Done. Okay. Next one is called as deemed prospectus. What do I mean by deemed prospectus? Generally, what did we say? Whenever a company gives its shares to public, you have to always give a prospectus. Now what if a company do not give the shares directly to directly to the public? Instead, there is one company who will give the shares to another company. Now that will further give it to public. So company A is not giving to the public directly. They are giving to company B. Company B is giving the shares to the public. Now the question is, in this case, should we give a prospectus? So people used to avoid giving prospectus in these cases. That's why they introduced the concept called as deemed prospectus. What do I mean by deemed prospectus? Deemed means what? Assumed. So when company A gives its shares to company B and company B gives the shares to the public, whatever document the company B is using to give the shares to the public, it can be advertisement, it can be some document, it can be newspaper advertisement, whatever document you are giving, that document will be deemed to be prospectus. That's why the name comes as deemed prospectus. I hope this is clear. Clear, Ram? Yes, Ram? Okay. Provided, when will this become a deemed prospectus? For this to become a deemed prospectus, you need to satisfy some condition. What is that? For a document to become a deemed document, remember, when A gave shares to B. Now we have two questions. When did A give shares to B? Sorry, A gave shares to B on 1st Jan 2026. What is the value? So the value of the share is 1000 crore. Okay, question number 1. Has company B paid that 1000 crore for company A? If the answer is yes, then you have satisfied one condition. Question number 2. When is company B giving the shares to the public? Sir, the company B is giving the shares to the public on 1st of April 2026. On 1st of Jan only company A gave shares to B, and 1st of April company B is giving shares to public. Then people, whatever the document, we will call this document as deemed prospectus. So basically it will become a deemed public offer. Why? Because you are giving the shares further to public within the 6 months of company A giving it to you. Sir, what if I give the shares on 1st August 2026? Jan, Feb, March, April, May, June. Once June is done, forget about August. Even if it is July, this will not become a deemed prospectus because 6 months period is over and full money is also paid. If both the conditions are not satisfied, people, then this will not become a deemed prospectus. If even one condition is not satisfied, that is, if full consideration is not paid, or if within 6 months only, if I am giving it to someone else, it will become a deemed prospectus. In such case, what should we do? Whichever is the deemed prospectus, this company B is there, no? If that B is a company or if it is a partnership. If you are a company, at least 2 directors from your company should also sign this prospectus. Sir, it is not a company, it's a partnership. Then people, half of your partners has to sign this particular prospectus. That is what they are telling you. If it is a firm, half of the partners have to sign. If it's a company, 2 directors have to sign the prospectus. Is this clear, all of you? Okay, done. The next one is called as offer for sale. What do I mean by OFS? Offer for sale. Simple people, when a company is doing a public offer, what does the company do? The company will print new shares and that they will give it to public. But at times what happens, the existing shareholders in a company who are already shareholders, like example is promoters, they will say, hey, why do you print new shares? I will give the shares to you. You can give it to them. Why would you want to again print new shares? We do not need it. So if existing shareholders ka shares, if it is taken and if it is given to public, we call this as offer for sale. Example is in the case of Mamaearth. There was an offer for sale done. Who did it? There was, who is that hero in the yoga and all, she does know. Shilpa Shetty. Shilpa Shetty was one of the investors in Mamaearth. When they went for an IPO, she liquidated her shares, around 60% of her shares she sold at a price of around 40 crore. Now this is only called as offer for sale. Understood? Yes, hello, pakka, done. Okay. The next one, allotment, section 39. Okay. Now, whenever a company goes for a public offer, you need to allot the shares, right? Sir, when should we allot the shares? Remember, for you to do the allotment, people, the first condition you need to satisfy is, in the prospectus, the company has to clearly tell what will be the minimum subscription that the company is looking for. That means, if we are selling 100 shares, when will the IPO be considered as complete? You have to mention what is the minimum percentage of shares that the public has to buy. It can be, say for example, in the prospectus you can write at least out of 100 shares, 60 shares has to be purchased. If that is purchased, then the IPO is successful. So that number you have to write in prospectus. But remember, according to company law, you can write whatever is a number the company wants. But as per SEBI people, this is 90%. So out of 100 shares, 90 shares has to be purchased. If not, people, your IPO is unsuccessful. Sir, within how many days it has to be purchased? It has to be purchased, people, whatever is the offer period, within that it has to be purchased. Sir, what if it is not purchased? The received amount shall be refunded if not subscribed within the 30 days. So within the offer period, if they are not buying, people, I need to refund the entire money within 30 days. Sir, what if to be refunded within 15 days from the date of closure? Sir, now what if it is not refunded? If it is not refunded, people, I need to pay interest the rate of 15%. Is this clear? Hello, all of you. Okay. So I have to refund. If it is not subscribed within 30 days, I will get another 15 days to refund. Within this time, if I don't pay it, it will be 15%. Do not get confused between this and private placement. I am writing it hand in hand here only. Here it is 30 days to allot. If not, people, within 15 days I have to refund. If not, people, it is 15% rate of interest. In private placement, it will be 60 days, 15 days to refund, 12% rate of interest in case of default. Remember this. Hello? Hello? Okay. Next one, sir. What is the minimum application money? According to Companies Act, it is 5%. That is, if my face value is 100, at least 5 rupees I have to collect it upfront as an application value. But the Companies Act only say it is 5% or whatever is prescribed by SEBI. SEBI has prescribed it as 25%. In reality, we follow this only. But according to company law, this is 5%. Return of allotment, once you allot the shares, you need to file the form PAS3 to the ROC. Remember, PAS3 will clearly have the list of allottees, what is the value of the price, how did you decide that is the value of the price, that is, you need to give something called as valuer certificate, as the case may be. Penalty if you do not do it on time. Remember, when you are doing offer for sale, no, these conditions will not apply. What? Minimum subscription, minimum application value, and what are you going to do with the money you have raised? You have to mention that in the prospectus. Here, what will I do? I will give it to the promoters only. No, whoever has given us shares, we will give the money to them. We can't keep it as a company. Statement to be made by board in respect of utilization of money. All of this will not apply to offer for sale. I hope this is clear. That is allotment. Securities to be dealt within stock exchange. This is nothing but whenever you are going for an IPO, remember you have to file an application at least to one of the stock exchange. Hello. Of course, no, that's why you are calling it listed. Okay. And remember, you have to keep the entire money that you have raised and public offer until you get the entire money, and until the entire procedure is done, you're not supposed to utilize that money. You have to keep it in a separate bank account. Okay. Sir, what is the maximum commission I can pay? If it depends, people. If you are issuing shares, the maximum commission you can pay shall not exceed, this is for underwriters, the maximum you can pay people for shares shall not exceed 5% or whatever is the percentage prescribed in AOA, whichever is less. If it is debentures, 2.5 or whatever is prescribed in AOA, whichever is less. And remember, whatever shares today, if you guys are doing, if you are a listed company, any issue you do, according to Rule 9 of Prospectus and Allotment of Securities, everything should be in a DMAT form. As per Rule 9A, any public company, if you guys are doing any issue, even your shares has to be in DMAT form. As per Rule 9B, within 18 months from 31st of March 2023, all the shares issued even by a private company should also be in DMAT form. Only exception is people, small company. Is this clear? So today listed public and private except small company, everyone today are issuing the shares in DMAT form only. Hello. Abridged prospectus. When is it not required? Whenever you are entering into underwriting agreement, next one, in relation to securities which were not offered to public. So if you are not giving it to the public, if you are giving the shares to the existing members, abridged prospectus is not required. Remember, this can be important from exam point of view. Offer for sale, Zomato's details we had seen. Duplicate share certificate, do you want what is duplicate share certificate? Whenever you're existing, today's date is irrelevant, people, because as I told you, even if listed company, public company and private company, if everyone shares are dematerialized, who is holding physical shares today? So this becomes eventually, people, if you ask me 3 years, 5 years down the line, even small companies will also be said to convert their physical share certificate into DMAT form only. Then people, this becomes absolutely irrelevant. Correct? When you're converting your physical shares into DMAT form, then what is the use? Agreed? But yes, what is duplicate share certificate? Whenever my existing share certificates, if I lose it, or if it is torn, if it is defaced, if it is mutilated, any such things happen, upon me submitting it, I'll have to go and give my letter of allotment or the share certificate. The company will pass a board resolution and they will collect some fees, which will generally not be more than 50 days. They will collect some fees and they will allot me a duplicate share certificate. If you are an unlisted company, you have to, once the person gives you a request for duplicate share certificate, you have to give it within 45 days. If you're a listed company, you guys will have to do it within listed company is 45 days. If you are unlisted company, within 3 months. Where is it? Listed company has to do it within 45 days. Unlisted company has to do it within 3 months. And whenever you are issuing duplicate share certificate, all the details you have to maintain it in a register. That register is in the form SH2. Remember, the SH2 is not the format of duplicate share certificate. Duplicate share certificate format is SH1 only. But whenever you are issuing duplicate share certificate, all the details has to be mentioned in a register called as SH2, Register of Duplicate Share Certificate. That is what it is, 50 SH2. What do you mean by share split? If I have 100 shares, if I split it into, like if I have 100 rupees, if I get 50 rupees, 2 notes. The same way, if I have 100 shares in one certificate, I can split it into 2. That is called as share split. Remember, this duplicate share certificate, all these registers and all has to be maintained for a period of 30 years by the company. That is what they are saying. Legal effect of share certificate, there is something called as estoppel as to title, estoppel as to payment. That is, once the company has issued a share certificate, you can never say that the shareholder, whosoever is a shareholder, if their name is written on the share certificate, we generally say on a prima facie evidence, he only is the owner. Estoppel means the company cannot go back. Next one, the company cannot say that he has not paid the money. If on the share certificate it is mentioned, it is 5 rupees paid, 10 rupees paid, tomorrow, next day, the company cannot deny that particular fact. That's your part 2. Let's do part C. Yes, people. So, in the part C, yes, before we start part C, I think we had to do the share certificates, correct? Duplicate we did. SH1, yes, this one, just remember and go. Whenever a company is newly incorporated, within how many days should we issue the share certificates? We'll have to issue it within 2 months from the day of incorporation. Whenever it's a newly incorporated company. So whoever are the initial shareholders, we need to allot them the share certificates within 2 months from the date of incorporation. Okay. And whenever any new allotment happens, like for example, you can take as an IPO, rights issue, private placement, within 2 months from the date of allotment, I need to give them the share certificates. Third one, transfer and transmission. What is this? Nothing but people, if you guys remember our last part, you will be seeing it. SH4, whenever I'm transferring my shares, A is transferring his shares from A to B. Now we need to issue a new share certificate to B, right? So that has to be done within 1 month from the date of receipt by the company. Whenever we give this SH4 within 1 month, I need to do that. Next one, any allotment in the case of debentures. Any other security, 2 months. In the case of debenture, 6 months. Remember. Okay, next one, part C. Part C, yes, it has this is nothing but personation of shareholder. What does personation of shareholder mean? Nothing but if someone pretends to be a shareholder, that is, fraudulently, he personate means what, people? Someone acts like a shareholder, even though they are not. They are punishable. It is a criminal offense. You can be even put into jail for that. Remember and go. I'm not going into the imprisonment part that much in detail. Okay, next one, part C, issue and allotment of securities. Of course, it also has a certain parts of your public offer as well. It also has the other issues like rights issue, private placement, preferential issues, and things like that. Okay, section 23, the first things first. What does section 23 say? Section 23 says, what are the different ways of raising money by a company? It depends upon what type of company you are. If you are a public company, then you can raise money, people, in many ways. One of it is by a public offer, correct? You can do a public offer. Next one, you can do a private placement, rights issue, bonus issue. If you are a private company, the first one will not come. Now, these three will come in the case of private company. Okay, now remember there is one more new section added, that is section 23 subsection 3, which is not that much in detail, but it just says what? If at all any Indian company wants to go and list its securities directly in the foreign jurisdiction, it can do it now. The central government will prescribe which security you can issue. Is it equity, preference, or which security? Central government will prescribe the rules. Next one, which foreign jurisdiction? Can it be anything? Can you go and list it in Pakistan? Yeah, they only need, okay. Next one, can you go and list it in any stock exchange? So which foreign jurisdiction, which stock exchange, which security, everything will be prescribed by central government. Now that is what is section 23 subsection 3. That's the new section, but I wouldn't say like an amendment, but it's been a while that they have added it. Prospectus we have seen, shelf prospectus, red herring prospectus, and all of that. Punishment for fraud, important. If there is a place where you guys have to remember the punishment, it will be this 447. Try to remember and go. What do they say? Section 447 is nothing but if someone does anything intentionally, then you will be liable under section 447. How much will be the penalty? The penalty will be, it depends upon what is the amount of fraud you have done. Imagine if the amount involved in fraud is more than 10 lakhs or 1% of the turnover of the company, whichever is less. So imagine the amount of fraud you have done is around, say for example, 30 lakhs. Now try to see 10 lakhs or 1% of the turnover of the company. Let us imagine the turnover of the company is 1 crore. Yeah, how much is 1% of 1 crore is 1 lakh. 10 lakh or 1 lakh, whichever is less. Which is less? 1 lakh is less. So if the amount involved in the fraud is more than 1 lakh, it is definitely more than 1 lakh in our case. Then you will be liable for how much? Punishable with imprisonment. Minimum shall be 6 months. Maximum it can go up to 10 years. And you will also be liable for a fine. How much? Minimum amount involved in the fraud. In our case, it is 30 lakh or 3 times of the amount of fraud, that is 90 lakh. That will be the penalty. And remember, you have caused this thing, no? That is, you have made this fraud, right? Whom did you cheat? Is it your directors? Is it your members? Whom did you cheat? Sir, we cheated public. If public is cheated people, imagine you have issued prospectus. In the prospectus, you have given all fraudulent information. In that case, people, the minimum imprisonment will be at least 3 years. Remember that and go. Sir, what if the amount involved in fraud, here it is more than. What if it is coming for less than? Sir, if it is 10 lakh or 1%, whichever is less. If the amount involved in the fraud is coming for less than that, then people, the punishment will be imprisonment may go up to 5 years. See, this becomes or. Yeah, fine up to 50 lakh rupees or it can be both. This is what is the penalty. 447, remember and go. So OFS we have seen, public offer of securities in DMAT form I told you, section 29. We can see it as 3 rules, rule 9, rule 9A, rule 9B. This is any listed company, any public company, any private company, except small company. Rule 9A, okay, 39 allotment, 40, we saw that. Okay, we'll do private placement. Okay, important ones, let us see it off. Okay, now how do we do a private placement? First of all, what do we mean by a private placement? Private placement is nothing but whenever we offer our securities to identified group of people. They are not some random person. They are identified individuals or persons. If we are giving the shares to the identified the group of people, we call it as private placement. They are not random. They are the known people. We call it as private placement. Sir, in a year, how many people I can do the private placement? You can do the private placement for 200 people in a year. You can do it for 200 person in a year. So this person 200, is it equity, preference, debentures, everything put together? No, everything is different. So you can do in a year equity shares you can issue to 200 people. You can, in addition to that, you can also issue 200 you can issue to the preference shares also to 200 people. Another 200 debentures also you can issue. Absolutely fine. So it is per security. However, in this 200, certain people are not included. Meaning it's okay. You can give it to how many ever people you want. One is employees. If you are giving it to employees, they do not come in the limit of 200. Next one is people, the qualified institutional buyers, they are not covered in the number of 200. Remember that. Okay. So the offer made to 200, QIB, ESOP, not. Sir, what if we are giving it to 210 people? It becomes people a public offer. What if it becomes a public offer? then it is no longer a private placement. Because it is public offer, you need to mandatorily issue something called as prospectus. Remember. Okay, sir, it shall be subscribed by. What is that? Check. You have to give it by check or demand draft or banking channel, and it cannot be by cash. Remember that. So it has to be for money. Money is coming in. That is the important thing. It should not be physical currency. It should be through a banking channel. In case of joint shareholders, the persons appearing first shall pay for the subscription. Whoever is the person named first, they will only get all the rights, as well as money also should be paid by them. Okay. This provisions shall not apply to NBFCs who are registered with RBI and housing finance companies who are registered with National Housing Bank. You need to pass a special resolution for you to do a private placement. And remember, this special resolution, if at all you are issuing the shares to the qualified institutional buyers, the special resolution will be valid for a period of 1 year. Hello. Okay. Next one, sir. The private placement offer letter. The format of the private placement offer letter is Form PAS4. Remember, whenever you do a public offer, you will always give them prospectus, right? In the case of private placement, how will the people know the terms of the issue, the price, all of that? How will they know? They will know it, people. You will give them something called as PPOL, private placement offer letter. The format of this is people PAS4. Okay, it has to be serially numbered. It has to be addressed specifically to that investor. This is what I told you. You cannot give it to a random person. Now, for example, I'll take a name. If I'm specifically giving it to a person called as, say, Harsha. So it has to be written in the name of Harsha. The offer letter has to be addressed to him. You can't leave the name blank. Clear? Okay. It should be sent within 30 days of recording the names. So first, what will the company do? The company will open one book. In that book, they will first write down to whom and all we are giving this offer to. Harsha, say for example, Pradeep. Yeah, we'll write down their names. Once you write down the names in the register, you will have to issue the offer letter to them within 30 days. And this register is called as people PAS5. The entire record of your private placement will be in the format PAS5. Now what will happen? If Harsha is interested, Harsha will apply for the shares. Once he gives us money, within 60 days, we need to allot him that particular share. Within 60 days. Sir, what if we are not able to allot within 60 days? You need to refund the money within 15 days. As we saw in our previous topic just now. So within 15 days. But in the case of public offer, it was 30 plus 15. Here it is 60 plus 15. Sir, what if I'm not refunding even within 15 days? Then people, I need to pay a simple rate of interest from the 60th day. Remember that. Okay. Remember, sir, what if even in the 15 days if I don't refund? If you guys remember our next chapter, that is nothing but this will become, it will be treated as deposits. Agreed? Okay. Next one, return of allotment. Once you are allotting the shares to Harsha, Pradeep and all of that, now registrar should know you will file a return of allotment to the registrar in the form PAS3. It will have the details of how many shares were allotted, who are the allottees. We need to tell no, Pradeep, Harsha, all their names. That entire details has to be filed with the ROC. It will be filed within 15 days of allotment. And this is very important. Remember, at any given point of time, at the same time, two private placement offers cannot run simultaneously. You have to first start one. You have to complete the allotment. You have to file form PAS3 to the registrar. Once it is complete, people, then only you can initiate another private placement. At the same time, two private placements cannot run. Clear? And until the return of allotment is filed, you cannot even utilize the money. Remember, they can test you in these two cases. They can ask you some questions and all. So until the money is collected, they cannot utilize that particular money. Is this clear, all of you? Yes. Yes. So 60 days, 70 days, 7 days, 15 days, PAS3. This is what we just saw. Hello. Okay. Can we issue the shares at a premium? Is it possible? Section 52 says you can issue shares at a premium. That is only called as securities premium account. Now what can I use this money for, sir? You can use this money for 5 purposes. What is the 5 purpose? The first one is, people, for issuing the fully paid bonus share. You can utilize the securities premium account to issue it back to the shareholders only as bonus share. Next one, writing of the balance of the preliminary expenses of the company. This is nothing but, people, pre-incorporation expenses. Whatever money you guys have spent before the incorporation, for that you can set off using the securities premium account. The third one, sir, writing of the commission paid. Imagine underwriting commission. We saw, right, in the previous part. You can pay up to 5%, 2.5%. That from where can you take? You can take it from the securities premium account, or discount allowed, or the expenses incurred on issue of shares or debentures. So whatever the expenses are, you need to appoint so many people, right? So all the expenses you can pay from securities premium account. Next one, for providing for the premium payable on redemption of any redeemable preference share. I told you when we were doing that preference share concept itself, you can redeem the preference shares at a premium price, and you can take that money from your securities premium account, and for the purchase of buyback technically. So for these 5 purposes, you can utilize your securities premium account. Okay. Sir, section 54, can we issue shares at a discount? Is it possible? Remember, people, generally you cannot issue shares at a discount. If the company's face value of share is 10 rupees, you cannot issue the shares at 8 rupees. Remember, you can issue shares at a discount on a market value, not on the face value. This is not possible. However, in 2 scenarios, it is still possible. Scenario number 1, whenever a company is issuing sweat equity shares. Scenario 2, whenever as a part of debt reconstruction, meaning we had taken loan from someone and we were not able to repay that loan, we can give them an option to convert the loan into equity. That is possible. Only these 2 scenarios you can issue the shares at a discounted price, and in no other scenario. This is clear? All of you? Done. Allotment, we saw. PS3, we saw. Private placement. Okay, section 62, further issue of share capital. Important. Section 62. Under section 62, you can further raise money in 4 ways. What is that, sir? The first one is called as, people, rights issue. What is rights issue? Whenever you are issuing shares to your existing shareholders. This only will come again in the next chapter, people, called as preemptive right. I am explaining that here only. What do I mean by preemptive right? Preemptive right means, people, before, see, as a shareholder, I have one right. What is that right? Before the company asks the money from any other person, I have a right to first be asked. About what? About investing more money in the company in return of some equity shares. So before you go and ask an outsider that, do you want shares of my company? It is the company's duty to first ask its existing members. Now that right only is called as preemptive. Before you consult or before you ask an outsider, you have to first ask me. That only is called as preemptive right. Hello? Yes. Okay. Now, sir, imagine we have so many shareholders. That is, we have around 100 shareholders. We give everyone an option. You cannot give it selectively. You cannot give it only to 50 people. You have to give it to all 100 people. Now, if they are interested, they will say, I want 50 shares, 100 shares, as the case may be. Sir, what if I am not interested? then people, you have a right, you can give your option to someone else if you are not interested. Now this option is only called as people right to renounce. It's also called as renunciation. What do I mean by renunciation? Renunciation is nothing but I will give my right of applying shares to someone else. Remember that other person need not be a shareholder. He can be an absolute outsider as well. Sir, by default, do we have a right to renunciation, people? Yes, by default, you have a right to renunciation. However, a company can restrict this right. That is, they can tell you cannot give this right to any outsider. They can restrict it. How? They can say in our company, there is no right to renunciation. They can mention it in the articles of association. If it is given in the articles, remember, then you will not have right to renounce. And remember, sir, what if I get the offer letter today? When will the rights issue start? Remember, if you get the offer letter today, it should start only after 3 days. So from the date of receiving the letter and from the date of opening of the offer, there should be at least 3 days gap. Sir, the offer letter should be open for minimum how many days? The offer letter should be open for a minimum of 7 days. Maximum, sir, it will be open for 30 days. Hello, clear? Sir, however, if at all I am a private company, then I do not want to follow this 7 days and all. Can I just keep my offer letter open for say 2 days? Is it possible? The law says, if at all in case of a private company, if 90% of the members of the private company, if you give your consent, people, then you can follow a period lesser than that specified in the act. That means what? If we have 100 members, if 90 members gives us consent to follow a shorter, offer periods and all of that, then you can follow even 1 day as your offer period, provided 90% of your members have to agree. People, remember, very important, it is not in value, it is in number. So if there are 100 shareholders, if 90 of them agree, if that 90 are holding just 5%, that is still okay. But if 90% of the members in number, if they are agreeing, not in value, you can follow a lesser period. Clear? Okay. The next one, sir, is ESOP. What is ESOP, people? An option given for the existing, an option given for your employees of the company, for whosoever you want to retain them, they give an option to subscribe more shares of the company. So what will happen if there is one employee who has been really working hard? We will say, we will give you an option to buy some shares of the company so that you can stay with us, you can grow with us. So that is only called as what, people? ESOP. Now generally what happens in ESOP, in 2026, we identify the employees who are entitled to get these shares. We are identifying in 2026. We do not give them the shares in 2026 only. From the day we identify them, they will have to wait at least for a period of 1 year. So if we are identifying them on 1st Jan 2026, they will wait that entire year, and in 1st Jan 2027, they will get a right to buy the shares on that day. They will have to at least wait for a period of 1 year. Now this is only called as, people, the day when we are giving them an option, this is only called as, when we are identifying them, that is only called as grant of option. When they have to wait for a period of 1 year, we call this 1 year as a vesting period, meaning a waiting period. The day when they have a right to say yes or a no, this is only called as exercise of an option. You have a free choice to say either yes or a no. And remember, until you say yes or a no, you do not enjoy any rights of the shares. That is, you cannot vote, you do not get a right to dividend. No notice will be sent. You cannot participate in the meeting. You don't have any right. You cannot transfer this right to anyone else. No right to renunciation and ESOP. All of that cannot happen. Hello? Is that clear? Yeah, but you can still enjoy. It is possible. You can enjoy the right to exercise only in 2 scenarios. So you need not wait for 1 year, it seems. Whenever people, let us imagine on 1st July 2026, an employee who was given an option, that particular employee passed away. So his legal heirs will get a right to buy those shares immediately. They need not have to wait for that entire year. The second scenario is people, whenever a person becomes disabled, permanently disabled. What do I mean by that? Imagine there is an employee who meets with an accident. In such case, he becomes permanently disabled. Let us imagine he lost his arm. He becomes permanently disabled. In such case, people, he gets a right to buy the shares on the same day. He need not have to wait for the entire 1 year. And this option is called as people ESOP. Remember, we maintain all the details of ESOP in the form SH6. The register of ESOP is called SH6. Is this clear, all of you? Okay. The third one is called as preferential issue. What do I mean by preferential issue? Sir, preferential issue is nothing but people, when you're giving shares to the identified people, we call it as preferential issue. And one more thing in ESOP, employee definition is important, no and go. They can ask you a standalone question in the employee part only. Yeah, for whom and all you are eligible. This is very, very important, no and go. So you can give your shares to permanent employee, whether he is working in India or outside India, you can give it to them. Not only that, you can also give it to your directors, whether you're a whole-time director or not. That means what? You can even give it to your non-executive directors. That is possible. Part-time directors, you can give it. However, you cannot give your ESOPs to the independent director. Remember, sweat equity you can give. That's the difference. Remember that. Okay. Next one. An employee as defined in A or B, that is our permanent employee or a director of a subsidiary company in India or outside India, or a holding company of the company. This is very important. Remember, what is that? There is a company A, you can give your shares to the employee of your holding company. That is, imagine if there is a company called B, you can give the shares to company B. This is possible. Yes? Wait, where did that go? Okay. Next one, you can also give your shares to the subsidiary company of your company. The employees of your subsidiary company, even for them also you can give the shares of company A. They will test you here. Remember, important. Yes, you can give. Associate company and all is not there. You can give it to the company, subsidiary, holding. Possible. Hello? However, you cannot give it to the following people. Who? You cannot give it to the employees if they are promoters or related to the promoter group. For example, Mukesh Ambani is a promoter. If you are related to the promoter group, or if you are only the promoter, Mukesh Ambani will not come in the definition of employee. His relatives do not come in the definition of employee. Next one. A director who either himself or through his relative or through any body corporate directly or indirectly holds more than 10% is okay. More than 10%. I am talking about 10.1. 10% of the outstanding equity shares of the company. Mukesh Ambani holds, let us imagine, 27%. He is holding more than 10%. So you will not be entitled to participate in ESOP. Note, if you are a startup company, then this promoter and this director holding more than 10%, this condition will not apply for a period of 10 years from the date of incorporation. Very important, no and go. Okay, the third one, people, is called as preferential issue. What do I mean by preferential issue? Preferential issue is nothing but you allotting the shares or you issuing the shares to the identified group of people is called as preferential issue. Sir, don't you think that is what is private placement? Yes, similar only. But there are some differences between private placement and preferential issue. I will tell you the main ones. What is that? The first one is people, private placement can be made only and only, or I'll tell it to you this way. If you want to issue shares to any identified group of people, now which security you are issuing? Sir, let us imagine I am issuing equity share. Then you need to follow section 42 and you will follow section 62(1)(c), that is private placement and preferential offer. Sir, I am doing a private placement of debenture. What type of debenture? Convertible debenture or non-convertible? Sir, I am doing non-convertible debenture. Then people, you will follow only 42. You will not follow 62(1)(c). Why? Because preferential offer will get triggered only and only when you are issuing anything related to equity or any instrument which gets converted to equity. If there is no equity at all, then people, section 62(1)(c), that is preferential offer, will not apply at all. The very, very important fundamental difference. That's the point number one. Point number two. You can do private placement. Now imagine people, there is okay, let us imagine this way. Now, there is a company, they have set up their company, their operations in one of the building. They have taken it on rent. Now, we need to pay rent. Now, let us imagine people, instead of rent, we decided to issue them, say for example, equity shares. We will not give them rent, we will give them shares instead. Now, whether is he paying anything for us? Answer is no. Now, we call such things as people non-cash consideration. Let us imagine if someone has worked very hard for us. Say for example, someone has given us a design. So, someone has given us a trademark. We need to pay him fees. Instead of fees, we are giving him shares. Now, such things are called as what? Non-cash consideration. Private placement will not come in the case of non-cash consideration. You will follow preferential issue. Because for private placement, remember DD or any banking channel, you cannot do anything other than cash. 62(1)(c) will apply. Hello. These two are the very important details. And of course, there are other details also. Here there is a format. PS3, PS4, PS5. Here only PS3. There is no offer letter. All of that will not come. This is very stringent. It is not stringent. So like that, there are various differences. You have to complete your preferential offer within 1 year. But you have to complete your private placement within 60 days. This can be done within 1 year. So these are the differences. Remember and go, very, very important. Rest of it, yes, is the same. But the main differences are these. Yeah. Securities, private placement includes. Here, offer letter. Here, nothing. Mode, through any banking channel. Here, either for cash or this is 60 days, this is 12 months. Bank account, separate bank account is required. Here, no such a requirement. This is very, very important. Remember and go. Clear? Okay. After this, let us go to, I don't think we did sweat equity, right? Okay, we'll do of sweat equity shares. Now, what do I mean by sweat equity shares, sir? Okay, whenever we are giving our shares to the employees. Now, what is the difference between the words ESOP and sweat equity? ESOP is, remember people, the employee has not contributed anything, but the employee has been with the company for a really long time. It can be say 5 years or say 10 years, as the case may be. What does the company decides to do? The company decides to make him part of their growth. So whenever the value of the company increases, the value of the shares given to him also increase. His life is also taken care. Now, what do I mean by the word sweat equity? Sweat equity, people, is basically where the employee has earned his shares. In ESOP, you need to give money to get your shares. In sweat equity, there will be no money involved at all. That is, you would have given something. Say, for example, I have worked really hard towards some project, or have given you some intellectual property right, or a value addition, or a know-how, have given you something. So in return, the company decides to give you equity shares. So you have either given your blood, sweat, you have worked really hard, or you have given some asset, or if you have given some, imagine a value addition or a know-how. In such case, what can a company do? Imagine, I told you, a person has given us a patent. Imagine now a person gives us a textbook using which the company will make money. That's a copyright. Now, because the person has given us a copyright, the company decides to give him in return something called as shares. So he is giving us an asset, we are giving him a share. Now, this is only called as people sweat equity. What is the beauty of sweat equity? He need not even pay 1 rupee in cash. That is absolutely fine. If you want, you take cash, or you need not even get 1 rupee from him. That is only called as what people sweat equity. Is this clear? So it can be given for cash or consideration other than cash. Hello? Okay. So how much sweat equity we can issue, sir? Maximum one time, that is in a year, people. I cannot issue more than 15% of paid up capital in a year, or issue value of rupees 5 crore in a year. So value of 5 crore or 15% of my total paid up equity capital, whichever is higher. So sir, every year can I keep giving 15? No, people. Everything put together, the maximum sweat equity you can issue cannot exceed 25% of your paid up equity capital. However, if you are a startup, then you can give it up to 50% of your paid up capital. Open your eyes here. You can give it up to 50% up to a period of 10 years from the date of incorporation. Is this clear? Hello? Okay. The sweat equity will be locked in for a period of 3 years. This is mandatory. A company cannot prescribe a higher period. It shall be 3 years only. Sir, the price of issue is determined by the registered valuer. The treatment for non-cash consideration, that is, how are you giving sweat equity shares? What did he give? Sir, what if he has given us a copyright? Okay, then we will show the copyright in our balance sheet. Sir, what if he has just worked hard? He has not given us anything else. He has just given his sweat. Where will I show the sweat? I can show it as people a employee expense in my P&L account. I will treat it as my employee expense. He has not given us anything. It's okay. We will treat it as an employee expenditure. Very, very important. Remember, if it takes form part of a depreciable or amortizable asset. Depreciable means people tangible asset. Amortizable means intangible. We will carry it to balance sheet. If it is not forming a part of depreciable or amortizable asset, then people we will expense it. And remember, the entire details of sweat equity you will maintain in the form SH3. Done now? That is my sweat equity. Okay. Because these were all connected, I thought of doing it simultaneously. Buyback and all we'll do as a part of part D. Okay. In part C, is there anything else that is important that we haven't covered? Okay, the last one is section 62(4). What is this, sir? Remember, people, whenever a company wants to issue any convertible debt, it can be convertible debenture, convertible loan, which in the later point, if it wants to get converted to equity, then the company cannot take such loan or cannot issue such debentures without first taking the shareholders' approval. You need to pass a special resolution. What resolution we will see? There is a section called 181C. You will be seeing it in the chapter 6. We will be doing it. That time I will tell you. Okay. So if you want to first issue a convertible debt or convertible loan, which is later point of time getting converted to equity, then you have to mandatorily pass a special resolution. However, let us imagine there is a company called Company X. Company X has taken loan from a government. Now, government people, in the public interest, even though the company has not passed a special resolution, at the public interest people, the government can convert the loan. Let us imagine there is a Company X which has taken loan from government. Now, the government people, in the public interest, they can decide to convert this loan into equity at its option. If the company is not okay with it, the company can always go and appeal it with the tribunal. Sir, the government is doing unfair things. Can you please help us? The company can go and appeal it with the tribunal. Whatever is the tribunal's order, that will be final. So whether the company has passed the resolution or not while taking loan from the government, that will not have any significance. Is this clear? Yes? Okay, done. I hope you guys are able to understand. I'm trying to go as detailed as possible. I think it will be a good lengthy video only. Private placement. Okay, let's start with part D. Yes, people. So let us do the part D. That is, one second. So sorry. Okay. Now the next one is, people, your alteration, buyback, and reduction. Mainly these three things. So let us do the first part, that is alteration. Now, what is the alteration of share capital? Whenever any of the 5 things happen, what are the 5 things? First one, if your increase in authorized capital happens, if my authorized capital is currently 10 lakh, if you are increasing it to 15 lakh, you will follow section 61. Next one, consolidation and divide into larger denomination. What do I mean by that? Now, take for example, we had 10 shares of 10 rupees each. Face value is 100. Now, what do? We make this 10 as 5 shares and we increase the face value to 20. The face value will change, but not the overall value. That will still remain the same. This is only called as consolidation and division into larger denomination. What if you bring it down to smaller denomination? That is only called as share split. That is, we had 10 shares of 10 rupees each. Now what do? We bring it down to 20 shares of 5 rupees each. This is still same. This is called as share split. And the fourth one is called as conversion of stock into shares, shares into stock. As I told you, I've explained you also in the class, but for this part it is not relevant. So I'm just skipping that part. Do not go there, because in India we do not have an instance of a stock getting converted to a share and share getting converted to a stock. So leave it. The fifth one is cancelling those shares which are unsubscribed by the people. That is only called as cancellation. So if you are doing any of these 5 plus redemption of preference share, if you are doing these 6 things, you have to intimate the registrar within 30 days in the form SH7. Is this clear? Hello. Pakka. Done. Okay, done. That is okay. That's your alteration. The next part is, people, buyback of shares. When I'm doing the buyback, people, I need to keep section 68 in mind. What does section 68 say? What are the sources of doing a buyback? It has to be done. Sources are always important. Remember, It can be done using your free reserves, securities, premium account, proceeds of fresh issue. That means I can issue my equity and I can buy back my preference possible. Next one, after my buyback is done, my debt is to equity should not be more than 2:1. If my loan is 2 lakh, my equity should not be less than 1 lakh. Imagine if my loan becomes 3 lakh, if my equity and free reserves are just 1 lakh, it's a very bad company. Third one, all securities should be first fully paid up. Next one, no further buyback shall be made within the next 1 year. That means between two buybacks people, there should be a cool off of at least 1 year. Sir, today we have purchased equity shares. We have done a buyback. Can I again issue equity shares only in the next month? No, people. It becomes a speculation. That's why there should be at least a time gap of 6 months. If you have purchased it today, you cannot again issue the equity only in the next 6 months. However, there are exceptions. If at all, imagine you want to issue it as a bonus. That's an exception. You can do it. Imagine 5 years back you had issued convertible debentures. That conversion is coming now. You can do it. Imagine if there is sweat equity, you have to give it to your employees. They have performed really well. You can issue it within 6 months only possible. Register of buyback will be in the format SH10. Sweat equity is SH3. SH1 was share certificate, format of share certificate. SH2 was register of duplicate share certificate. SH3 was sweat equity. SH4 will come in the next part, that is your transfer. SH5 is the partly paid, again next part. SH6 is register of ESOP. SH7 is your alteration of capital, which you file it with ROC. And next one, that another important one is SH9, that is declaration of solvency. That is, when you are doing a buyback, you are using your free reserves and all, and you are doing a buyback. So you had money, you are using that to give it back to the shareholders, and you are buying back the shares. And within the next few days, imagine within the next 2 months, 3 months, the company is wound up because of insolvency. They are not able to pay the debt. Now, who is liable for this? The directors are liable. Then why did you first of all go for a buyback? You did not add money then. So the directors have to give something called as a declaration of solvency. That is, you don't worry, we have sufficient money. In the next 1 year, we will never become insolvent. For 1 year, I can't promise for the life. In the next 1 year, I will not become insolvent. It is given in the format SH9, given by the directors. In the next 1 year, we won't become insolvent. If we become insolvent, directors will be liable. As simple as that. Clear? Then, okay, done. Next one, sir. What is the maximum buyback we can do? It depends upon what resolution you pass. If at all you are passing a board resolution, then people, the maximum buyback we can do will not exceed 10% of my paid up equity share capital plus free reserves. If at all I am passing special resolution, then after passing special resolution, if I am buying back my equity shares, then it shall not exceed 25% of my paid up equity share capital. Sir, I am buying back any other security, or the total money I am allowed to invest in buyback shall not exceed more than 25% of paid up share capital plus free reserves. Remember this. Clear? Hello? Pakka? Okay. Declaration of solvency. Return of buyback. Once the entire buyback is done, you need to intimate ROC, right? How many shares you guys purchased back, you will intimate with ROC in the form SH11. Once the buyback is completed, you have to destroy all those shares within 7 days. That's your buyback. Done. And what is the last part left? It is capital reduction. Reduction of share capital. Remember people, 4 approvals are required if you guys have to reduce your capital. What do you mean by reduction? So today my paid up capital is 10 lakh. Now I want to make this 10 lakh as 7 lakh. It can be because of any reason, but I want to reduce. Generally it can happen in 2 scenarios people. Scenario 1. we have extra money. So we'll decide to reduce the capital. Because what will you do with extra money? The second one, people, we have incurred losses. That is, we started the business with 10 lakh, but we have lost around 3 lakh rupees in the business. Now the balance sheet looks very bad. You guys only know, no? In your exams, how does your balance sheet look? Left side you will get one number. Right side, pakka will not get LHS equals to RHS. What will you do? Something you will do. That and all you will do. And you will balance it. Correct? No. Remember, the balance sheet which does not tally does not please the creditors. Tomorrow if you go to a bank, you will not get loans. So what do the companies do? The companies will call its shareholders and say, people, this is a scenario. We have lost 3 lakhs. Is it okay even if we reduce our capital from 10 lakh to 7 lakh? Now the shareholders will ask, then what about our 3 lakh? It's gone. That's all. It's done and dusted. It will be removed from our balance sheet. Now what is this called? This is only called as reduction of capital. So how can you reduce the capital? You can reduce the capital in 3 ways. First way, we have say for example 1 lakh shares into 10 rupees each. Total 10 lakh. The shareholders have already paid 7 rupees. 3 rupees they have not yet paid. You can tell, Macha, we have extra money. Do one thing. Let us keep our face value as 7 rupees only. Let us reduce it. 3 rupees don't pay. This is the first way of reducing the capital. When the called up capital is just 7 and 3 rupees is still uncalled capital, you can tell don't pay that and you will reduce the capital to 7 rupees only. The first way. Second way, sir, 1 lakh into 10 rupees each, they have paid the entire 10 rupees. Now what we will do? We will return back the 3 lakhs. They have paid, what else we can do? We will return back the 3 lakh. This is the second way to reduce it. Third way, they have paid but we have lost it. You will reduce it and that is only called as compromise or negotiations. You don't have a choice. That is the third way and that is only called as reduction of capital. Is this clear all of you? Yes. And I told you there are 4 approvals you need to take. One is you need to take the shareholders approval. Of course, you need to pass special resolution. Okay. What is the second approval? The second approval, people, you need to take the approval of NCLT. Tribunal's approval is mandatory. And the next one is, people, what is that? Of course, board resolution is, of course. Without that, we cannot go to special. And the fourth one, sir, is, people, creditors approval. When you are reducing the capital, they should also be okay with it. If they are not okay with it, then people, no, you cannot do it. Sir, what if when we are preparing the list of creditors, what if we have excluded anyone's name? If you have left out anyone's name, people, then your capital reduction will be considered as ineffective. So whatever your previous capital was, that only will be considered as the actual capital. That is your capital reduction. Understood? So you can do it in 3 ways. You will apply with the tribunal. Tribunal will send your application to all the other departments like central government, registrars. If you are listed with SEBI, to everyone we will send. And we will tell them you have 3 months to give your representation. If you don't give your representation within 3 months, we assume it to be a no objection. Now, people, tribunal, after being satisfied that every creditor is repaid or consent is given, we will allow for a capital reduction. That is your 66. Hello. I hope this is clear. And one more thing, scenarios when the capital reduction is not considered as capital reduction. Important, remember. In the following cases, the diminution of share capital is not to be treated as reduction of share capital. Diminution means, people, it is decreasing, but it is not considered as reduction of capital. When you already know 2 scenarios, you already know which one. The first one is, people, buyback. Second one is, people, redemption of preference share. In both the cases, the share is going down only, no? The decreasing is happening, no? But still it is not considered as reduction of capital. See, what is that? The first one. First one is redeemable preference shares. Next one is buyback. Easiest. Okay. Third one. This also we have seen. What? Section 61E. What is that, sir? Cancellation of the shares which are not subscribed by the shareholders. Section 61. Cancellation. Yes, sir. And the fourth one, again a easy one. Whenever a shareholder has not paid the call money, what do? We are going to forfeit it. Even the forfeiture is also, the share will go down, but it is still not considered as reduction of capital. The last one, if at all there is any reduction of capital due to the order of tribunal or with the consent of the tribunal, section 230, compromise or arrangement, we will not consider it as reduction. Clear? Next one, reduction of share capital without the sanction of tribunal. Now we saw, to reduce the capital, you need to take board, special, tribunal and creditors approval. In this case, all that is not required at all, it seems. When is that people? The first one is called as people in the case of forfeiture. When he does not pay the call money, we will forfeit. That's all. As simple as that. This one is called, generally doesn't happen at all, people. It's called surrender. What is surrender? Surrender is nothing but, people, it's like Gautam Buddha. What did Gautam Buddha do? Whatever his assets were, he just went and surrendered everything and he just left everything. That is called surrender. You do not transfer, you do not give it to anyone. You just go and give it back to the company itself. He will say, I don't want anything. You will not even take money in return. You will transfer it to the company only. And that is only called as surrender. Generally, rarely, it never happens, but yes. Yes, huh? Okay. The last part, sir, that is part E. Okay. So let us do of part E. Now, what is part E, sir? In part E, section 56 is important. Now, what is 56, sir? It talks about, people, transfer and transmission. First of all, what is transfer? What is transmission? Transfer happens, people. Transfer is a voluntary act. Transmission is, people, happens due to operation of law. Imagine a person becomes insolvent. A person dies. Automatically the legal heirs will get the shares. You are not transferring. You are not signing any document. But the person automatically becomes the owner of it. Now we call that as, people, what, people? We call it as transmission. In transfer, because it is a voluntary act, you guys need to sign SH4. Transmission, no such thing is required. SH4, you need to pay stamp duty, nothing. So these are certain differences. Remember, of course, here it is for consideration, or it may not be also, but here there is no consideration involved, as the case may be. Okay. Now we'll see the procedure of transfer. How do we transfer the shares, sir? First, the transferor transfers the shares to transferee. Using which form? We use a form called as SH4. Once you have signed the agreement, within 60 days, you need to go and submit it to the company. Once you go and give it to the company, imagine we are transferring the shares of, say, for example, XYZ Private Limited. We are transferring the shares. Once you transfer, people, you need to intimate this to XYZ Private Limited. Now they will register the shares from A to B's name within 60 days. Clear? Sir, what if company B does not register the transfer? Then, people, section 58 will come. We will see that. Okay. So we need to submit the share certificate, letter of allotment, all of that. Now imagine, sir, what if this is a partly paid share? Face value is 10 rupees, but the paid up value is just 5 rupees. Another 5 rupees is yet to be paid. It is uncalled. In such case, what will happen? Remember, people, if it is an uncalled capital, then, then you are liable. Now transferor has transferred it to B. With the company, initially A has agreed to pay for it. Now what if B, once the transfer has happened, if a company asks for the rest of the money, now who is a shareholder? B is a shareholder. He will have to pay for it now. But who had initially agreed with us? A has agreed. So that's why remember, if it's a partly paid share, the company will check with B, do you know that it's a partly paid share? We will give you a notice, intimation. That intimation will be given in the form SH5. Excuse me. Yeah, it will be given in the form SH5. Now B has to respond to this within 2 weeks. If B does not respond, people, we will assume it to be a deemed approval. Is this clear? Hello? Pakka? Okay. Okay. Next one, sir. See, private company refused. We gave. They did not register the transfer. Then what should they do? Within 30 days of we giving the instrument, they have to what? The company shall give a notice to the transferor and transferee within 30 days of receipt of the notice. So we gave them the instrument. They have to reply to us within 30 days. Now imagine they replied. We are rejecting the. We don't want to transfer it. Then what will I do? Within 30 days of them giving me a reply, I will go and appeal it to the tribunal. Sir, you know, we gave a request, they rejected our request. Can you please help us? I will go within 30 days. Sir, what if they did not reply at all? If they don't reply at all, then from the day I gave them my instrument, within 60 days, I will directly go because they have 60 days, no? Sir, if they don't reply at all, then what will I do? Within 60 days of the delivery of instrument, people, I will directly go and appeal it to the tribunal. Yes. This is in the case of private company. In the case of public company, we need to consider this as 60 and 90 days. That's the only difference. Clear? Okay, that is your transfer transmission. Can we transfer the shares to a minor? The answer is yes, we can transfer, provided it should be signed by a guardian. And remember, people, it has to be a fully paid share. If it is a partly paid share, people, then in that case, the transferor only will continue to be liable. Can we transfer shares to partners? Remember, a partnership firm can never become a member. Not possible. Can we give it to a body corporate? Yes, possible. DMAT mode, it's okay. You can skip it here. Don't give much of the preference. If it's a forged transfer, will it give you a valid title? Answer is no. What is forged? Someone else signed A's signature. They transferred it to B. Will it give a valid title? Answer is no. It is never a valid transfer. You can always remember, a forged transfer will never give you a valid title. Remember that. What do I mean by transposition? Transposition means nothing but people. There are joint shareholders. Say for example, A and B. They want to change this order. They want B to come first and A to come second. They can make a request to the company, and this is only called as transposition. Changing the order. Why? Because by default, whosoever name is written first will always enjoy all the rights, like right to vote, dividend and all of that. And remember, at any given point of time, if they decide, hey, let us not have it as a joint, let us split, they can always write it to the company asking them to split the share in the proportion they are asking. They will issue two different certificates. You have a right as a shareholder to ask for this. Remember, they can ask you this. Okay. Relation between transfer and transferee, we'll see this also in dividends chapter, something called as abeyance. We'll see that. Right of transfer, effect of transfer. Okay, what is the checklist for a company secretary? Make sure that the form is properly filled. SH4, if it's partly paid share, then you will issue SH5. If it's a joint share, then all the shareholders have to sign, and all the other details are properly filled. So all of that you have to keep it in mind. Checklist for company secretary, just go through that. DMAT, it's okay, you can leave it because it all comes majorly in your CMSL. Here it will not be that important. Yes, so these are the main topics as such in this particular chapter. Try to see this and go. So after this, we'll start your next chapter, chapter 5. If you guys want, you can go for a break and come and we can resume it. Yes, people. So the next chapter, let us start with chapter 5, members and shareholders. Okay. So what is given in this particular chapter? The first one, what is the difference between members and shareholders? Are they one and the same? See, once your name is entered in the register of members, you become a member. Until your name is not yet entered in the register of members, but you already, let us imagine, if you have transferred shares, A has transferred his shares to B. Now B becomes a shareholder, but not a member yet because his name is not yet entered in the register of members. That's a point one. Point two, you would have seen some types of companies like company limited by share, company limited by guarantee. In company limited by guarantee, you can have two types of company. One is with share capital, without share capital. So in a company limited by guarantee, having no share capital, so you can never have a shareholder at all. Then what you will have is member. So in a company not having share capital, they will not have shareholders at all. They will have only members. That's the difference. So no and go. So how and all you can become a member? First one, you can become a member by subscribing your name to MOA. Next one, you can become a member by making an application for allotment. Imagine rights issue, private placement, as the case may be. Next one, you can become a member by transfer. That is, A transfers his shares to B. So B becomes a member. Next one, transmission. A dies, B becomes a member. The last one, by estoppel. Estoppel is, people, let us imagine the company by mistake, A has transferred the shares to B, but A's name only is still there. If your name is reflecting in the register of members, in the eyes of the world, you are still considered as a member only. This is only called as by estoppel. You cannot go back. You could have taken an action, but you did not take it. So for the world, you will be treated as a member only. The next one, who and all can become members, people? They have given who can become member. The first one, partnership, can they become a member? They cannot become a member. However, remember, people, in the case of a Section 8 company, a partnership firm can become a member. That's only the exception. Next one, LLP can become member. Section 8 company, yes. Foreigner subject to FEMA laws, yes. But remember, you also have to keep in mind, if you have land border sharing with India, then you need to take approval. Minor, directly no. Through a guardian, yes. Provided partly paid share, transferor only will be liable. HUF in the name of Karta, yes. Pawnee, who is a pawnee? Basically a pledger, pledgee. The person who has given you the loan is called as a pledgee. Can I take loan by giving my shares? Answer is yes. I can pledge my shares and I can take loan. If I don't repay, that day he will become a member. Until then, I will only be a member. So until there is no default, remember, the pledger only will become the member. Insolvent, a new company, he can never be a member. But what if I was already a member? Remember, you will continue to have all the non-monetary rights, meaning you will not have a right to transfer. You will not have a right to get dividend. Then all these rights will be given to whom? It will be given to a person called as receiver, who is appointed by the court or appointed by the creditor. He will have a right to, get the dividend or transfer the shares, and as the case may be. As long as the insolvent member's name is still entered in the register of members, the right to vote will still be with him only. Society, can it become? Answer is yes, they can become. Fictitious name? No. Basically, Benami? No. Trade union? Answer is yes, you can become. GDR, until converted, Global Depository Receipts. Until converted, people, you are not a member. Once converted, you can become a member. So, until converted, no. Can a subsidiary company be a shareholder in holding company? Answer is no. But there are three exceptions. One is as a trustee you can hold. Next one, you can hold it as a legal representative. Meaning A said, if I die after my death, please transfer all my shares to XYZ Private Limited. Who is XYZ Private Limited? XYZ Private Limited is a subsidiary company of ABC Private Limited. So A has some shares in ABC Private Limited. So he says after my death all the shares has to go to XYZ Private Limited. So this is allowed. Now it becomes the shareholder possible. Next one, I became a subsidiary. I'm holding shares even before I became a subsidiary company. In that case, I can continue to hold. But remember, when it comes to the right to vote, you can vote in this scenario, but you cannot vote in this scenario. You do not have a right to vote. Remember and go. The next one is called Register of Members. What is that? It is nothing but maintaining all the details of the shareholders. If it is equity shareholders details, you will maintain it in the form MGT1. Preference shares, MGT1 only. It is maintained permanently. It is preserved permanently. What about any other security holders? Let us imagine debentures. It is maintained in the format MGT2. It shall be preserved for a period of 8 years from the date of redemption. Whenever is the day you repay, from that day you maintain these registers for a period of 8 years. So where do we keep it? By default, you will keep it in the place where your registered office is. Sir, can I keep it in any other place? Yes. You can keep it within the same city, town or village. Imagine Infosys is there in Bangalore. It's in an area called as Electronic City. Now from that place I can keep it in any other place in Bangalore only. How? I just need to pass a special resolution. Sir, but from Bangalore can I take it and keep it in say for example Kerala? Is it possible? Yes, provided I need to pass a special resolution and more than 1/10 of the total shareholders in my company. Imagine out of 100, at least 11 shareholders should be from Kerala. Then yes, I can keep it in Kerala. Next one, index. What is index? Nothing but your first page of your book. In which page, which chapter is there. In the same way, in which page, which shareholders detail is there. Maintaining that is called as index. Remember, index is not required if the number of members in your company is less than 50. If you have 50 or more, you will have to maintain index. Remember, all the entries in the registers shall be authenticated by a CS or any other person authorized by the board. He has to make sure all entries are correct. When will you make all the entries? All the entries in the book will be made within 7 days of the resolution. Imagine if you are doing an allotment. From the date of resolution, 7 days you have to make an entry. Inspection of register, section 94. Who can inspect? All your members, debenture holders, creditors, they are free to come and inspect. They need not pay any money. Every day the books will be kept open at least for a period of 2 hours every day. Sir, what if there is any other person? Any other person, we can charge a fees not more than 50 rupees. We can charge. Our members, our debenture holders, we can give it free of cost. Sir, can they come and take a copy? Meaning, can they take extract? Can I make a note of it? Yes, anyone can come and make a note of it. Sir, can they ask for a printout? Yes, provided they will be charged for it. The price of which will not be more than 10 days. We will have to give the printout within 7 days from the date of request. So you will pay 10 rupees, not more than 10 rupees per page. Sir, foreign register, can we maintain a foreign register? It's absolutely optional. It is not mandatory. Whenever you open a foreign register, you always need to intimate ROC. Sir, in a foreign jurisdiction, we have maintained all the foreign security holders details we have maintained outside India. We have maintained it in, sir, in the in this place, in so and so place. You will maintain it in the format. Which format? You will maintain it in the principal registers format only. But whenever you open, you need to intimate it to ROC in the form MGT3 within 30 days of you opening and within 30 days of you closing as well. Remember, maintaining of foreign register is not mandatory. And remember, all the entries made in the foreign register should also be transferred to the principal register in India within 15 days. Remember and go. Next one, the closure of register. A company can always close its register. Why? To determine the dividend payment, notice of the meeting, all of this. We can always close the register for a period not more than 30 days at once and not more than 45 days in aggregate in a year. And whenever I am closing my register, I have to give a notice. If you are a listed company, I have to give a notice in a newspaper. I have to give it at least 7 days notice in an English and a vernacular newspaper. If you are an unlisted company, then this English newspaper, this newspaper advertisement is not required. Just a personal intimation 7 days prior to the closure is sufficient. Remember. Okay, next one is section 89. What is section 89? Beneficial interest. What is that? Let us imagine, sir, generally this happens in our homes and all. There will be father. The father will never hold any property, assets, land, car, anything. Gold will not be in the father's name. Father will always make sure to buy everything in the mother's name. But who is taking all the benefits? Who is the decision maker? The decision maker here is the father. But in whose name we have taken everything? We have taken in the name of the mother. Let us imagine we buy some shares. The father does not buy it in his name. He buys it in the mother's name. We call the mother as the registered owner, the father as the beneficial owner. Now this fact you need to intimate it to the company. In your company we have purchased the shares in the name of the mother, but the benefit comes to me. The father has to intimate as well as mother will also intimate. So the registered holder, the mother will intimate in the form MGT 4. The father will intimate in the form MGT 5. Within 30 days of them becoming registered owner or beneficial owner, we will intimate it to the company. The company will take all the information, they will verify, they will further pass it on to the registrar within 30 days in the form MGT 6. Clear? Failure to do this, always remember there is a penalty. This is only called as what people? Section 89, beneficial interest. Next one people, section 90. What is section 90? SBO. What is SBO? In short, I'll tell you. Whenever there is an individual, the individual who is controlling, let us imagine if I am having 55% of shares in a company called as company A. Company A has control in another company called as company B. Company B is having control in another company called company C. If company B is holding at least 10% of shares in company C or 10% of voting rights in company C or whatever dividend declared by company C. Imagine company C is declaring 1 lakh as dividend. In that 10,000 rupees goes to company B only. So out of the total distributable dividend, the 10% of dividend is going to company B. Or if company B has significant influence on company A, controlling power on company C, in all these cases, company C will have to report it to the registrar that, sir, in my company, there is a company who is having a very high interest. And that company's name is company B. The registrar says, I do not want company B's name. I want to know who is controlling company B. Sir, it is company A. I don't want the body corporates. I want the name of the individual who is controlling all of this. So we will finally report the name of the individual. This is only called as what people? SBO. That is what is this. First one is shares, voting, dividend and significant influence. How much? Everything is 10%. Hello, is this clear? So we disclose it in the form Ben 1. Correct? Now we will disclose everything to the company in Ben 1. What will the company do? The company will forward it to the ROC in Ben 2. And the company will also maintain all the details of that in the form Ben 3. Sir, what if the person does not disclose all of this on his own? Then the company C will file a notice to them in form Ben 4. You guys have to disclose, you don't have a choice. Now, whenever company C asks for it, it is a duty of company B, A and the individual to disclose the details. Sir, what if they don't disclose the details? If they don't disclose the details, people, within 60 days of the application, if you don't disclose the details, we will apply to the tribunal. The tribunal will give you 1 year time to disclose everything. If you do not give it within 1 year, people, the tribunal will tell, transfer all the shares of that individual to IEPF. So whatever shares we are holding here, that controlling in company C, that entire shares will be transferred to IEPF. Anyone who fails to follow any of this, you will have a penalty, fine for officers, and all the rights will also be seized. This is people section 90 SBO. Remember, important from exam point of view. Okay, and next members and shareholders, that's the main important points. Cessation of membership, just give me 1 second. Okay, when and all a member ceases to be a member, not so important, but yes. In transfer, forfeiture, when you sell your shares, death, insolvency, redemption, that is when company only repaying, cancellation of shares, purchased by another member or by company itself. This is nothing but people, you'll be seeing it, what do you say? I can say, imagine a tribunal passes an order. Based on that order, someone purchases it. So that is also one of the case. Winding up, the company is only wound up. Or imagine company A is a shareholder in company B. When will company A ceases to be a shareholder in company B? One, when company B winds up. Second one, when company A only winds up. In both the cases, correct? Yes, done. Expulsion of a member. Can we expel a member, people? Can we have it in articles of association? We have a right to remove a member. Remember, even if you have it in your articles of association, there has been a scenario where Supreme Court has clearly said the right of expulsion cannot be written in the articles of association. Even if you have it, it will be considered as ultra vires. Clear? So you cannot have a right to remove a member from your company. Not possible. Expulsion is not possible. Register of members, index, inspection, preservation, register and evidence. What is that? Anything that is written in the register is considered as a prima facie evidence. They are only considered as the shareholders. Section 95. If your name is written in the register of members, then you are only considered as a shareholder. Primarily, that's not a conclusive evidence. If someone can come and prove that, sir, in the register of members, it is not properly written, there has been a mistake. If someone can come and prove, then remember the evidence will win, not what is written in the register of members. Clear? Okay, preservation of register of members. Declaration, SBO. Okay, SBO will not apply in some scenarios. To which company SBO is exempted? Non-applicability of SBO when IEPF is the shareholder. So what happens? Imagine if you have not paid dividend, someone has not come and collected. We have transferred all the shares to IEPF. Now IEPF will come and tell, I am the shareholder in your company, not required, exempted. Next one, its holding reporting company has reported about it. What do I mean by that? There is company A, there is company B, there is company C, there is an individual. So what is happening? Company C has to report everything. No, let us imagine company B only has reported everything. So they're telling you for company C, all this is not required. However, you have to at least disclose this chain in Ben 2. Rest of it is not applicable to you. Next one, the central government, state government or any local authority is the shareholder. Now in the company, see who is the shareholder, central government or state government or local authority, like your, your municipality, your BDAs and things like that. Sir, next one, reporting company or body corporate is controlled by central government or by state government or partially by central government or state government. So one is shareholder or next one is control. If it is with CG, then not applicable. Next one, if at all the shareholder is a person who is registered with SEBI as REIT, InvIT, alternate investment fund, because you are registered with SEBI, you need not have to satisfy section 90, not required. Done. Okay, there are different types of rights for a shareholder under this. One is called as individual rights, one is called as collective rights. Individual rights, you have a right to vote, you have a right to receive the notice, you have a right to get dividend, you have a right to attend the meeting, you have a right to be informed, you have a right to elect your directors. All these are your rights only, right? You have a right to get your notice of general meeting. You have a right to inspect all the registers. It can be charges, it can be register of members. All these things, yes. Yep. Collective membership rights. We'll be seeing all of this in the further chapters. That's why I'm not going very much in detail. Preemptive rights, I explained it to you in the previous chapter only. Sir, variation of shareholder rights, important. What does this variation of shareholder rights say? Section 48. Now let us imagine if a company has issued preference shares with a 12% rate of interest with 5 years maturity. Now the company wants to make this 5 years into 8 years. Let us imagine. Would they agree or no? So they also want to increase the rate of interest from 12% to 14%. Now can they do it just like that? The answer is no. This is only called as variation of shareholder rights. How can they do? They have to call the preference shareholders for a meeting. They have to either pass a special resolution or 3/4 of the issued shares of preference shares. If at all, imagine if we have totally issued 10 lakh shares, in that 3/4, 7.5 lakh worth shares, now they have to give their approval for such variation. However, remember, if at all there is anyone who is not okay with it, if they are at least 10% in value, they can go and appeal it to the tribunal. Sir, we are not okay with it, sir. Then tribunal's order will be final. But remember, people, if we increase the rate of interest from 12 to 14%, then what is happening? Whatever is the dividend that is available for equity shareholders, that will reduce, no? So if alteration of one shareholders will have an impact on the other shareholder, you need to take an approval. 3/4 of the people have to approve. The equity shareholders also have to give their approval. If variation by one class affects the rights of any other class, the consent of 3/4 of such other class of shareholders shall also be obtained. You need to take their approval as well. Is this clear? Hello. And one more thing, sir, main thing, end of the day, remember, for this variation, two things are to be satisfied. What? You guys should have a right to vary the preference shares. That is from 5 to 10 years you want to make it, right? Or 5 to 8 years you want to make it, right? This right to variation should be given in your AOA or MOA. Sir, what if my AOA or MOA does not provide the right for variation? If it does not provide people, at least the offer letter or the prospectus or whatever you have issued while you were raising this preference share, in that you shouldn't have mentioned that we are not going to vary the preference shares. So see, in the absence of such provision in MOA, if such variation is not prohibited by the terms of issue of the shares, so whatever you have issued, in that you shouldn't have said, I will not vary it at any given point of time. If you have said, you cannot go back. Clear? That's important, remember. Next one. Voting rights of members will always be in proportion of your paid up capital. Remember, anything paid in advance, calls in advance, will not have voting rights. Calls in advance will also not get any dividend. You may get interest on it. That is allowed. Clear? That is something, remember. Nomination, always remember section 72 says any security holder, you have a right to nominate any person after your death who will be the next security holder. Can a minor be a nominee? Absolutely fine. But if you're nominating a minor, you also have to nominate who the next nominee will be, because minor cannot enter into a contract. What if a minor also dies? So you also have to intimate who the next shareholder will be if the minor also dies. And remember, at any given point of time, you can change also. Even the nominee can also withdraw their consent. Remember that. You will nominate in form SH13. You can vary it in SH14. Clear? Okay. The liability and all we have seen. What is shareholders democracy? Basically, this you will be seeing in our chapter called your compromise and arrangement. Technically, there are certain restrictions where the directors cannot do everything without asking the shareholders, especially these things. I would say just pause for a second and see this. These things, the shareholders are mandatorily to be consulted. So directors cannot decide it on their own. You have to mandatorily consult the shareholders and only then you can do it. So that is only called as shareholders democracy. So everything is done by them, for them, from them. Okay. Shareholders agreement is nothing but an agreement which is entered between the shareholders. Technically, like imagine if there is any investor, if the investor wants to come in. So what do? We first enter into something called as shareholders agreement. If you guys watch this, series in YouTube called as Shark Tank, where there is a person who has a business idea, you go and you pitch it in front of these judges. If anyone is interested, they will come and invest money with you, provided they come with a lot of conditions of their own. And that conditions can be many. For example, imagine out of 5 directors, that 3 directors will belong to me. The auditors will belong to me. So I come with my own conditions, and that is only called, we enter into an agreement. Whoever is an investor and the company, we enter into an agreement. That is only called as what people? Shareholders agreement. Sir, whenever there is a conflict between the shareholders agreement and the articles of association, which one will prevail? Always remember, articles of association will prevail, because it has been decided in one of the case law by Supreme Court, and that case law is VB Rangaraj versus VB Gopalakrishnan. In this case, it was decided whenever there is a conflict between articles and shareholders agreement, always and always articles of association will prevail. Remember that. This Foss versus Hab bottle and all, we'll see when we're doing compromise and arrangements. Casting out, what do I mean by casting out? Whenever there are equality of oaths, imagine we have 10 shareholders. If 5 shareholders said yes, if 5 shareholders said no, in such case, what do? Whoever is the chairman of the meeting, he will be given a second vote. So his first vote is done, he can vote again. So if he says yes, this will prevail. He will say no, that will prevail. That is only called as what people? A second vote, or also called as casting vote. It will come in the case of equality of votes. Yeah. People, there is a last one called as resolutions and shareholder agreements and all. This, I have done a video on that separately. Please watch it on how to draft resolutions and these agreements. You guys will get a fair idea on it, and that is little important. Please watch that. Yeah, and then you guys can continue. Clear? Okay. So let's start the next chapter. That is your chapter 5. Not that in depth, but yes, whatever the major sections, we have tried to cover it. Let's start the next chapter. Yes, people. Let's start the chapter number 6. Yep. So part A, chapter number 6 can be divided into 2 parts. The first one will be basically your debt. To be even more precise, your debentures. The second part will be your deposits. So if you actually see how the chapters are classified, the first chapter, that is your prospectus and allotment of securities, speaks completely about public offer. So if you want to raise money from the company's point of view, what and all are the different sources that are available? The first one is public offer. Next one is share capital and debentures. So in share capital, you would have seen sweat equity, ESOP, rights issue, private placement, preferential issue, bonus issue. All of that will come under your share capital and debentures. The next one will be your debentures part. That is the section which we are seeing now, section 71. The next one will be your people deposits. If you see, one common thing in all these chapters is that in all the chapters, you are raising money in one or the other way. It can be in the form of debt, it can be in the form of capital, as the case may be. Yep. Okay. So let us start the part A, that is debentures. Okay. So first of all, how do we raise the debentures? First of all, should we pass ordinary resolution? Should we pass board resolution, or should we pass a special resolution? How do we decide? First thing, people, who has a power to borrow? The directors itself has a power to borrow. You can just conduct a board of directors meeting and you can borrow loan. However, remember, if at all the total amount you guys want to borrow, the old plus whatever you want to borrow now. So the existing loan plus the new loan. In this, everything gets added. Secured loan, unsecured loan, debentures, deposits, add everything. If existing plus new, if at all it is going beyond your aggregate of paid up share capital plus free reserves plus securities premium, add everything. If at all it is going beyond this, your total debt, if it is going beyond this, then people, to borrow such loan, you have to mandatorily pass a special resolution. This is what is given in section 180 subsection 1 clause C. Here, okay. However, in this, temporary loans are not included. Temporary loans means I can say it as a short-term loan. That means the repayment does not exceed 6 months of maturity period. Such loans will not be excluded in this particular calculation. Okay. Ultra vires borrowing means what? If at all you are going beyond the powers of the company, then what will happen? It will be considered as void ab initio. This is nothing but, people, whatever you have seen it in we have seen it in our MOA, object clause. So if at all you are doing ultra vires borrowing, it is always void ab initio. It does not bind the company. What about ultra vires directors, intra vires the company? Remember, the directors will be liable. However, it can always be ratified by the company if needed. That is what is this. Again, I am not going in detail. That's the same thing whatever we discussed in the second unit. Second and third unit basically. See, if company ratifies, company does not ratify. In that case, what happens? Doctrine of alter ego. The directors will be liable. The types of borrowing, the first one is called as long-term borrowing. Long-term borrowing means the maturity period of 5 years or more. Short-term, 1 year or less. Mid-term, anywhere between 1 to 5 years. Secured, collateral. Unsecured, no collateral. Syndicated borrowing means what, people? Whenever you are borrowing from multiple financial institutions, that is called as syndicate. Syndicate is generally, people, in your push part 2, they will say, no, a syndicate. What is syndicate? Imagine if you guys, if there is a supplier who wants just 10 kgs of sandalwood. Sandalwood. Basically your sandal, the tree. So what do you say? You will call one supplier and ask, what if I want to buy 2000 tons of sandal? One person cannot supply that. So what do? They form a syndicate. So what do you mean by syndicate? Same thing, cut, copy, paste. Whenever you are borrowing loan, when one bank cannot fund you the entire loan, what do? The multiple banks come together and they fund the loan. That is called as syndicate. Opposite of syndicate is people, bilateral borrowing. Bilateral means only there are two parties. One is borrower, one is lender. Private borrowing is nothing but opposite to your public borrowing. It is between the financial institutions, private institutions. Next one is public borrowing. Nothing but like your debentures, going for a public offer of debentures. Debentures and bonds. What is the difference between debentures and bonds, people? Generally, remember, debentures are issued by companies, large corporations, as the case may be. Bonds are again issued by companies, large corporations, and also by government agencies. It can be government companies, government departments. Now they issue people something called as bonds, but debentures is issued by corporates always. This is very important. Remember, the debentures can be either secured or unsecured, but the bonds are always secured in nature. Because of that, because it is always secured, the risk is less here. So the interest is also less. Here the interest may be less or high, depending upon whether it is secured or unsecured. Debenture holder, bond holder. Collateral, as I told you, there is maybe or may not be, there is always a collateral. Tenure, it is generally short to medium. This is always long term. Bonds. Convertible, debentures can be issued with the option of convertibility, but bonds will not have conversion option at all. Rate of interest, as I told you. Kinds of debentures, non-convertible, partly convertible, fully, optionally. What do I mean by optionally convertible debentures? That means if you want, you can convert it into equity. If not, you can redeem it. Remember, the investor has an option to whether convert it or redeem it. That means if I think the conversion is beneficial for me, I will choose conversion. If not, if redemption is beneficial for me, I will choose redemption. Okay, redeemable, perpetual. Can you have a perpetual debentures? Answer is no. The maximum maturity of the secured debentures cannot exceed 10 years. Same thing, infrastructure companies can go up to 30 years. Okay, issue and redemption of debentures, redemption clause. Okay, whatever is the important part, let us pick up that only. Section 71. An issue of secured debentures. See, secured debentures can be issued with a maximum maturity which will not exceed 10 years from the date of issue. The maximum maturity of secured debentures cannot be more than 10 years. But see, the words used are secured debentures. What if it is unsecured debentures? Yeah, that is silent in the act. Following companies may issue secured debentures even for 30 years. Up to 30 years, it's okay. Who? Same thing. The companies who are into infrastructure projects like L&T. Next one is infrastructure finance companies. Meaning their main objective is to finance the infrastructure projects. Example is L&T Finance. They only finance your infrastructural projects. Infrastructure Debt Fund NBFC. For now, just imagine even that is a type of lending financial institution only. The fourth one, companies which are permitted by RBI, National Housing Bank or any other statutory authority to issue debentures for a period exceeding 10 years. So if IRDA allows you, PFRDA allows you, if any other authority is allowing you, you can go and issue debentures for more than 10 years. Yes. Okay. Next one. It has to be created. You need to create a security. Always remember. Now this is important. What is that, sir? Why is it important? Such an issue of debentures shall be secured by creation of charge on the properties of. This is very important. I can create a security on my company assets or my subsidiary company assets or my holding company assets or even my associate company assets. I can always create a security. They can definitely ask you such questions. Whenever the students say that the paper was difficult, they always go into this type of questions and ask. They will ask you, a company wants to take a loan and its holding company wants to give a collateral security. Is it possible? Is it allowed? Answer is yes. Hello? Okay. And One more thing, this is also important. Remember, the collateral security, to what amount should I take? Now imagine the loan amount is, say for example 70 lakh. The interest amount is say 30 lakh. Always remember, your collateral should always cover the interest as well as the loan part. They can always question you. Appointment of debenture trustee and execution of debenture trust deed. They can ask you a question. What is that? The company shall appoint a debenture trustee. When is debenture trustee appointment mandatory, people? When is it mandatory? Whenever you are doing a public offer of debentures, first one. Second one, if at all you are issuing debentures for more than 500 people, or if you are doing a public offer, in such case, appointment of debenture trustee is mandatory. Sir, when should I appoint? Always remember, you have to appoint the debenture trustee even before the issue of prospectus or letter of, excuse me. So, see, you need to appoint the debenture trustee when? They are telling you need to appoint the debenture trustee even before you issue the prospectus or letter of offer. But remember, you need not have to enter into the agreement immediately with them. You need to first appoint them. Agreement can happen even on a later date. Later means when, sir? After 5 years, Allah. Later date means, people, you need to do it within not later than 60 days after the allotment of debentures. So once a debenture allotment is done, within 60 days from the date of allotment, you need to enter into a trust deed. Clear? Okay. Sir, if at all the collateral security is given by central government or state government, then there is no need to create the charge and all. What is that? We will see in the next chapter. When debentures are issued by a company, the company shall create a debenture redemption reserve account. Now, what do I mean by DRR account, people? DRR account is nothing but, what is DRR account? You need to create DRR and DRF. Agreed? How much will you create your DRR? DRR is always created up to the extent of 10% of your total outstanding debentures. Is very important. What do I mean by that? At any given point of time, total outstanding debentures in your company, what is the amount? Let us take, for example, in 2022, we have issued debentures with the 5-year maturity. How much we have issued? Imagine we have raised 5 crore rupees. In 2023, we have raised another 3 crore. In 2024, we have raised another 2 crore. Now let us imagine, in the year 2027, we have to start repaying the debentures. How much I need to repay? Let us imagine, in the year 2027, we have promised to repay 2 crore worth of debentures. In 2027, now people, remember, we need to create DRR and DRF as the case may be. This is the applicability. So only the unlisted companies which are not covered under the above, they need to create DRR. How much will you create? You need to take the total outstanding debentures. My total outstanding debenture is how much? 10 crore. In that I need to create 10%, and that is how much, people? 1 crore worth of DRR I need to create. Hello? Are you guys getting the point? Okay. Next one is DRF. What is DRF? Whatever is the total debentures that is going to mature in the current year. In 2027, we are going to repay 2 crore. You need to, people, create DRF on this 2 crore. You need to take 15%. And how much will that come to? I think it is coming to around 30 lakhs. This 30 lakh, you are free to invest it in some places which is prescribed in the Act. You are free to go and invest in those places, like scheduled commercial banks, unencumbered government securities. In such cases, you can go and invest it there. Where and all? You can go and invest it in the scheduled banks, unencumbered securities of the government. Unencumbered security is mentioned in the Indian Trust Act. Unencumbered bonds issued by company under Indian Trust Act. You are free to invest that money anywhere here. The 30 lakhs I'm telling you, not this, what is that, 1 crore. 1 crore only, no, we got. And that 1 crore, 10% Allah. We are only talking about the 15% part. That you can invest. What do you mean by unencumbered? Unencumbered means people, imagine I've invested in the government securities. I've gone and given that as collateral and I've taken loan even on that also. Such things you cannot do. It should always be free from any of those claims. That's the meaning of unencumbered. Is this clear all of you? Yes. Sir, now when should I create this investment? We call it as DRF or DRI. Debenture Redemption Fund or Debenture Redemption Investment. Sir, by when should I do it? You need to do it. You are creating it for the year. Let us imagine 2027 and 2028. You need to create the DRF people by 30th of April 2027. You need to invest 30 lakhs in any of the funds which we just discussed. Now, this is an ongoing procedure. And remember, this DRR cannot be used for any purpose other than the redemption of debentures. How do I create DRR? Out of the profits available for the company to distribute dividend. Whatever is the money that is available, free money, that money will be utilized to transfer the money to DRR. Hello, done. Done. DRR. Sir, what if it's a convertible debentures? Then people, DRR is not mandatory. What if it is partly convertible? You will create DRR only on the non-convertible part. For the convertible part, there is no need of creating DRR. Okay, appointment of debenture trustee. Okay. Important, the disqualifications for becoming a debenture trustee. Who and all are disqualified? The first one, people, basically your shareholders are disqualified. Which shareholder? Registered holder or beneficial owner? If you go in details in between the lines, the word used are beneficial shareholder is disqualified. Yeah? Okay. Next one. Who else is disqualified? The promoter, the director, the KMP or any other officer or an employee of the company. See, basically everyone are disqualified, people. Yes, so promoter, director, KMP. Promoter, director, KMP, any other officer or an employee. Technically, everyone is covered. Yeah, employee of the company means everyone only, no? Okay. Of what and all? Of the company, holding, subsidiary, associate. We can just write it as cash. So, my company ka employees, my associate, my subsidiary, my holding company, everyone are disqualified to be appointed as a debenture trustee. Why? Because you will be biased. You will not work in the interest of the debenture holders. You will work for your own interest. Next one, a person who is beneficially entitled to money paid by the company otherwise than as remuneration. Now, people remember, whenever you are appointed as a debenture trustee, you are eligible to get remuneration. Company only will pay you. Now, apart from that, if you are getting any other money from the company, then people, you cannot be appointed as a debenture trustee. Why? You will be biased because you are getting money. Simple. Next one, a person who is indebted to the company or subsidiary, holding or associate. What does this indebted means, people? Nothing but I have taken loan from the company. I need to repay. In such case also I might be biased because I have taken loan, no? What if they force me to pay me immediately, or what if they take any action? What if they ask me higher rate of interest and all of that? So in such case, what will happen? In such case, they are telling you that a person, whoever is indebted, cannot become a debenture trustee. Next one, sir, I have not taken loan. My friend has taken loan. Can I become a debenture trustee? Remember, if your friend has taken loan, you can become a debenture trustee, provided you should have not given a guarantee to that contract. If your friend does not repay, you are agreeing to repay, then people, you cannot be a debenture trustee. Next one, a person who has any pecuniary means what, people? Monetary. So a person who has any monetary relationship, with the company amounting to 2% or more of its gross turnover or total income or 50 lakh or such higher amount as may be prescribed, whichever is lower. How much people? First take the company's turnover. Let us imagine the company's turnover is 100 crore. 2% of it is people, 2 crore. Or 2% of its gross turnover or 2% of its total income. Let us imagine its total income is say for example 1 crore. What is 2% of 1 crore? That is, let us imagine 2 lakh or 50 lakh rupees, whichever is less, which is lesser, 2 lakh. If any person has a pecuniary relationship, meaning monetary, you are doing a transaction with them, the value of the transaction, if it is 2 lakh rupees, they are telling you people, when is this 2 lakh? Whether in the last 2 years or even during the current year, such a person, whoever is having the contract with the company, that person cannot be appointed as a debenture trustee. Here, hello, okay. Next one, sir, any person who is a relative of promoter, director or KMP. Remember, relative of employee or officer is okay, but relative of promoter, director, KMP is disqualified. Clear? Remember, important exam point of view, they may ask you. Okay, next one from debenture trustee, which other point is important? This is important. A debenture trustee may appoint a nominee director. Who is a nominee director? Whenever we give loan to a company, we would want to know what is happening amongst the board. So we have a right to appoint a nominee director. Now the question is, when can we appoint a nominee director? These are the circumstances under which you can appoint a nominee director. When is that? Whenever a company makes 2 consecutive defaults in payment of interest. Next one, default in creation of security. You have said it is a secured debenture, but you did not create the security on it. Third one, default in redeeming the debentures. So non-payment of interest, non-creation of securities, non-payment of principal. In such case, the debenture trustee may appoint a, the debenture trustee may appoint a director who will be called as a nominee director on the board of the company. Is clear? Okay. This is important again. The debenture trustee may call for a meeting. When will a debenture trustee call for a meeting? Upon happening of any event which the debenture trustee thinks the company has done a breach of a contract which will affect the interest of the debenture holders. I think, example, the company has not paid interest on time. It is affecting the interest of the debenture holders. In such case, what can the debenture trustee do? He can call for a meeting. This is him calling on happening of any event. Next one is people. You guys only can request for it. Whenever the debenture holders of 1/10 in value, this is very important. 1/10 in value, this is very important. So, debenture holders holding 1/10 in value, if they request for a meeting, then the debenture trustee may conduct a meeting. Remember, important. Okay, next one, casual vacancy in the office of the debenture trustee. Meaning, let us imagine if at all we have appointed an individual as a debenture trustee, that person dies. Now, what will happen? The board of directors of a company will appoint the next debenture trustee. Sir, what if the debenture trustee did not die, but the debenture trustee resigned? Sir, if at all the debenture trustee is resigning people, then the board will appoint the next debenture trustee. However, it shall be appointed only after a consent is received by majority of the debenture holders. Only the directors cannot fill the vacancy. Where the vacancy is created by resignation, the vacancy shall only be filled with the written consent of majority. Very important, remember and go. Very, very important. Here the words used are machas. Here the words used are majority. Why? Because the next point is people, removal. Can we remove a debenture trustee? Is it possible? Yes, possible. But how? Remember, debenture holder holding 3/4 in value shall agree. If they agree, people, you can remove a debenture trustee. If they do not agree, people, you cannot remove a debenture trustee. It's clear. Debenture trustee we already saw. It shall be in the format SH12. This is important again. What does it say? In my debenture trust deed, you cannot have a clause in the debenture trust deed which will exempt the debenture trustee from any of his liabilities. What do I mean by that? Imagine, people, due to my negligence, the debenture trustee's negligence, the company did not create any charge, but the debenture trustees did not bother to inform anyone because of their negligence. Now, if you look at it, for this, debenture trustee should be punished. But let us imagine, what if the debenture trustee has entered a clause in the debenture trust deed saying that if any loss is suffered by debenture holders, whether it is because of my negligence or because of anything, if at all the debenture holders suffer any loss, for that loss, I will not be liable. I am always exempted for any of the actions that I take, and whatever is the result for it, I will never be liable. Even if such clause is written in the debenture trust deed, remember, that will not be binding. We can still hold the debenture trustees liable. We can recover the cost. Sir, we can never exempt them. Never. Sir, we can never. You can. When? Remember, the debenture holders, they can pass a special resolution. There is nothing but, if 3/4 of the debenture holders in value, if they agree, it's okay, hamara banda, our fellow only, let us leave him. If 3/4 in value agrees, then you can leave the person. Remember, people, for casual vacancy, it is majority. For removal, it is 3/4. For this also, it is 3/4. Remember. Yeah. In the previous paper, they have asked in 2025 and all. Remember and go. Yes, sir. So that is your debentures. That is your part A. Next, let us start with the part B. Yes, people. So, what is deposit? To know what is deposit, we need to know the definition. What is not a deposit? Okay, so whichever is more important, let us try to focus that. What is not a deposit? They can ask you a question here, important from exam point of view, 3 to 5 marks. They will ask you 4 to 5 scenarios and they will ask you which of it is a deposit, which of it is not a deposit. The first one is any amount received from the central or state government or from any other source whose repayment is guaranteed by central or state. Any amount received from local authority, statutory authority, it will not be considered as deposits. Basically, any money received from government is not a deposit. It can be Indian or even foreign as well. And any money received from foreign banks and Indian banks is not considered as deposit. Any money received from multilateral financial institutions not considered as deposit. Any loan or financial assistance received from public financial institutions like LIC, IDFC, they are not considered as deposit. Any amount received against issue of commercial paper or any other instruments issued in accordance with RBI guidelines. So if you are following RBI guidelines and if you are raising money, it is not considered as deposit. Any amount received by a company from any other company, it is popularly called as intercorporate loans or intercorporate deposits. It is not considered as deposit. Example, imagine Tata's receiving loan from Infosys. Yeah, okay. Amount received and held towards subscription to any securities. What is this? Imagine in private placement, I already told you when we were seeing today the private placement thing. Whatever is the money we have received as a share application money, you need to do the allotment within 60 days. If I do not do it, then within 15 days I need to do the refund. If I don't do it, it will be considered as deposit. Hello. Done. Done. Next one. Any amount, any adjustment to the amount for any other purpose shall not be treated as a refund. That means what? Imagine if you, instead of giving this money back to them, if you are adjusting towards, if they have taken any loan, you have adjusted towards that. All of these people will not be considered as refund. For you to consider it as a refund, you have to refund it only. You cannot adjust it for any other source. Next one, any amount received from a director of the company or the relative of a director of a private company. Very important, remember and go. If you are receiving, in the case of public company, if the money is given by a director, in the case of a private company, if the money is given by the director or relative of the director, if they are giving the funds, it is not considered as deposit, provided the money should be given from their own funds and it should not be borrowed and given. That's the only condition. So you need to give a declaration that whatever is the money we are giving, that is ours only. We have not borrowed it from anyone. And remember, the company has to disclose this in the board's report that it prepares in the end of the year. In that they have to disclose this. And remember, this condition does not apply only for the directors. It applies for everyone. Whoever is giving money in this chapter to the company in the form of deposits, everyone will have to give an undertaking that it is their own money and we have not borrowed it from anyone. Next one, amount raised by issue of secured debentures. Sir, is secured debenture, can it be considered as bonds or secured debentures? Should we treat it as deposit? Answer is no, provided you satisfy these conditions. What is that? First of all, it has to be secured by a first charge. What is this first and all? We'll see in the next chapter. Next one, such charge is created always on the assets referred in Schedule 3. What do I mean by that? Remember, sir, it should always be on tangible assets and it should not be on intangible assets. So you have to first create a charge on the assets given in Schedule 3. It should always be on tangible and not on intangible. Next one, it should be compulsorily convertible. Compulsorily convertible into shares of the company within 10 years, and you have to mandatorily convert into, we have seen in debentures part only, the maximum maturity should be 10 years. So within 10 years, secured debentures you have to convert. Next one, the amount of such bonds or debentures shall not exceed the market value of such assets. What do I mean by that? So it is secured. That means you have given some asset, right? What is the value of the asset? Value of the asset is 1 crore. Then what should be the value of the loan? The value of the loan should not exceed the value of the asset. So it should always be less than 1 crore only. If the value of the asset is 1 crore. Done. Okay, next one. Any amount raised by issue of non-convertible debenture, it should not constitute a charge. So if it is convertible, it should be secured. If it is non-convertible, it should not be secured, but it should be listed on the recognized stock exchange. That's the condition, remember. Secured, then it should be convertible. Non-secured, non-convertible, it should be listed on a stock exchange and no security. Okay, next one, amount received from an employee not exceeding his annual salary. So, for example, imagine if we are, there are some companies who provide a work from home option to its employees. They give all valuable assets and all, like laptops and all of that. What if the employee never returns? So, few companies as a policy, they have a policy of taking some money as deposit, like a caution deposit. They can take it provided, remember, it cannot exceed their annual salary. And why are you taking it? It's a caution deposit. So remember, it should not have any interest paid on it. It should be non-interest bearing. Simple. Okay. So any non-interest bearing amount received or held in trust. Meaning if we have received money not belonging to us, it belongs to someone else. We are just holding it on behalf of someone else. It is not considered as deposit. Any amount received in the course of or for the purpose of the business of the company. What is this? As a business, you will be taking so many different types of amounts, right? For example, one of it is people advance. Now, for example, if you guys take your telecom, I can recharge my SIM for 1 year in advance, right? I can recharge for the entire year. They're telling you any company can, raise money in advance. That is allowed. Any company can do it, provided you need to give the services or the goods within 365 days. Of course, if there is any litigation or any case going on, it's okay. It can go beyond 365 days also. If not, people, on a normal day, you need to give the services or those goods within 365 days. If not, whatever is the money you have received as advance will be treated as deposit. Next one. As such advance received in connection with a immovable property. This is nothing but what people, if at all you are buying any land, they will take people like secure, what is that? Not security deposit. What do you call that? What deposit do they call it? Advance. Booking charges, something like that they call it. So, imagine if the value of the property is say 1 crore, they might tell you, sir, please give 50,000 as advance. So I will not show the property to anyone else. Sir, is this considered as deposit? Answer is no, provided they need to deduct this when they are taking the rest of the money. So when I am coming to repay the 1 crore, that time you should reduce the 50,000 part. Next one. As security deposit for the performance of the contract. What is this? Security deposit. You guys will do it in many places, no? Whenever, imagine if you're taking a Yulu bike, bounce bike rentals, you will always give some caution, right? Some money as deposit. That is not treated as a deposit. Why? Because it will be given back to you. Next one. Any advance received under long-term projects or for supply of capital goods. That means people, nothing, imagine. If you are supplying any big plants, machineries and all of that, they will take some booking charges. They're telling you even that will also not be considered as deposit. Next one, any advance received for providing future services or warranty or maintenance contract if the period for providing such service does not exceed the period prevalent in the business practice or 5 years, whichever is less. Now, what do I mean by that? Imagine, sir, I take now I have taken one, water purifier. It's called as Native. This belongs to a company called as Urban Company. Yeah, if you guys are from Bangalore, Mumbai and all of that, you guys will know this Urban Company. Now, what do? Now, I need to pay. Now, what are the charges? For example, if you guys see only, you will know. Exactly, I'll give you an example. We'll see if it opens. People see here, what does it say? 2-year filter life. Now smarter, 2-year. People, can you see this? 2 years unconditional warranty. Meaning nothing, anything happens, people, they'll come and repair it. Anything that may happen. Now, why will they repair it for free of cost? If you think they are repairing it for free of cost, I am only using it. We will become idiots if we think that is true. How much they are collecting upfront? Yeah. Now they have reduced. I think when we took it, it was around 18,500 rupees. Now, why are they collecting 18,500 rupees upfront? Why are they doing it? Because people, now what happens? The cost of the purifier will be, say for example, say 14,000. The rest of the 4,500 rupees that they had collected was for this warranty charges only. Now this warranty charges they have collected, no. Now they are telling you, can such companies collect it? Will that warranty charges be considered as deposit? They are telling you it will not be treated as deposit provided the warranty period is how much? In our case is 2 years. That is what they are telling you. What if some other company is doing 3 years? Some other company is doing say 5 years. Some other okay, let us imagine most of the companies are doing 3 years. And finally there is one more company, let us imagine, called as AquaGuard. They are doing it for 7 years. Now they are taking the warranty charges for 7 years. Up to what extent it will not be treated as deposit? They are telling you whatever is the warranty period prevalent in that industry, everyone is following 3 years. That's the majority. Now it will be 3 years or 5 years, whichever is less. Up to that extent, it will not be treated as deposit. In our case, it is 2 years. It will not be treated as deposit. Now, for this person, AquaGuard, who is taking it for 7 years, remember, for the 2 years, it is not a deposit. After 2 years, it will be treated as a deposit. That is what is the scenario. That is what they are trying to tell you. I hope this is understandable. I hope it is clear. Yes? Because most of them will have difficulty in understanding that. Okay, next one. Any advance received and allowed by any sectoral regulator. If PFRDA allows you, TRAI allows you, you can do it. Any advance for subscription towards publication. Say for example, you give a newspaper, magazines, I pay upfront. That entire money will not be treated as deposit. But imagine at any given point of time, if they are not able to supply me the magazine or newspaper, it is their duty to refund me the money within 15 days. If they do not refund it within 15 days, it will be treated as deposit. Next one, any amount brought in by the promoters themselves or by their relatives of the company by way of unsecured loan in pursuance of a stipulation of any lending financial institutions. What is that? Sir, let us imagine it's like down payment people. We went to a bank asking for a loan. The bank said, I will give you loan. I will give you 85% provided the rest of the 15% you guys have to bring. Who? The promoters. Only then I will believe in that project. So to convince that people as a down payment, the 15% will be introduced by the promoters, or it can be even the relatives of the promoters. And provided it should be an unsecured loan. If that is if all of this is satisfied, people, they're telling you whatever is the money brought in by the promoters will be not considered as deposits. Any amount accepted by a Nidhi company, that's their business. Amount received by way of subscription, chit funds. Amount received by collective investment schemes, not important for us. It comes in CIS, it comes in CMSL. This is important. Convertible note. This instrument was specifically introduced for startup companies. Now, what is convertible note? It is nothing but it's a type of instrument where a company raises money. Which company? Only a startup raises a money from any person, provided the minimum amount they raise from one person shall be 25 lakh rupees. And this entire 25 lakh rupees should be given at once. You cannot give it in installments. It should be given in a single transaction. And remember, this particular this instrument either should be converted into equity or repaid within a maximum period of 10 years. If some company satisfies all of these conditions and if they raise money, such type of instruments are called as convertible notes. It is exempted. It will not be considered as deposit. Clear? So the conditions to be satisfied is it should be raised by a startup, compulsorily convertible or redeemable within 10 years, and single tranche 25 lakh from one person. Any amount further received from alternate investment funds, venture capital funds, mutual funds, because all of them are regulated by SEBI. So any money received from them will not be treated as deposit. That's all. Done. Next one is provision. Just 1 second. Yes. Okay, so now we saw people what is not considered as deposit. Now we need to just see two sections. One is section 73, one is section 76. 73 says you are not supposed to accept deposits from public. Then you are okay to accept deposits from members. Fine. Sir, what if I have to accept deposits from public? Then you need to follow section 76. What does 73 say? Prohibition of acceptance of deposits from public. However, this prohibition does not apply to certain companies. Who are they? Important, remember and go. One is banking companies, no prohibition. They can accept deposits. It's their everyday business. Housing finance companies, companies which are specified by central government, and NBFCs, non-banking financial institutions, they can accept deposits from public. Section 73 will not apply to them. Okay, next one, sir. How do I accept deposits, sir? What is the condition? What is the procedure? To accept the deposit, the conditions are this. How should I do it? Okay, first one, people. The procedure is, first you need to pass a resolution. Which resolution you will pass, people? People, you will pass that resolution keeping section 180 subsection 1 clause C in mind. Whatever we just saw in the case of debentures. If the value is going beyond paid up share capital, free reserve securities premium, pass special resolution. If not, not required. Next one, if I have to raise money from my members, I need to pass something called as circular. That is like an offer letter. So always remember, I need to give it like an offer letter to the public, or for the members, for them to see and understand what are the conditions, and then they can invest money. Remember, before I issue it to the members, I have to first issue it to someone else, and that is only called as registrar. So section 73 subsection 2 clause B says, before issuing circular to any of its members, first you need to give it to the registrar 30 days prior. So if I am giving it to the members today, 30 days prior I have to give it to the registrar. Which one? The circular, the offer letter basically. Sir, what should be there in this offer letter? In the offer letter, I have to clearly tell what is the financial position of the company and what is the credit rating. What is the credit rating? Next one, total number of outstanding deposits as on today. Meaning, what if already there is something existing? So I need to give the details about that as well. Already existing deposits. And remember, if it is, this is for raising money from members. If you are raising money from public, then you need to give this circular even in the newspaper as well. In the form DPT1, that's the format. You will give it in the newspaper. One in English, one in vernacular. Sir, what is the validity of this offer letter? The validity will be, people, either it will be the 6 months from the closure of financial, or whatever is the due date of AGM, whichever is earlier. 6 months from the closure of financial year, or whatever is the due date of AGM, whichever is earlier. That is the validity. Up to that day, you guys can keep on raising money from people. Whoever is interested, they can keep on investing the money. Clear? Okay, done. So this is section 73.2a, 73.2b. What is 73.2c? We already know. Something similar to your DRF. What is that? There you guys invested 15%, right, of the total debentures maturing during the year. Same way here, you will do it for 20% of the deposits maturing during the financial year. I have to deposit in a separate reserve. I need to keep it in a separate reserve. That is only called as deposit repayment reserve. Maintain it separately by 30th April of every year. Next one is 73.2e. D is not there. D was there. Now it is removed. It is not there. Company should have not defaulted in repayment of any deposits. If they have done a default, then there should be 5-year cool-off period. Hello. So 73A is nothing but offer letter. I need to give outstanding deposits, credit rating, and I have to also make sure I have to tell what is the details of the deposits and all of that. And 73(2)(b says people, before I give it to the members, I have to first give it to the registrar. C says DRR, D removed. E says people, you should have not made any default. If you have made default, there should be a cool off of 5 years. Agreed? Okay. Sir, every company has to follow it. Yes, every company should follow A to E. However, a few companies are exempted from following the procedure. Who are they? This is important. If you are a private company, not every private company, if you are a private company who is accepting from your members, deposits you are accepting, how much? Not exceeding 100% of your, take your paid up share capital, free reserves, securities premium, add everything. Sir, everything is coming to 10 crore. How much deposits are you raising? Sir, we are raising 8 crore. It is within this limit. Absolutely fine. Sir, we are raising 9 crore. Absolutely fine. Sir, we are raising 10 crore. Absolutely fine. Sir, we are raising 11 crore. No. You need to follow 73A to E. Sir, mandatorily I need to follow. You need to follow. So there is no exception. One exception is there. What is that? If at all you are a startup, even if you are raising beyond 100%, if you are a startup people, then there is no limit. You can absolutely raise money without following any limits. Sir, what if I am not a startup also? Then the last condition is a company which fulfills all the conditions. What is that? First one, you should not be an associate or a subsidiary of any other company. Second one, the borrowing in your company should be less than twice of your paid up capital or 50 crore, whichever is less. That means what? What is the total paid up capital in your company? Let us imagine people, the total paid up capital in my company is 20 crore. What is the twice of it? 40 crore. So it will be 40 or 50, whichever is less. Which is less? 40. The total debt in your company should not be more than 40 crore. If it is more than 40 crore people, then yes, there is no exemption. So if you satisfy any of, next one, you should have not done any default in repayment of the previously raised deposits. If you have done any default, sir, if you do not satisfy these conditions, then you need to follow A to E. If you satisfy any of the conditions, then you need not have to follow A to E. The procedures are exempted. You need not have to follow that entire thing, DRR or DPT1 or giving it to registrar, or these are exempted. Hello, clear? Okay. Sir, what is the procedure of raising money? Simple. The first one is people, you will pass a board resolution, and the resolution, which is ordinary or special as the case may be, 181C has to be kept in mind. You will draft a circular, you will prepare DPT1, you will file it with ROC 30 days prior. Once it is filed, DPT1 will be given to all the members. If it is a public, then you will also publish it in the newspaper. 6 months validity. Basically, the closure of financial year or the due date of AGM. Now, people will start applying for it, collect the application along with the declaration that it should be their own money. It should not be any borrowed money. I already told this. And remember, once they give you the money, within 21 days, you have to give them the acknowledgement, like a certificate. That is only called as deposit receipt, like a share certificate. So you will give them deposit receipt. Once you give a deposit receipt, you need to make the entry of all those people in a register, that is only called as register of deposits. Within how many days? Within 7 days of you giving the deposit receipt. Next one, maintain DR at the rate of 20% by 30th April of each year. Submit return of deposits. Now every year, how much is still outstanding? How much have you repaid? That ROC does not know, no? You need to file one form every year. That form is called as DPT3. You file it by 30th June of every year, telling what is the current status of deposits. The last one, if a company fails to repay any deposits, then you can apply to the tribunal. Maximum amount of deposits that can be raised. We will see how much is the maximum deposits a company can raise. Clear? Hello, all of you. Done. Next one, sir. If at all I want to raise it from public, then what are the conditions? Condition is simple. First thing, it should be secured. You need to mandatorily appoint a deposit trustee. Mandatory. Yeah, and you should be a eligible company. Not everyone can raise deposits from public, right? Not it's don't assume that a public company can raise deposits from public. It's never written like that. It depends upon two conditions. One is net worth, one is turnover. If a public company's net worth is 100 crore or more, or if the turnover is 500 crore or more, then such companies can raise deposits from public. So if a public company has a net worth of 100 crore or more, or if it has a turnover of 500 crore or more, then you can raise deposits from public. Clear? Okay, only thing that becomes mandatory here is, in addition to that, you need to appoint mandatorily a deposit trustee. You need to enter into a deposit trust deed, just like debentures, in the format DPT2. There it was SH12. Sir, and you need to obtain credit rating mandatory. Remember people, if your deposits, the maturity of deposits is 3 years, then for every year you need to take the credit rating, and you need to intimate it to the registrar every year. As long as your deposits is valid, you need to keep on obtaining the credit rating, and you need to intimate it to the registrar. And remember, the credit rating shall not be below the minimum investment grade. So whatever is the minimum grade, it should not be below that. Eligible company, rest of it is the same. You have to create charge. So you need to, if you have passed a special resolution, which and all forms will come into picture now? MGT 14, DPT 1, you need to enter into deposit trust deed, DPT 2, you need to create charge, CHG 1. So all these conditions and forms will apply if at all you have raised deposits from public. Okay, some common rules for deposits, sir. What is that? First one, the tenure of deposits. What is the tenure? Minimum is 6 months, maximum is 36 months. However, to meet your short-term working capital, you can raise deposits for even less than 6 months also, but not less than 3 months for short-term working capital requirement. However, for that short-term working capital, the maximum deposit you can raise is not more than 10% of your paid up capital, free reserves and securities premium account. Okay, next one, sir, the premature repayment of deposits. Imagine we have accepted deposits for 3 years. Someone is coming and asking the deposits within 1 year only. Are we under a liability to repay? That is only called as premature redemption. What do you mean by premature? I am coming and asking for the money before the due date. Is the company liable to give you money? Yes. Answer is yes. The company will give you money after reducing a interest at the rate of 1% for whatever is the period run. That means if you have completed 1 year, if for the 1 year if you are eligible for 12%, then we will give you only 11%. Sir, what if it is run for 2 years? Then 11% into 2 years. So whatever is a period run, you will be reduce the rate of interest by 1%. Sir, what if I have completed 1 year 5 months? Remember, any fraction, if it is less than 6 months, ignore it. So you need to treat 1 year 5 months as 1 year only. Sir, what if I have completed 1 year 6 months? It will be treated as 2 years. Any fraction of 6 months and above, you will treat it as a complete year. Hello, done. Sir, there is no need of reducing the rate of interest by 1% if at all. Imagine during the emergency, the money is requested by any of the military, army, navy or their widows during emergency, then we will not reduce any rate of interest. Second one, there is a limit of maximum how much deposit you can raise. If at all you have exceeded that limit, that's why you want to reduce and you want to give back the money, not because they asked for it. So if you have to satisfy the limits and if you want to pay back the money, then they are telling you you need not have to reduce the rate of interest by 1%. You can give it the complete amount. Clear? Next one, higher rate of interest. Imagine we have raised deposit for 3 years. 2 years is done. 1 more year to go. We have not yet completed this 1 year. Now the deposit holder wants to renew the deposit. How much is my unexpired period? 1 year. I want to renew it by another 2 years. In such case, what does the law say? The law says you are eligible for higher rate of interest if at all you are renewing your deposits, provided whatever is the period of renewal should always be more than the unexpired period. Here unexpired period is 1 year. You need to renew it for a period more than that. That's all. Sir, what is the maximum quantum of deposits? How much you can raise? Maximum. If at all you are an eligible company, you can maximum raise 10% from its members, 25% from public. You cannot, adjust this in the other category. 10 is only from members, 25 alone is from public. You cannot interchange. If you are other than eligible company, then entire 35% is from members. Government company, entire 35% will be from public. Remember that. Hello? Okay, if a company fails to repay the deposits on time, you need to pay a simple interest at the rate of 18% per annum. However, this limits for other than eligible company. Imagine a private company. This 35% limit will not apply, provided if you satisfy these conditions. What is that? A private company, whichever is a startup up to 10 years people, it will not be, they will not be liable. They can accept deposits even beyond 35%. Or a private company which fulfills all the conditions. That is, you should not be a associate or a subsidiary company. The borrowing in your company should be less than twice of its paid up share capital or 50 crore rupees, whichever is less. Or company should have not made a default in repayment of any of its borrowing. If you satisfy all of those people, then you can raise money even beyond the 35%. Clear? And what else is there? Who cannot be a deposit trustee people? Disqualifications. Remember, a director, KMP, any other officer or an employee. Same was there also, but we added promoter there. Here it is, director, KMP or any other officer or an employee of company holding subsidiary associate. Same thing only, no? Or even a depositor, that's added here. So whoever the depositor, he cannot be appointed as a deposit trustee. Next one, a person who is indebted, meaning if you have taken loan, if you have to repay, then you cannot be appointed as a deposit trustee. Sir, I have not taken loan, someone else has taken loan, I have given a guarantee, you cannot be a deposit trustee. Next one, same thing, if you have any material, pecuniary relationship, monetary relationship, you cannot be a deposit trustee. Next one, any person who is related to a person specified in the A above. See difference. There you cannot be a relative of promoter, director, KMP. Here they are telling you cannot be a relative of anyone given in point A. Who is given in point A? Director, KMP and officer, employee, everyone comes here. That's the difference. For your level, they will not go to that extent and all, but remember and go. What is the maximum rate of interest that you can pay? RBI has prescribed a maximum rate of interest that NBFCs can pay. Let us imagine like Muthoot Finance, Bajaj Finance and all. Whatever is prescribed by RBI to NBFC, same thing will apply even for a deposit raised under Companies Act. The rate of interest cannot be more than what is prescribed by RBI to NBFCs. Deposits can be in joint names also. What do you mean by joint names? 3 people can hold deposit together in one account. Possible. They can appoint a nominee together. If all of them die, the interest will go to the nominee. Amongst 3, if 2 dies, the surviving person will get the money. That's the gist, summary of whatever is written here. Clear? Documents and filing we saw. Register of deposits, you need to maintain all of this for a period of 8 years from the date the last entry is made. Premature repayment, we saw. Duties of deposit trust deed. Meeting similar to debentures. That is happening of any event or a request is made by 1/10 in value. Furnishing of deposit receipts, we saw. CIG 121 days. People, this is important. Can we remove the deposit debenture trustee there? You need to remove it only after 3/4 of the members' approval. That is what you have seen. The trustee shall not be removed after the circular and before the expiry of his term, except with the consent of seer. 3/4 there. Here, all the directors, there it is debentures 3/4. Present at a meeting of the board. In case the company is required to appoint an independent director, at least one independent director should be present in such a meeting. We are not talking about the deposit trustee at all. Yes? Remember, this point is very important from your exam point of view. That's one thing that I wanted to tell you. Clear? So more or less, that's the thing. That's your deposits. Yes, people. So let's start our next chapter, that is your charges. Okay, easy breezy. Let us try to quickly complete it. Okay, first of all, what is the charge, people? A charge means an interest or a lien created on the property or assets of a company or any of its undertaking or both as security and includes a mortgage. That is called as a charge. So technically, whenever you are taking a loan from, let us imagine, any financial institution, and if you have given your property as a collateral, it is your duty to intimate about this to the registrar. Sir, on this particular property, we have taken a loan and we have given this property as a collateral. Now, why are we giving this? Because earlier what used to happen, there were people who used to borrow loan on the same property again and again. So on the date of repayment, what will happen? There will be a conflict. Now 2-3 financial institutions will fight saying that that property belongs to me, that property belongs to me. To avoid such scenarios, what did they do? They started filing the details. Once you take a loan and if you have given a collateral once, they started following on a scenario where they will intimate about this to ROC and you will register the charge. So when you took the loan, you have created a charge. And once you intimate this to ROC, you have registered the charge. So that tomorrow, if any other lender is trying to give you the loan on the same property, he is always secured. He is always, I am saying, safeguarded. He will know that there is already a charge created on this property. Is this clear, all of you? Okay. So, what are the parties in a charge? There are two parties in a charge. That is, one is called as charge holder and one is called as the creator of a charge. Creator of a charge is always a debtor. The charge holder is the creditor. Why charge? To basically to ensure all the encumbrances made by the company on its assets are made public and to protect the interest of the lenders. Correct? What are the different types of charge? There are two types. One is called fixed, one is called as floating. A fixed charge is basically created on the assets of the company, and remember, you cannot sell these assets. Imagine if I have created a fixed charge on my plant and machinery. I cannot sell this without asking the lender. Whereas, what do you mean by floating charge? Floating charge is nothing but something you create on your things like stock, debtors. Now I can sell this even without asking my lender. Every day I can sell my stock because the old stock goes, the new stock comes. Old goes, new comes. So a floating charge is basically a charge where you can keep on selling it without asking the lender's approval. But this can continue. You can keep on selling it until when? Until a point where the floating charge gets crystallized. When will the floating charge gets fixed? Crystallized means the floating charge gets fixed. After the floating becomes fixed, you cannot sell it without the approval of the lender. Remember that. Example of fixed charge can be on your plant and machinery. It can be building, land, etc. Whereas on the other hand, floating charges, it can be stock in trade, it can be debtors, it can be raw material. All these things can be examples of floating charge. When does the floating charge gets crystallized? The floating charge gets crystallized when company goes into liquidation. That means technically company is coming to an end. Next one, when company ceases to carry on the business, that means company has, now there is no stock, new stock coming into picture. That means if I sell the old stock, then I don't have anything going forward. So whatever is there in the godown, that becomes mine. The creditors or debenture holders take steps to enforce the security. That means they appoint a receiver. You guys will be seeing it, right? You file a form called CHG6 whenever you appoint a receiver. That is this. Next one, on happening of any event specified in the deed. Example is, imagine non-payment of interest for 2 consecutive terms. Then the fixed charge can become, the floating charge can become fixed charge. So this is left to you guys in the agreement. Whatever it happens, upon that people, the floating charge will get fixed charge. What are the consequences of non-registration of a charge? Void against liquidator, void against creditor. What do I mean by that? Imagine if the company goes for winding up, the liquidator will treat you as a unsecured creditor. He will tell you to please come in the line in the last. After paying all the secured creditors, I will repay you. Void against creditor. What do I mean by that? Meanwhile, imagine if the company goes and takes loan on the same property with some other person, and if that person registers this particular charge before us, he will enjoy the priority and not us. So he will be given first preference and then the preference will be with us. That's the problem if you guys do not register the charge. Remember that. And remember people, just because you do not register the charge, the loan will not become invalid. Loan will be valid only. Of course, the priority will change. That's all. That's the only difference. Yes. Okay. And sir, what is that? What is the next one? Postponement of floating charge. What do you mean by postponement of floating charge? Let us imagine there is a lender called A. He has given loan to a company called as Kingfisher. Kingfisher has created a floating charge on this person. So tomorrow if anything happens to the Kingfisher, I will get the priority. I can sell the stock and I can recover my money. Agreed? Yes sir, that's called as floating charge. Now however, remember, in some scenarios, even though my charge is registered and created, I will be given a second preference when compared to someone else. So the money will be first given to that person, not me, even though I have a charge. And this process or concept is called as people postponement of a charge. So first he will be given preference, next is me. Sir, who is this person, sir, that he will be given preference over me? When will this happen? The first one people, in the case of a landlord who distrains for rent. What do I mean by that? Let us imagine Kingfisher is in a place. It's in a building. That building belongs to him. That is Mr. C. If at all the rent is not paid, this fellow will tell you to vacate the business immediately. Then the business itself cannot continue. So the law says, remember, now repaying the rent becomes a priority for the survival of the company. So if at all the charge is there also, the priority will be first given, that money will be first given to C to repay the C's debt. If at all C is a landlord. Okay, next one. A creditor who obtains a garnishee order. What do I mean by that? Let us imagine the Kingfisher has to pay some money to this person called C. Yeah, so now Kingfisher has not paid. So Kingfisher has created a floating charge in the favor of Mr. A. On what have they done? Let us imagine they have created a floating charge on debtors. What do I mean by debtors? Debtors means they have to pay money to me. They have taken some credit sale, they have to pay money to me. So on that we have created a charge. Tomorrow if anything happens, if Kingfisher does not repay money to A, then the debtor should have repaid to him because we have created a charge on it. Now remember people, if C goes to court, if at all the court orders garnishee order in the favor of C, that means whoever has to pay money to Kingfisher, they will have to pay money to this particular person. You need not have to pay to C. So the debtors ideally would have paid money to A, but because C got the garnishee order, now all the money will be paid to Mr. C and not A. Now this is only called as a concept of garnishee order. So court tells, hey, don't give money to anyone. I am telling pay to him. You will have to pay to him. Even though you have a charge, he gets a priority. Next one. The judgment creditor who attaches goods to the company and gets them sold. Now what is this? Judgment creditor is nothing but people. Imagine there is this goods, right? There is a fight, conflict going on. So we go to the court and the court orders that particular stock in my favor. They say I am the rightful owner. In such case, people, the goods itself is won by me. The case is won by me. They are saying that that goods belongs to me. In such case, C will get the priority, not A. Next one, the employees of the company. Simple people. Remember, Kingfisher did not pay the salaries of its employees for almost up to 2 years. In such case, even though there is someone who has a floating charge, our first preference will be to repay the employees of the company, because if they do not work, then we will have to shut down the company immediately. So they enjoy a preferential right. Next one, sir, the supplier of the goods to the company under a hire purchase agreement. What do I mean by that? First of all, it is not a valid charge at all. What is a hire purchase, people? Someone has given us goods, but the ownership is not yet transferred. And this fellow has further created a charge on this hire purchased, machine or car or anything. Remember, ownership is never with us. So if at all you do not repay the loan, or if you do not repay all the installments, they will come back and take back the car. Why will they give it to you? Because you have to pay all the installments. So any product purchased under hire purchase, whoever is the owner, he will only get the property, even though I have created a charge on this particular car, hire purchase. Remember, these are the scenarios where the floating charge will be postponed. Okay. Next one, sir. How do we create a charge? Duty to register a charge. Yes, first one, left side, it's okay, leave it, because we were following that before 2019. It's been 7 years now. So focus on the right side part. If at all the charge is created on or after 2nd November 2018, then what is the duty? How do we have to register the charge? Along with this, I am also telling the steps also. Again, towards then, let us not do the checklist and procedure. First, I need to file the charge in the form CHG1. If it is debentures, then it will be CHG9. I need to register the charge within 30 days of us creating the charge. Correct? So I will file in the form CHG9. Sir, what if I am not able to file it within 30 days? then people, they will give you an additional time of another 30 days. However, for this people, you need to pay certain additional fees. Sir, what if I was not able to register even in the additional 30 days? They will give you one time, the last one more extension of another 60 days. For this, you need to pay additional fees plus you need to pay ad valorem fees. Ad valorem means people nothing but like a penalty. So maximum time now you enjoy is people 120 days, not beyond that. And that too how people, if you do it within 30 days, you will be filing form CHG1, you will be paying normal fees. If not, within 30 days, additional fees. Sir, if not, additional fees plus ad valorem fees, like a penalty. Yes, sir, if at all the details you are given, if it is correct, then the registrar will reply to you in the form CHG2. That is only called as people the registration of your charge. Clear? Yes, sir. Okay. Sir, what if the creator of charge, if the company does not file the charge, if within 30 days, if the company does not file people, then the lender, that is the financial institution, that the bank will be there, no, they can only file the charge. Yeah, now what will the lender do? Let us imagine SBI bank has given loan. SBI only will file it with ROC that we have given loan to this company called as Kingfisher. So now ROC will check with the Kingfisher. We got an application creating a charge on your assets. Is it true? Now Kingfisher has to reply to the ROC within a period of 14 days. You need to reply, yes, whatever SBI said is true or false. If you do not reply, it will be considered as a deemed approval. Now SBI can recover all the cost from Kingfisher. What all cost? I can recover the cost of the normal fees, plus if there is any additional fees, I can recover that as well from the Kingfisher, because it is your duty to register the charge and not mine. Is this clear? Okay. And remember, sir, all the documents that are filed with registrar, everything sits in the public domain. So if anyone is entering into a contract with the company, you are deemed to have the knowledge about the charge. You cannot say that they did not inform me. If you are entering into a contract with the company, because all of this is considered as constructive notice, it is deemed to be a public document, because remember, the ROC maintains the details of all these charges that you have filed. Hello, remember, the charges will be maintained in two places. One with the company itself in the form CHG7. It is available for inspection. The members, the creditors, they can come and inspect these registers whenever they want. In addition to that, the registrar will also maintain one copy of all the registers. So you can inspect in either ways. That's why the charges are always considered as public domain documents. Hello, done. Next one, sir, registration of satisfaction of charge. What do you mean by that? Sir, Kingfisher has repaid the loan to SBI. Now what will I do? The Kingfisher will file an application to ROC. Sir, I have repaid the loan. Now ROC will check with SBI. Hey, Kingfisher is telling that they have repaid the loan. Is it true? Now RBI has people 14 days time to reply. If RBI does not reply, it is considered as deemed approval. Sir, what if, within how many days should I intimate to ROC? You need to intimate ROC within 30 days of you satisfying the charge, meaning repayment of the charge. Sir, what if we are not able to do it within 30 days? If you don't do it within 30 days, people, you will get 300 days from the date of payment. You will get an addition, you will get a total time of another 300 days. Same thing, normal fees plus additional fees. Hello, clear? Okay. Now, sir, what if we are not able to file it within 30 or within 300 days? Now what to do? From section 82, you will go to the next section, that is section 87. What is the next section? Rectification by central government. Go and tell central government, sir, because of these reasons, we were not able to intimate the satisfaction. Can you please help us? If central government is convinced people, central government will allow you to file your satisfaction of a charge even after 300 days. Remember, for satisfaction of a charge, there is no upper limit at all. But that is not the case with registration of a charge. If 120 days, if you guys are not doing it, you can never register a charge. It is gone. But satisfaction 30, 300, if not also CG approval, you can any time do it. This is only called as condonation of delay. You have to pay additional fees. That's the only thing. Clear? Sir, what if in any of the documents we have filed, it can be CHG 1, 2, 3 and something. In those documents, there are some mistakes. Can we correct it? Answer is yes. How? Again, the same section 87 will apply. You need to file to the central government in the form CHG8. Sir, there are some mistakes in this form. Can we please correct it? And you can correct your whatever is the forms that you have filed. Clear? And next one is, and remember what all charges has to be registered, whether the charge is created in India or outside India, movable, immovable, tangible, intangible, everything has to be registered with ROC. Remember, that is very, very important, mandatory. Sir, who should sign the charge documents? Again, important. If the property is situated outside India, the charge documents shall be authenticated by common seal or 2 directors or a company secretary or the authorized officer of the charge holder. That means nothing but I'm talking about the bank lender. So one is my directors, or I can take it the company secretary of my company, or I can take the signature of the any authorized officer from the bank, or some other person other than the company who is interested in the mortgage. That means what, sir? We are taking from any other person. For example, A has taken loan from SBI and the guarantee for this is given by company B. Now they can also authenticate this particular document. Hello. Sir, what if the property situated in India? The third condition will not come. It should be either common seal or director or CS or any other person authorized by the charge holder. Okay. Next one, sir. What else? Acquisition of property subject to charge and modification of charge. What is this, sir? Let us imagine, people, there is company A. Company A has taken loan from SBI on a particular property. Imagine they have a land. On this they have taken a loan. Now company A has sold this land to company B. Now has company A repaid the loan? Answer is no. Now company B has purchased this particular land. Now going forward, you need to repay this loan to SBI bank, no? So it is your duty, the company B will have to file form CHG1 again to register a charge. Who will file? The acquirer, the company B will file within 30 days. Hello? Now going forward, SBI will say, okay, company A's name will be discharged and company B's name will be entered. This is one place where you will file. This is called modification only. Second place, company A only has taken loan. Imagine they want to change the tenure. From 5 years, they want to make it 8 years. If there is any change in the documents that you have already filed, you can file certificate of modification of charge. Again, you will file it in CHG1 only within 30 days of modification. ROC will give you something called as certificate of modification of a charge in the form CHG3. You will file CHG1 only. They will reply to you in CHG3. What is CHG4? Is nothing but satisfaction of charge that you file. CHG5 is memorandum of satisfaction of a charge, meaning ROC gives you an acknowledgement. Okay, I have noted your charge is discharged. CHG 6, whenever the company does not repay the loan, what will the SBI do? SBI will appoint a receiver to go and take charge over that property. Now, whenever we appoint a person, now that person's appointment has to be communicated to the company, that is Kingfisher, as well as to the registrar, ROC, in form CHG 6. Sir, once the purpose is done, served, now his appointment will come to an end. That also has to be communicated to the ROC in the form CHG 6. And next one is register of charge will be in the format CHG 7. Register of charge shall be maintained permanently. Remember, instrument creating the charge will be maintained for a period of 8 years from the date of repayment. However, the instrument creating the charge is 8 years, the register of charge will be maintained permanently for the life of the company. CHG 8 is nothing but central government, condonation of delay or errors. CHG 9, registration of charge in the case of debentures. Remember, whenever in this case only, section 79, any person acquires a property which is subject to a charge. Imagine B. Now B has intimated to the ROC, sir, I have taken it over today. Now going forward, I will repay the loan. Please register the charge in your records. Now for the ROC, neither company A informed, neither SBI informed. Company B is informing. It's okay. ROC will reply to A and SBI that your charge in between you both is discharged. So he will issue satisfaction of a charge. Now a new charge will be replaced in the B's name. Remember that. Hello. Hello. Power of registrar to make entries. I can make an entry whether you intimate or not. Now B has intimated, it's okay. I will enter it and I will give it to A and SBI. Appointment of receiver or manager. Company's register of charges CAG 7 permanently. Instrument 8 years. Okay. Inspection of charges. Any member creditor without fees. Any other person you need to pay fees. Charge forms. Procedure for registration. I already told you what is the procedure. Yes, sir. That's all. That's all. That is your charges. Simple chapter. That's all. No? Yes, people. So let's start our next chapter. That is chapter 8, distribution of profits. Nothing but dividends. So first things first, what is that? There are two types of dividend. One is final dividend. What is interim dividend? What is the difference between the final and interim dividend, people? See, always remember the final dividend is always recommended by the board, declared by the shareholders. So the directors tell you, they fix. Imagine whenever you can think like this. Once the year is done, the directors will prepare something called as board of directors or directors report. In that they will say during the year, this is the net profit we made, this is the tax, this is the depreciation, everything. After everything, your net profit after tax, what is the final amount? From that amount we are going to say, imagine if that money is coming to 1 crore. In that we will tell, in this 20 lakh will be transferred to free reserves and 80 lakh will be used to declare as a dividend at the rate of, let us imagine, say 100% is what we have decided. And always remember, dividend is declared on face value, not on market value. So we have declared dividend on 100% and that amount is coming to 80 lakh. Now this recommendation is made by the board. Now what will happen? After the notice is given, after 21 days, people will come for an AGM. In the AGM, the shareholders will say whether they are okay with this or not. So they will approve this. The shareholders also have a right to say, no, let us put that money back to the business only. Don't distribute it as a dividend. The shareholders can say yes or a no. It is their choice. Now such type of dividend is called as what, people? Final dividend. Whereas what do you mean by interim dividend? Interim dividend is nothing but a dividend which is declared between an AGM. So it is always recommended by the board and declared also by the board only. And always remember the interim dividend, to declare interim dividend, you need to give the power to the directors in the articles of association. And you can declare any number of interim dividends in a year. There is no limit. In a year, you can declare any number of interim dividends. So that's the difference between final dividend and interim dividend. Final dividend is always recommended by the board and declared by the shareholders. Whereas interim dividend, recommended by the board and declared also by the board only. That's the interim dividend. Is this clear, all of you? Okay. The next one, sir, section 123. Let's start that. What is that? Declaration of dividend. The source of dividend. From where will we declare dividend? The first one, people, you can declare dividend out of the current financial year, whatever your current profits are. You can also declare it out of the previous financial year, that is free reserves. Also, you can declare it out of the credit balance of P&L account. Using all of this, you are free to declare a dividend. And not only that, from any money provided by central government or state government, you can use that also to declare dividend. Next one, before declaration of any dividend, the following should be first deducted or set off. That is nothing but depreciation and previous year losses. Transfer of money, as I told you, remember in the director's report we will tell that we have decided to transfer so much of money to reserves. There is no mandate. You can even declare the entire 1 crore as dividend. There is no mandate. You have to transfer 10%, 50%, nothing. Only thing, if you guys have any debenture redemption reserves or deposit repayment reserves, if such things are there, then yes, it is your duty to transfer money for that. But apart from that, you need not have to transfer any money to free reserves. You can use the entire profits to declare as dividend. Remember, whenever you have adequate profits, sufficient profits, there is no limit on declaring dividend. You can use the entire profits to declare dividend. Remember that. Whenever you have inadequate or there is no sufficient profits in your company, and if you want to declare dividends, then in such case, yes, the rule 3 will apply. That is that what is the maximum you can borrow? You cannot exceed the average of 3 years. That and all will come into picture. We'll see. Is this clear? Okay. What is that? Rule 3. Declaration of dividend out of the profits of previous year, or when there is inadequacy of profits or absence of profit. In such case, there are 3 conditions. What is that? Condition number 1. What is the maximum rate? It shall not exceed the average of 3 years. Remember, sir, what if in my last 3 years, I have not declared at all? Then this condition itself will not apply. And very, very important. So remember, in my year 1, we have declared, say for example, 15%. In my year 2, we have declared 6%. In my year 3, we have not declared anything. Now, how do I take an average? You still do it in the same way. Divided by 3. It will still be 21 divided by 3. That is 7%. Remember, this is very important. Even if there is 0 in a year in between, you still take it while you are taking an average. You will not do it divided by 2. You will do it divided by 3 only. Because it is average of 3 years is what is the condition. Next one, maximum amount that we can draw from the reserves. What is the maximum amount we can draw? The maximum amount we can take from reserves, people, shall not exceed 1/10 of the paid up capital plus free reserves. If in my free reserves, if there is 1 crore, what is the maximum I can draw? They're telling you, I can draw maximum is basically 1/10, 10% of your paid up capital plus free reserves. Take your paid up capital, take your free reserves. From that 10% you can withdraw. Hello, and remember, from whatever is the money you have withdrawn, from that first you need to set off your current year losses, if any. First you need to set off that, and whatever is the remaining money, only that money you can use to declare as dividend. And remember, after the money is withdrawn, whatever is the money that is left in the balance, that left as a balance in the reserve, it should not be less than this number. What is that? After such withdrawal, the balance should not fall below 15% of your paid up capital. So whatever is the money left behind in my free reserves, it should be at least 15% of your paid up capital. How much ever that value is coming to, you need to maintain at least that much of amount. Now let us imagine if the total amount that we have drawn here is 40 lakh. In that we have used, in the current year there was a loss of say 20 lakh. Let us imagine current year there was a loss of 10 lakh. So 30 lakh we can use to declare as dividend, because 10 lakh you cannot, you have to first set off the current year losses. Now balance in reserve after withdrawing should not fall below the 15% of paid up capital. No, sir, should we take 40 here or 30 here? You will take as 30 only for the purpose of calculation as the amount drawn here. Whatever you have withdrawn, for that you need to take the calculation as 30, not as 40. Again, this is one thing where they will generally feel confused. Okay. And remember, in your book there will be other things also. What is that? If at all a company has preference shares, people remember, preference share is just the share which gets a right, or you can say it gets a priority for repaying the dividend when compared to a equity shareholder. We always give a preference first, priority first to the preference shareholder. Agreed? No? Remember, preference should not be misunderstood for mandatory dividend. Unless and until, see, preference dividend is nothing but, it is always with regards to your terms of issue. If at all while issuing you said we will declare dividend every year, you have to declare every year. Example is cumulative. If I do not declare dividend this year, in the next year I have to add it. Next year I have to add it. Hello? Sir, what if it is non-cumulative? I said if I have profits during the year, I will pay. If I don't have, remember people, don't get confused. If I don't have, you are not liable to pay dividends and all. Preference share should not be confused with, mandatory dividend. Preference here is not giving you any right for dividend. It is just giving priority over the dividend if the company is declaring dividend. If company does not declare dividend, the company is not liable to pay you. So it all depends upon the terms of issue. Remember that. That is very, very important. Clear? Okay. Next one, sir, payment of dividend. It shall be paid only to the registered shareholder or any of his order. Meaning if I tell don't pay to me, pay to that person, will pay to that person. Or to the banker. Generally digital payments. Dividend can only be paid by cash. Basically, when I say cash, it's not a physical cash. I'm talking about electronic mode. And not in kind. So you can pay by check, by dividend warrants. You can give it by electronic mode also, like NEFT, RTGS. Okay. Next one, dividend shall not be paid if company has not complied with Section 73, Section 74, Section 8. You are not, first of all, you are prohibited. You cannot declare dividend at all. And when else you cannot declare dividend? The company cannot declare dividend if it has defaulted in redemption of debentures, interest, creation of DRR. Any default, no dividend. Same thing, redemption of preference shares, creation of capital redemption reserve, CRR. Next one, payment of any dividends declared. Meaning if you have already declared any dividends and if you have not paid that, it's again you cannot declare any new dividend. Repayment of any term loan or its interest. We have taken loan, we have not repaid the principal or interest. If you have made such default, you cannot declare dividends. Remember that. Okay. Next one, interim dividend. What is the maximum interim dividend you can pay and how can we pay? Sources very important. Interim dividend can be paid out of surplus in P&L account. Next one, profits of the current financial year. What is the surplus in P&L account, people? Imagine if we are in the year, now this is, let us imagine 26-27. In the year 25-26, we completed the year. So your P&L account is done. You got your net profit. From net profit, what you're going to do? You're going to do something called as appropriation. How much of it goes to reserve? How much of it is declared as dividend? You're going to do the appropriation. So how are you going to utilize these profits? Once the entire appropriation is done, imagine your net profits was say 1 crore. You have appropriated around 80 lakhs. Rest of the 20 lakhs, you don't know what to do. So what do? You keep it in the P&L account only. You have not yet appropriated it. And that is only called as surplus in P&L account. So the last year's profit is still left there only. We have not yet utilized it, or we have not yet reserved it for any purpose. Such things are called as what, people? Surplus in P&L account. So you can utilize that money to declare interim dividend, because to utilize that money, we need not have to ask shareholders. It comes in the director's power only. They can only declare, they can only use anything. That is absolutely fine. Next one, profits of the current financial year. You can use the current financial year profits. Or, sir, what if the year is not yet completed? In such case, profits generated in the financial year till the quarter preceding the date of declaration. That means what? Sir, Q1 profits, Q2 profits. In Q3, our Q1, Q2 is in profits. No, quarter 1, quarter 2. I can utilize that only to declare the dividends in the quarter 3. Okay. Restriction during the loss of current financial year up to the end of immediately preceding quarter. That means what? Sir, in Q1 also loss, Q2 also loss. In Q3, we want to declare dividend. Can we? Yes. How? You still have the surplus in P&L account, no, from the previous year. Utilize that. Provided in such scenario, when you are declaring dividend, remember the rate of dividend cannot be more than average of your last 3 financial years ka dividend. Only that one condition will apply. The rule 3 first condition only that will apply, not the rest of the 2. Clear? And remember, you cannot declare interim dividend out of free reserves. Remember that. Okay. Okay. Declare dividend to be deposited in a separate scheduled bank account. That's a procedure, right? Okay. Next one is section 124. What does 124 say? When to give the dividend. Once the dividend is declared, now what do I have to do? Within the next within the next 5 days, you need to deposit the dividend into a separate scheduled bank account. I have to first separate it. So from my main account, I have to separate it into a different account. Now within 30 days from the date of declaration, that is from the date of meeting there, within 30 days, I need to make the payment. Sir, what if I am using dividend warrants or checks? Remember, the payment can happen even after 30 days, but you need to post it within 30 days. Okay. Sir, within the 7 days after 30 days, imagine, sir, for a few people we were not able to pay. What to do? Whomsoever you are not able to pay, within 7 days, after the 30 days is done, do one thing. Within 7 days, open another account, name that account as unpaid dividend account, and transfer all the funds to that unpaid dividend account. Hello, within 7 days. Amount unpaid transfer to UDA. Failure to transfer to UDA, you need to pay interest at the rate of 12% per annum. Sir, even there also, once you transfer to UDA, within 90 days of you transferring to UDA, you need to display on your website of the company whose dividend it is, what is their last known address, what is their last known address, and the amount of unpaid dividend. What is the amount? We need to disclose all of this on the website within 90 days of we transferring the money to unpaid dividend account. And the money is going to stay there for a period of 7 years. And in the 7 years, if no one is coming to collect that dividend, then what are we going to do? We are going to transfer that entire dividend to a account called as IEPF. Sir, only dividend, not only dividend, people, the shares on which the dividend you guys earned, that shares also we are going to transfer. And not only that, for that 7 years we would have earned interest upon that money, right? Your money, that interest also we are going to transfer. Unpaid dividend account, section 124. Next, section 125, IEPF. What and all are the different money that is credited to this account? The fund is credited with the grants by central government, any money sent by central or state government, general revenue account of central government, amount in IEPF under Companies Act 1956. So before this, under Companies Act 1956, we had IEPF. So once Companies Act 2013 came, that money was transferred to this account. That one. Interest or income received from investments made out of the fund. So this fund, we are going to interest in government securities. We are going to earn money. That will be credited only, no? Next one, disgorgement order money. What is disgorgement? If at all anyone has made illegal gains, we are going to take away that money. Now, for example, in the case of Harshad Mehta, he made so much of illegal assets, right? So government will take away all that illegal assets. And what will they do? If at all anyone has suffered loss, we will take money and we will use that money to repay to those people who have suffered losses because of you. Next one, security application money. We saw in deposits. If someone has applied and if we don't allot them, within 15 days we have to refund. If we are not able to refund, it will be treated as deposit. But for how long? For 7 years it will be with you. After that you will transfer it to IEPF. Mature deposits, 3 years is done, no one came to collect the money. Debentures, no one came. Preference shares, no one came. And interest accrued on all of this, no one came. SBO, the person did not disclose the details within 1 year, section 90. We are going to transfer all the particular shares to IEPF. Hello? Hello? Okay. Sir, and what are we going to use this money for? Where you going to use this money for? First one is, if they are coming and asking, you will refund them. Promoting of awareness amongst the investors education. Like there are, investments are subject to market risk. Please read the offer document carefully. Don't share the OTPs, things like that. Educating investors, protecting the interest of the investors, distribution of disgorgement amount. I told you, we took it here and we are going to give it to the people who suffered the money. So distribution, who suffered the loss. Next one, reimbursement of legal expenses. What is this? Now imagine if at all some 100, 200 people, now in the case of Harshad Mehta, around he has created a loss for more than 10,000, 50,000 people. So everyone wants to file a case on him. Now imagine if the courts take up a case, they have to hear 50,000 cases. Rather, what will they do? They will combine all these cases into one case and they will make this as a class action suit. Meaning, one person will come on behalf of everyone and that particular case will be conducted, and such type of things is called as class action suit. Not everyone need to come to that particular court. Only one case will be heard. That expenses will be given by IEPF because so many people suffered loss. So it is the interest of the government that we need to protect you and they try to protect you. Simple. Okay. Next one, dividends to be held in abeyance. What is this, people? Whenever imagine there is a transfer of shares, we sign SH4. We have given this SH4 to the company to register the transfer. The company has time, right, to register the transfer. The company can register the transfer within 30 days. They have time. But you have given people, immediately company took your SH4, but the company has declared the dividend. And hence in the register of members, still A's name only is reflecting. B's name is not yet reflecting because we have not yet made the entry. But technically, as per the contract, I have received the money, I have given everything, I have signed. B should receive it. Actually, if you ask me who is the owner, he should get it. But according to the rule, your name is reflecting, hence you will only get it. So what does the rule say? It is A's duty to take it and it is A's duty to give it to B because there has been a contract. But all of this will be like a conflict only. If such things happen, then what do we do? What will the company do? The company will keep aside the dividend until the rightful owner is decided. We don't know who the owner is. Until the owner is decided, we are going to keep the dividend, aside with the company only. And that is only called as abeyance. Abeyance means, people, nothing but kept aside until the owner is decided. Clear? All of you? Okay. 126. Last one is 127. Punishment for failure to distribute dividend within 30 days. So see, always remember, it is your duty to pay the dividend within 30 days. If at all I don't pay, and it is not because of the company's fault, it's okay. If you don't pay and it is because of company's fault, you are liable. To what? Your liability will be, you will pay interest at the rate of 18% to the shareholder, and the directors can be imprisoned up to the maximum of 2 years, and fine can go up to ₹1,000 per day of default. That will be the penalty. Sir, in which scenarios the company will not be liable? For the company, these are the scenarios where company will not be liable. First one, we were not able to pay the dividend to the shareholder due to the operation of law. Meaning, imagine the shareholder became alien enemy. He is a foreigner and we declare that country as an alien enemy. We are not able to do contract with them. Next, when shareholders' direction of payment could not be complied and same has been communicated. The shareholder said, I have 3 bank accounts. In that, please transfer the money to this bank account. And he has given all the details wrong. The account number is mentioned wrong. We tried and it is not reflecting right. So whenever there has been a clear instruction and if that instruction was not able to be followed, then people remember, we have to clearly tell the shareholder, sir, your instruction we were not able to follow. You have to communicate. If you don't communicate, then it is considered as non-compliance. That is important, remember. Third one, you should have paid us some call money. For the call money, we adjusted it. It's absolutely fine. Next one, dispute in right to receive the dividend. Abeyance, 126, we are fighting. They are saying this is mine, it belongs to me, it belongs to me. Non-payment is not due to the default of company. So it can be any other reason, but it should not be the company's fault. In such case, people, yes, you can file. You will not be liable for any of the penalties. And next one is what? Okay, dividend distribution policy, regulation 43 of SEBI LODR. What does it say? The top 1000 listed companies have to come up and they have to frame something called as dividend distribution policy. What do I mean by dividend distribution policy? See, what happens as a shareholder is you always anticipate when are you going to get dividend. You always anticipate that. Yes. So whenever you are going to get dividend, it is always unfair for you to keep asking, keep expecting, will I get dividend this year? So rather, what did the SEBI Act do, SEBI LODR? They said, why don't you guys form a policy called as dividend distribution policy? This is applicable for the top 1000 listed companies. What does the policy say? Very simple. What are the scenarios under which the company's shareholders, when can they expect dividend from the company? You give probable scenarios. Now what happens? They will only do the calculation. Okay, profits has to be this much. Our reserves have to be this much. Our future prospect of growth is this much. And we will do the calculation. We will know whether to expect dividend every year or not. And this is only called as dividend distribution policy. See here. It shall include the following parameters. The circumstances under which the shareholders may expect the dividend or may not. If the financial parameters that shall be considered while declaring the dividend. What are the financial parameters? Profits has to be this much. It has to be this much. Internal and external factors that shall be considered for declaration of dividend. So internal is company related. External is political or global related. Policy as to how the retained earnings shall be utilized. Imagine if we are not declaring dividend or we have free reserves, right? How are we going to utilize that money? Next one, parameters that shall be adopted with regards to various classes of shares. So it can be DVR, it can be preference. For all of them, how are we going to see it? So that is only called as dividend distribution policy. The listed entities other than those specified may disclose their dividend distribution policy even on a voluntary basis. For these people, it's mandatory. Anyone else, you can do it voluntary as well. Declaration of dividend should be unconditional. What do I mean by unconditional? You cannot say that subject to the central government's approval, subject to the tribunal's approval, we will give you dividend. All such things cannot happen. It should be always unconditional. Subject to the bank's approval, subject to my creditor's approval, that and all is not a valid dividend. It should always be unconditional. Okay, we have that IEPF procedure, no? You want it, IEPF, you want me to do? Want? Okay. I've tried to summarize that. Okay. So the transfer of unpaid or unclaimed dividend to IEPF, 7 years done, no one came. Now what do? The company, first step is identification. Companies must identify the dividends which has been unclaimed for a period of 7 consecutive years. It is to be done within 60 days of AGM or its due date. The last 7th year is done, the AGM is done. So from that, within 60 days, I need to do this. Okay, now what do? Amount must be transferred online to the IEPF account within 30 days of becoming due. So what do you mean by that? 7 years done. Within 30 days, I have to transfer all the amount to the IEPF account. And I need to file a form that is called IEPF1. In that I have to clearly tell, I am giving you the dividends and this is the amount for so many shareholders for so many years. I'll give everything. Mode of payment, it will be under MCA. Miscellaneous fees it will be called as. You need to go under MCA and make the payment. Post-transfer compliance, authority enters data in the register and reconciles monthly with the banks. The bank provides monthly abstract within 7 days after the month end. Company maintains full records of the filing. What is this, people? Reconciliation. The company has filed all the details to IEPF. IEPF's bank has received some money. So what will IEPF do? IEPF will reconcile with whatever the data the company has sent and whatever is the data the banks have received. They will reconcile and they will check whether we have received the correct amount or not. Disclosure IEPF2. What is this? Uploaded every year on the company's website and IEPF authority website. What will be given in IEPF2? We will give the details of the shareholders. Last name and last known address of the claimant, amount and nature and value, due date for transfer, other essential information. We'll give all the details in IEPF2. IEPF1 money, IEPF2 the details of the shares. Next one, transfer of shares to IEPF. Here we have transferred money. We are transferring shares also here. Same thing, 7 years. We have to intimate the shareholders first before we transfer the shares. So notify the shareholders 3 months in advance. Give it individual. Give it a newspaper. Also mention it on the website of the company. Exemptions. Shares shall not be transferred if a court or a tribunal's order is there, or the shares are pledged, or any dividend has been claimed in this 7 years, then we will not transfer the shares. Remember, after all of this, you need to file form IEPF4 to disclose all the details about the shares and all the other part. How will we transfer the shares? If the shares are in DMAT form, we will clearly transfer the shares from our DMAT account to IEPF DMAT account. If the shares are in physical form, then what will we do? The company will nominate its company secretary or any authorized person. They will apply for a duplicate share certificate because the shares are in physical form now. We will convert this duplicate share certificate into DMAT form and then we will transfer it to IEPF account DMAT form. So first we will take a duplicate share certificate, convert it into DMAT form, and that will be transferred to IEPF DMAT. Next one, if anyone wants to take back the money, now imagine after 10 years, someone was in coma, he woke up, now he wants the shares back. Can he get it? Yes. How? You need to file form IEPF 5. You will file it with the IEPF authorities. IEPF will forward your application to the company and they will ask him to make a proper research and tell whether is it rightful owner or not. We have received a request. The company will do the research, the company will present its report, and accordingly the IEPF will process the transfer. And who will do the complete research and all in the company? We call that person as a nodal officer. Generally it is company secretary. Approval and refund. IEPF. Then now, that's all. Remember these, it's more than sufficient. Here, dividend distribution. And the last one, people, one thing, yes, remember there is something called as SS3. SS1 is on your board, SS2 is on your general meeting, SS3 is on your dividends, which is voluntary in nature from the 2018. It's not yet mandatory. So if you guys want, you guys can follow secretarial standards on a voluntary basis. It is not mandatory. Clear? Yes, I hope I have covered most of it, IEPF as well as all the sections here. Yeah, procedure also, as I told you, you remember that timeline is important, and if it is final dividend, it is always declared in AGM. If it is interim dividend, directors only will declare it. So it will be board meeting. If it's final dividend, it will be AGM. And timeline will come into picture within 5 days, 30 days, 7 days, 7 years, 90 days, UDA account, all that is as it is. Yes, hello? Secretarial standards on dividend. There is something called as deemed dividend, right? Let us see that. There is deemed dividend, right? What do you mean by deemed dividend, people? The concept of deemed dividend is embedded in Income Tax Act, not here, where a closely held company extends a loan or advance to any of its shareholders who has more than 10% of voting power in the company. Closely held company means, people, imagine there are 3 people who are, say, friends or family, whatever you call. All of them are holding 30%, imagine 40 and 30 in a company called XYZ. Now this is called closely held company, and one of the shareholder, let us imagine any of the shareholder who has more than 10% of the voting power, he has, in our case everyone has 30, 40. So now what happens? If at all this XYZ company is giving a loan to this person, we consider this loan also as a dividend only in the hands of Mr. C. Even though it is a loan, if you remember, people, Dinsha Manakji Petit's case, similar to that only is this. That is only called as a deemed dividend. When else it will be a deemed dividend? To any concern in which such shareholder is substantially interested. That means what? Sir, let us imagine there is XYZ. In XYZ, okay, let us imagine this way. Again, same thing. Okay, take the extension of this only. There is this A, B, C. Sir, C is a shareholder of one more company called as ABC Private Limited. And XYZ gave loan to this ABC Private Limited. Now, this is also called as a deemed dividend. Because we have common shareholder, a common controlling person. Even that is also called as deemed dividend. Next one, for the individual benefit of such shareholder. Meaning direct benefit, if I make anything on behalf of such shareholder to the extent the company has accumulated profit, such payment would be deemed as dividend. Meaning, sir, imagine Mr. C had to pay some money to an outsider called D. We give that money. Again, it is considered as deemed dividend. That is the concept of deemed dividend. Remember and go. That is, it will be taxed as a dividend in the hands of Mr. C. Yes, sir. That's all. Dividend distribution was IEPF. Okay. Done? Yes? Okay. I hope we went in detail. Where did that go? Okay. That's your chapter 8. Let's start your chapter. Next is chapter 9. Yes, people. Let's start the next chapter. That is your chapter 9. Okay. So let us directly go to our chapter 9. That is books of accounts. So what and all should be maintained by technically every company, right? There is no exception as such. So you have to maintain your books of accounts, books and paper. What and all is coming under books of accounts? It includes all the amounts which is received as well as expenses, assets and liabilities of the company, sales and purchases of goods and services, items of cost. That is nothing but your last one, cost records, cost audit we'll be seeing when we are doing 148. You'll also maintain books and paper. Okay, from exam point of view. Financial statements. What and all does financial statement include? It includes balance sheet, P&L account, cash flow statement, statement of changes in equity, and explanatory note. So you will maintain all these particular details if at all you are maintaining it for every company basically. Agreed? Okay. Okay. So yes, people. So financial statements includes balance sheet, P&L, cash flow statements, statement of changes in equity, and explanatory note. Certain companies are exempted from preparing cash flow statement, and who are the people? They are your OPC and small company and dormant companies and startup companies. All these companies are exempted from preparing the cash flow statements while they are preparing the financial statements. Important exam point of view, remember. Okay, general requirement in preparation of books of accounts. It has to always give true and fair view. Okay, it shall be prepared every financial year. Explain the transactions of registered office has to be kept separate. Branch office accounts has to be kept separate. Always remember, you have to prepare separate accounts for branch office. Those books will be maintained in branch office. Even those accounts shall also be audited. All three are important. Agreed? Next one, accounts should always be maintained on accrual basis, double entry system. Place of maintenance of books of accounts. Where do we maintain it? You generally maintain it at the registered office of the company, or you can maintain it in any other place also. Which place? Any other place in India after passing board resolution. Do not get confused between this point and register of members. Their special resolution, more than 1/10 of the population, all that will come into picture. Here all those conditions will not come. So keep this thing in mind. Okay, so just pass board resolution and you need to intimate the ROC, sir, going forward, my books of accounts will not be here, it will be in this place. You have to maintain it, you have to mention that to the ROC in form AOC 5 within 7 days. Then, okay. So, books of the branch office, whether in India or outside, the books shall be kept at the branch office itself, provided a summarized returns shall be sent to the main office every quarterly once. So on a regular basis, you maintain your books outside India only. But once in a quarter, you summarize it and you send that books to your head office. Inspection by directors. Directors can inspect the books. Yes, possible. Any director can inspect the books during the business hours. Whether non-executive, independent, executive, anyone can inspect. He can inspect the books of subsidiary company only after authorization by the board of directors. So can you check this books of subsidiary company? Yes, possible. But yes, it should be authorized by the board of directors. Next one, the financial information maintained outside India can be requested by the director to the company and it shall be provided within 15 days. Imagine we have a branch office, or if we have any other details of the company that belongs to the company outside India, if we have maintained, any director of the company can say, Sida, if I go, it will be very expensive. Rather, can you send me those books here only? I just want to check it. So you can just make a request. Remember, from the day you make a request, within 15 days, those books has to be given to the concerned director. Remember, those books has to be personally asked by you, and you should not ask it through any agent or any advocate or any attorney. It should always be a personal request. Just a second. These guys will take AC remote. They will make the AC one room heater. Okay. Next one, period of preservation. How long will you maintain the books of accounts? The books of accounts, the vouchers and all the supporting documents will be preserved for a period of 8 years preceding the financial year. That means if at all you are in the year 26-27, don't count the current financial year. Leaving that from 25-26, you have to go back 8 years. This is 1. 2, like that 8 years. You have to maintain it for a period of 8 years. Is clear? Sir, who are the persons responsible to maintain the books of accounts? Very important, remember. It is a responsibility of the managing director, whole-time director in charge of finance, CFO or any other person authorized by the board. They may ask you a question here. Whose duty is to maintain the books of accounts? It's managing director, whole-time director in charge of finance and CFO or any other person authorized by the board. Tomorrow, if there is any non-compliance with regards to maintenance of the books, who will be under liability? These people will be under the liability. Sir, next one, this books and all, how should we maintain? You can maintain it in physical form or you can even maintain it in electronic form. Remember, from 2023 onwards, people, you have to maintain, you can maintain it in electronic form. Like for example, you can use it SAP, you can use Tally, you can use Zoho books, whatever are the softwares, you can use all of this. Provided you can use only those softwares which has audit trail feature in it. Now, what do I mean by audit trail, people? Audit trail means nothing but whenever if there is anyone who is changing the entries made, imagine you are editing or you are deleting an entry of some entry of past in the past. You are deleting it, you are changing the things. It should clearly tell if any edit is made, any entry is deleted, who deleted it. That entire option we should be able to capture. Only such softwares you can use. Zoho allows you to do it. Zoho books. So audit trail feature is mandatory. So the manner of books of accounts to be kept in electronic form. The books of accounts and other relevant books and paper shall remain accessible in India. So if you are maintaining it electronic mode, it should not become in a way that you are not able to access it from India. You should be able to access it in India at all times so as to be usable for subsequent use. So not even 1 second. It should not be a case where we are not able to access the books. At any given point of time, you should be able to access the books. The books of accounts and all the relevant papers shall be always maintained in the original format. Okay. Audit trail, which I just said. The information received from branch office shall not be altered. As it is, you have to maintain it in the principal book. The information in the electronic record shall be in the legible form. For example, if you take fuel bills, it will fade away after some point of time, right? So it should be readable. There shall be proper system for storage, how to store the data, retrieval, how to take it whenever you want, display whenever you want to see, print out of the electronic records. So the system, whatever you are using, should be able to support all these things. Provided that the backup of the books of accounts shall always be kept in servers physically located in India on a daily basis. What do I mean by that? Imagine we are using some software, something which is not from India. They are telling you in such case you have to always keep one backup in such a software which is physically located in India. If you look at Zoho books is from India. So one software should be in such a way that it should always be physically located in India. That is what they're telling you. And the company shall intimate to the registrar on an annual basis at the time of filing of financial statements. So you'll be filing AOC 4, right, every year. In that, you have to clearly mention these details. What are these details? We are maintaining our books of accounts over a software, right? So you have to disclose the details of that software, like the name of the service provider, Zoho, the location of the server, where it is applicable, wherever the location is, mention that. Where the books of accounts and other books and papers are maintained on cloud, such address as provided by the service provider. You will have, right, IP address and all. You maintain all of those address has to be given to the registrar when you are filing AOC 4. Okay, next one. Sir, financial statements. How to maintain financials? Same thing. True and fair view. It shall be in the format that is Schedule 3 of Companies Act. That's the format of your financial statements. Sir, and this is very important thing. The company should always comply with the accounting standards. Sir, what if we do not comply with the accounting standards? Then, if at all, imagine people, law says I need to follow WDV method of depreciation. Instead of WDV, I followed SLM method. I'm just giving you an example. I have to disclose 3 things about that. What is that? Sir, I did not do WDV, I did SLM. Why? Reason. Third one, what is the benefit I gained because of the alternate method I used? What is the financial effect of the deviation? I have to disclose all of this. Clear? Non-applicability of section 129, meaning the schedule 3, all of that will not apply to some company citizens. Which one? Insurance companies, banking companies, and companies which are engaged in production and supply of electricity, and any other company for which any other specific format of financial statements are specified. So they need not have to follow this particular section. Okay. Board shall lay full documents in AGM. So in the annual general meeting, all the financial statements of the company has to be laid before the AGM. Correct? Adda. In Adda, the first year itself is what? Adoption of the accounts. I have to give it to the members, right? They have to accept whatever our expenses, revenue are in the during the financial year. We have to tell that, right? That is what they're telling you. Next one, we have to file consolidated financial statements of all the subsidiary and associate companies. What do I mean by consolidated financial statements? I have to file it of my subsidiary companies, my associate companies together. We have to present it, people. It has to be prepared as per the accounting standards. Sir, every time we have to prepare consolidated financial statements. Yes, every time you need to prepare. But there is one exception. What is that exception? It is if it is an unlisted company or not in the process of listing, whether in India or outside India, then people CFS will not apply for you. So if you are unlisted companies, for you CFS is not applicable. Next one, it's holding or intermediary holding company files CFS with ROC. What do I mean by that? Imagine there is company X. It has a subsidiary company. It has a subsidiary company. Imagine this is the holding company. This is a subsidiary company. So let us imagine if company X has already prepared the CFS. Why should company Y again prepare? That is what they are telling you. If it's ultimate company or an intermediate company, if they have hold or they have prepared a CFS, again you need not prepare CFS. That's what they are trying to tell. Third one, it is a wholly or a partly owned subsidiary of another company and all its members have given no objection on non-presentment of CFS. What is this, sir? There is a company X. The company X has a subsidiary company. Imagine we are holding 55%. Now company X does not want to prepare CFS. Now company X is okay with it. Not only that, in company Y, whoever are the other shareholders, imagine people, whoever is holding the rest of the 45%, even they will also have to give a no objection. Sir, we have no problem if you don't prepare CFS. It's totally fine. If you satisfy these conditions, people, CFS is exempted. Next one, exemption by CG. That is, this section can be exempted on any company if there is a special request made by the company and CG is convinced, or CG on its own thinks that in the interest of public, this company need not have to follow all the sections. CG can exempt you from following any of these provisions. Clear? Okay. All other sections related to financial statements, let us finish it off. Who shall sign the financial statements, people? The financial statements shall be signed by chairperson if authorized by the board. So what if chairperson is not authorized? Then 2 directors have to sign. In that 2 directors, one shall be a managing director. If there is no managing director, then only 2 directors will sign. And CEO, CFO, CS if appointed. Very, very important. Remember, imagine if your company has a CEO, your company has CFO and CS. Then remember, people, all 3 people have to sign, not only any one. All 3 people will have to sign. Yeah, so it will be 1 chairman or 2 directors and CEO, CFO, CS. Sir, what if it's a case of OPCA? Then people, only 1 director is sufficient. You need not have to get it signed by all the rest of the people. Clear? Okay. And one more connected. All connected sections will do it together. Okay. Periodical financial results. What does that mean? See, every year, people, a company has to prepare its financial statements, yearly ones. It has to be audited yearly ones, and it has to be filed with the registrar also yearly ones. However, if central government thinks that in the interest of the public or because of any reason, central government can direct any company to prepare the financial statements at such intervals, get it audited at such intervals, file it with the government at such intervals as may be prescribed by central government. I can prescribe whatever is the time. That is this periodical financial results. Clear? So prepare financial on such periodical basis. Limited review of periodical financials, that is audit as may be prescribed. File it with the registrar within 30 days of completion of the relevant period. Which relevant period? As may be prescribed. I can tell you to do any of these 3 things. Clear? Okay, done. And rights of members to copies of audited financial statements. Should we send it to the members? Of course we have to send. By when should we send? We have to send it, people, along with the notice of general meeting only you will send. So of course you will send it 21 days prior. So technically you will send it along with the notice of general meeting itself. Clear? Okay. Whom shall we send it to, sir? We will send it to every member and every debenture trustee, if at all there is any, and to all other persons who are entitled. Remember, every member includes equity as well as preference. We will send it to both. Timeline 21 days. Sir, what if general meeting is conducted in a shorter notice? If you guys remember that 95% condition and all. When that condition comes, I'll tell you the same thing will apply here also. So if it's conducted on a shorter notice, then you can give it even in a shorter period as well. That is absolutely fine. Sir, if it is a listed company, then what are they telling you? According to the listed entity shall give prior intimation to the stock exchange about the meeting of the board regarding the financial results wherever it is conducted. Meaning, in whichever board meeting you are going to conduct or you are going to discuss about the financial results, you need to disclose about such meeting to the stock exchange well in advance. Intimation shall be given at least 5 days in advance. Yeah, now it is made 2 days as per SEBI provisions. Yeah, a listed company, this first it was 5 days, now it is 2 days. But unfortunately in our books and all, it is not yet amended. A listed company shall also place its financial statements, including CFS if any, and all other documents required to be attached on its website. I'll also have to maintain all these documents on the website of the company. provided also that every listed company having a subsidiary or subsidiaries shall place separate audited accounts in respect of each of subsidiary on its website. Now, what do I mean by that, sir? Imagine if I'm a listed company. If I have a subsidiary company, they are telling you I have to publish my company financial statements on website. I'll also publish CFS on the website. If I have subsidiary company, their standalone financial statements also shall be published on the company's website. Which company? The holding company's website. Hello? Sir, whether this should be audited or the subsidiary company accounts, should it be audited or it's unaudited? It has to be audited, of course. Sir, what if, imagine my subsidiary company is not from India, it is from imagine some country outside India. So in that country the audit is not required. Remember people, if in such country if the audit is not required, then it is okay just to come and present the unaudited financials only with the declaration that I come from a country where audit is not mandatory. So what if it's not in English language? You have to also get a certified translated copy which is in English language. Okay, the 21 days, whatever we saw, it has to be sent 21 days prior to the date of the meeting. Okay, next one. So we are saying that we have to send the financial statements to the members, right? How do I send it? Simple people, if you are a listed company, today's date this limits and all makes irrelevant, but yes, still they say, if at all you are a listed company, and all the public companies which have net worth of 1 crore and turnover of more than 10 crore, then people, they will send all their financial statements and all the supporting documents by electronic mode. If a person's shares are in DMAT form. So if your shares are in DMAT form, we will send you all the details by electronic mode. Sir, what if my shares are in physical form? We will ask you, is it okay if we send it in electronic mode? If you agree people, then we will send it in the electronic mode. Sir, what if I don't agree for electronic mode? Then for such people, we will have to give it in a physical copy. But remember, the company is free to charge you for the physical copy. Clear? Yes. Sir, copy of financial statements to be filed with the registrar. Now, what is this, sir? Once the company's okay, company, once it's adopting the financial statements, now what do? The company will have to file the financial statements with ROC. Now, what is the format of the financial statements, sir? The format people will be, if it's a normal company, it is form AOC 4. Sir, if I have to prepare the consolidated financial statements, CFS, how do I prepare? It will be in AOC 4 CFS. Sir, for some companies, XBRL will apply. How do they file? They will file in AOC 4 XBRL. Hello? Clear? And remember, which financials we will file? You will always file the financials people which are adopted in the annual general meeting. Sir, what if the financial statements are not adopted in the annual general meeting? Then we will file something called as unadopted financials only. The ROC will consider such unadopted financials as provisional, temporary. And once you guys again conduct the AGM, and if the shareholders adopt your financial statements, you have to file such adopted financial statements again with the registrar. Sir, what if subsequently we were not able to adopt the financials? It's okay. You will file that unadopted financials only, and imagine you were not able to adopt because you did not conduct the AGM at all. In such case, you have to file unadopted financials with the reasons for not conducting AGM. That is what is given in the whole paragraph. Done now? Done. When do we file the financials, sir? You will file it within 30 days of AGM or the due date of AGM. If it's a case of OPC, of course there is no AGM. Then they will file it within 180 days of the closure of financial year. Remember this and go. XBRL is mandatory for whom, sir? Very important. It is mandatory for companies which are listed with stock exchanges in India and their Indian subsidiaries. So Indian listed companies and their Indian subsidiaries, whether you are listed or not, for all of you people, this becomes mandatory. Next one. Companies having paid up capital of rupees 5 crore or more. Companies having paid up capital of rupees 5 crore or more. Companies having turnover of 100 crore or more. Or all companies which are required to prepare financial statements in accordance with companies Ind AS rules. So whichever companies come under this brackets, for them XBRL format is mandatory. XBRL is nothing but people, it's just a format. Financial statements is still the same. You're reporting financial statements only. But how you're reporting is changing, that's all. What you're reporting does not change. How you're reporting alone changes. Is clear? All of you? Pakka? Okay. Okay, fair enough. The next one, sir, is your reopening of accounts. We'll do that. There are two types of reopening of accounts. One is mandatory, next one is voluntary. Mandatory people, what is reopening of accounts? Let us imagine we are in the year 26-27. In the year 22-23, we have done some fraud. We have tried to cover some, fraudulent numbers. That is, we have inflated the financial statements or we have done some fraud. We are trying to cover it up now. Now imagine IT authority, when they were doing an inspection, they got to know that this company has mismanaged their statements. Or SEBI, in the case of Harshad Mehta, Satyam scam, SEBI got to know that this company has done all fraud. Now what will SEBI do? SEBI will file an application, people, to the tribunal and say, sir, we don't know whether whatever financials that the company has filed in 2022, 23, 24, 25, whichever is a year, we doubt on their genuinity. We think that they have done some fraud. Can you please allow us to go back to that year, open all the books of accounts, recheck it, reconfirm whether whatever the numbers they have mentioned, is it right, is it fair or not? Now what will the SEBI do? SEBI will file an application to the tribunal. What will tribunal do? Tribunal will forward this application to all the other authorities like central government, like ROC, like income tax authorities, any other authorities. The tribunal is going to forward the application to all these people waiting for their objections. Now if anyone has an objection, people, it will go to hearing. Sir, what if there is no objection? Then people, it is assumed that it is deemed approval. We don't have a problem. Clear? All of you? Sir, when do we generally do this? If we think that the accounts or whatever the books of accounts that were prepared by the company, it was in a fraudulent manner, or the affairs of the company was mismanaged, meaning that the directors is not a good fellow. He has mismanaged the, the money of the funds, the money of the company a lot of times. In such cases, you are allowed to go and reopen your financial statements mandatorily because of the court's order. Is this clear? Sir, what if they did not tell? We only realize that it's not fraud, but whatever we have reported is wrong. Then what can we do? In such case, people, you will go to the next section, that is section 131, voluntary revision. Whenever a company thinks that we have not properly complied with section 129 and section 134, that is board's report and financial statements, we only think we have done some mistake. In such case, what will happen, people? We will file an application to the registrar. to the tribunal. The tribunal will again forward the application to all the other authorities. If the authorities have any problem, they will give a objection. If they have no problem, people, then you can go ahead with your voluntary revision. Simple. Sir, mandatory revision can happen for the last 8 years. But voluntary revision you cannot do for a period beyond 3 years. Remember, that's the difference. Clear, Ram? Yes, Ram? Okay, the last section, sir, technically not that important also. This is NAFRA. For us, it is not that important. What is NAFRA? NAFRA is nothing but, people, National Financial Reporting Authority. It was formed to recommend and pass accounting and auditing standards. So for our domain, it is not that relevant. So NAFRA also makes sure it oversees the work of the professionals, whether they're doing right or wrong. If at all any professional does work which is not up to the mark, it will advise on what are the changes. And if anyone has done a fraudulent action, NAFRA can even penalize such person. And NAFRA is again a body corporate which is established by the central government, and hence the NAFRA books of accounts are also audited by CAG. CAG also prepares an annual report which will be submitted under both the houses of parliament for the members' approval. So remember this much and go from NAFRA. NAFRA is more than sufficient. They will not go any much in detail. What is the penalty prescribed by NAFRA? Why is NAFRA formed, people? Imagine there is a CA. A CA is appointed to audit one company. What if the CA only has not audited this company properly? So NAFRA will oversee how this professional has done his work. That is only the job of NAFRA, oversee the work of the professionals. So what is the penalty? If tomorrow if I get to know you have done something, then I can impose a penalty. If at all you are an individual, I can impose a penalty of 1 lakh, which can extend up to 5 times of the fee you have taken. If you are a firm, the minimum will be, people, 5 lakh, which can go up to 10 times of the fees you have taken. That's all, sir. You can also be debarred for how many days, sir? Minimum 6 months. That's all. It can go up to maximum 10 years. You cannot take up any audit, nothing. Hello? That's all? Yes? That's your NAFRA. Accounting standards, that's okay. Okay, let us do the appointment of audit and auditors. So as I generally say, this chapter has 2 parts. One is accounts, one is audit. So this is your part A. Now let us start our part B. So what is there in part B? Yes, people. So in the auditors, appointment of auditors. So as you all know, I can write the types of auditors as 4. Which is the 4th one, sir? The first one is, people, the statutory auditors. The statutory auditors, that is only CA. Next one is, people, secretarial auditors. This is only CS. Next one is, people, the cost auditors. This is only your CMA. So this we know, which is the 4th one. The 4th one is called as internal audit. That is what is there in our syllabus. All 4. Yeah. One thing you guys have to remember. Easy tip that I can give you. The statutory auditor, only the first auditor is appointed by the board. Rest of all the statutory auditors are appointed by the shareholders in the AGM. Who appoints them? Shareholders appoints them, except the first auditor. The first auditor is appointed by the directors only. Sir, apart from that, these three people, it is appointed, remunerated, everything people, the appointment is done by board of directors only. They are appointed by shareholders. Remember this, very, very important. Clear? Same thing applies even to the KMP also. Who appoints the KMP? It is the directors who appoint the KMP. Clear, all of you? Okay. So, sir, appointment of auditors. The first auditor, sir, depends upon the type of company. If it's a government company, then who appoints? Within 60 days of incorporation, the Comptroller and Auditor General of India will appoint the first auditors in a government company. Example I can give you is ONGC. All the government companies or the government entities, statutory companies, all their audit is done by people, the CAG only. Who is CAG? Comptroller and Audit General of India. They will appoint the auditor. He will report to them. So within 60 days they will appoint. What if CAG is too busy? They are not able to appoint. Then people within next 30 days the directors will appoint the first auditor. Sir, what if even the directors also fails to appoint within 30 days? Then people within next 60 days the shareholders will appoint. Now I know your question. What if even shareholders also does not appoint? Then die. Then how long we can keep on going like this? Yes. So next one, what if I'm any other company? Any other company means not a government company. It can be private, public and all. In that case, people, within 30 days of incorporation, the first auditor will be appointed by the directors. Sir, what if the directors fails to appoint, sir? Then it will be shareholders within 90 days. Remember, this is the first auditor. Sir, what about the subsequent auditor? Remember, whosoever is the first auditor appointed by the directors, their validity will be only 1 year. Meaning the company is incorporated today. The company will conclude its first financial year and they will conduct their first AGM. In the first AGM, now they are going to appoint anyone else, or the same fellow can also be appointed, or you can appoint someone else in their position. That is also fine. But in the first AGM, the current auditor, whoever is appointed by the directors, now that person will have to retire in the first AGM. Clear? Yes. Now whosoever is an auditor appointed in the first AGM by the shareholders, he shall hold office for a period of 5 years. Clear? All of you? Yes. Okay, done. Easy breezy. Next one, tenure or rotation of auditors. First of all, is this rotation of auditors applicable for everyone? Answer is no. Why did rotation even come into picture? It all started because of the scam that happened in Satyam. What happened? There was so much of scam that happened in Satyam for years, but the world never got to know about it. So the authorities said, if at all you guys had done that particular thing properly, if you had, alerted the people that there is some fraud, then all of this wouldn't have happened at all. By that time, the internal auditors were PwC. So what did the authorities say? It is all happening because they are getting used to the environment. You have been an auditor for 5 years, 10 years, 15 years. So what happens? You become a friend of them. So you will not be able to achieve your objective. You will not be able to perform your duties to the best of your abilities. So what do? You tend to miss out. You may be little more lenient. You may become biased. So they say nothing doing. After 5 years, it is your duty to leave the company and next auditor will come and take over your position if you are an individual. Sir, what if I am a firm? Then you can be there on the board for 2 terms of 5 years. After that, there will be a cool off of 5 years. So someone else has to come and take up the appointment. Sir, this condition is applicable to every company. No, it is only applicable to listed companies. Unlisted public company having paid up capital of 10 crore or more. Private company having a paid up capital of 50 crore or more. All companies having borrowing from financial institutions, banks, public deposits of 50 crore or more, for these companies, rotation of auditors will apply. If it is applicable, then an individual can be an auditor maximum for a period of 1 term. After that, there is a cool off period of 5 years. If you are a firm, 2 terms of 5 years and 1 cool off period of 5 years will be there. So 10 years, 5 years cool off period. Okay, next one. Yes, one more thing is you can never appoint the firm which has a common partners. What do I mean by that? Let us imagine we had appointed A, B, C and Co as our auditors. Now their 10 years is done. Now we need to appoint one more auditors. The next auditors is called as people C, D, E and Co. So here and here there is a person called C who is a common partner. If there is a common partner, you cannot appoint such a audit firm as the next auditors. Purpose not served, no. Next one, casual vacancy of auditors. What do I mean by casual vacancy? If at all they leave, then what is going to happen? In case of company whose audit is done by CAG, then if at all there is any casual vacancy, within 30 days people, CAG shall fill that vacancy. Within 30 days, if CAG does not do it, then people, the board shall fill the vacancy. Sir, in the case of other companies, within 30 days, board will fill the vacancy. But just like your debenture trustee, if at all the vacancy is due to resignation, then remember people, the board only will fill the casual vacancy. However, within the 3 months of the board appointing the auditor, it should be approved by the shareholders as well. You have to call for a general meeting. You need to take the approval of shareholders. This person will hold the office up to the conclusion of one AGM. That AGM, once the AGM is completed, again in the AGM you will appoint one more person for a period of 5 years. Hello. Okay. Next one, reappointment of retiring auditor. A retiring auditor may be reappointed at an AGM. So technically what happens, imagine if rotation provisions are not applicable to me. Then what happens? The same auditor can be reappointed for 5, 10, 15, 20, 30, 80. How many years you want? You appoint. Why? Because if rotation is not applicable, then you can have the same auditor, no? So they are telling you the same auditor can be reappointed provided he is not disqualified. He has not given his unwillingness. He has said, no, I don't want to continue. Or the company has passed a special resolution. We don't want this fellow. No auditor is appointed or reappointed. The existing auditor only can continue. Provided if he is not disqualified and no other fresh person has been appointed, then the existing auditor only will be automatically reappointed. Next one, sir, section 115. What is this? Resignation removal. Section 140 read with 115. Nothing but people special notice. In management and administration chapter, this will come. Special notice. What is that? A few shareholders, they are unhappy with the way auditor is performing his duties. So we will request the company, sir, please can you remove this auditor, or please do not reappoint this person, please reappoint someone else in his position, or remove him from the job. Now this is only called as what people special notice. How do we do? Imagine a shareholder gives a request of removal of an auditor. He will give a request to the company. What will the company do? The company will forward that request to the auditor. The auditor will give his reply. Now, all of this will be circulated to the other shareholders as well. But if someone thinks this auditor is doing all of this for needless publicity, you can stop that auditor's comments being circulated to other members. You can stop it by filing an application to the tribunal. You can say that, sir, this person is doing all of this for needless publicity, and you can stop the circulation of the comments passed by the auditor. Hello, sir, and always remember, if you want to remove a secretarial auditor, cost auditor, internal auditor, you can remove it just by directors. If they want, they can remove. If you want to remove a statutory auditor, then remember the approval of central government and shareholders both are required. So first what will you do? You will first pass a board resolution. Within 30 days of board resolution, you need to apply for central government's approval. Sir, we want to remove him. Is it okay? You have to prove it. Why you want to remove? You will apply it in the form ADT 2. Once the central government gives you a reply, you need to now call for a shareholders meeting and you need to pass a special resolution. See, all these conditions you need to satisfy to remove an auditor. Clear? Okay, next one, resignation by auditor. You can resign. Of course, it is your choice. You can resign it by writing in the format ADT3. You will inform to the company. You will inform to the registrar. And if you are listed, you will also inform to the stock exchanges and SEBI. And if you are a government company, you need to also inform to CAG. Remember. Hello. That's all. That's your section 140. Section 141, sir, which speaks about what? Qualification, disqualification of auditors. Okay, who can be an auditor? Of course, you need to be a chartered accountant, or you can even appoint a firm as a auditor, provided the majority of the partners has to be qualified to be a chartered accountant. So disqualifications, who cannot be an auditor? First one is a body corporate, meaning a company cannot be an auditor. LLP can be, but a company cannot be. Next one, an officer or employee of the company. So you cannot appoint your own employees or officers as your auditor. Of course, they'll be biased. Next one, a person who is a partner or who is in the employment of an officer or employee of the company. What do I mean by that, sir? We cannot appoint, let us imagine, we are planning to appoint a person in a company. Let us imagine we are planning to appoint a person in Reliance. Now in Reliance, there is an officer. Who is this officer? Let us take, for example, the managing director. Who is he? Let us imagine Mukesh Ambani. Mukesh Ambani has one partnership firm. In this firm, there is one more partner with him, called as, let us imagine, Mr. Yash, who is also a partner in the partnership firm where Mukesh Ambani is also a partner. They're telling you Mr. Yash cannot be appointed as an auditor of Reliance company. Next one, Mukesh Ambani has one other company. Let us imagine Jio. In that, there is one more employee who is working in Jio. Let us imagine that is Mr. Shah Rukh Khan. Shah Rukh Khan also cannot be appointed as auditor of Reliance Industries. That is what they're telling you. An officer, the partner of the officer or the employee of the officer cannot be appointed as a auditor of the company where the officer is working. You cannot have the same person. You cannot have this person as a auditor because you will be biased. Clear? Okay. Next one, a person who is or his relative or partner holding any security in the cash, that means company, associate, subsidiary or holding, or a subsidiary of such holding company, provided that relative may hold security face value not exceeding 1 lakh rupees. What do I mean by that? We are planning to appoint a person in Reliance Industries as an auditor, but if this person is holding any shares in Reliance Industries, he is disqualified. Sir, what if I am just holding one share? Even then you are disqualified. Either sell it off. If you hold it, you are disqualified. Sir, we are in a partnership firm, ABC. Then none of your partners should hold any shares in the Reliance Industries. Sir, what if Mukesh Ambani's wife, let us imagine Neeta Ambani is a shareholder. I'm just giving you a generic scenario. Let us imagine he is not a managing director or anyone. we want, okay, let us imagine, not Mukesh Ambani at all. We want to appoint a person called as Mr. A as an auditor in Reliance Industries. Now imagine Mr. A's wife is holding shares worth 50,000 rupees in that particular company. Now the question is Mr. A qualified to be appointed as an auditor? Answer is yes. Relative can hold up to 1 lakh. Sir, is it like wife 50,000, father 50,000, son 50,000, brother 50,000, sister 60,000, mother 50,000? They are telling you people, it is not written specifically. So we always take it as a consolidated. All the relatives put together cannot exceed 1 lakh. And 1 lakh is not market price, it is face value. Very important, remember. Okay, done. Next one. A person who is indebted to cash, that means company, associate, subsidiary, holding company. A person who is indebted, that means what? I have taken loan. How much? In excess of rupees 5 lakh. Up to 5 lakh is okay. But if you have taken a loan in excess of 5 lakh rupees, you are disqualified. A person who has given a guarantee or provided any security in connection with indebtedness of money exceeding 1 lakh rupees. That means I did not take loan, sir. My friend took it, but the auditor has given the guarantee. Then people, if he doesn't pay, you will have to pay. No, then you will be biased. You cannot be a auditor. Next one. A person or a firm who, whether directly or indirectly, has business relationship with cash, subsidiary, holding, associate company. The business relationship is considered a commercial purpose, except commercial nature of professional service and the ordinary course of business. What is this, people? Hey, people, simple. Imagine there is a company called as Swiggy. Now Swiggy will appoint a person as an auditor. Now he has come to the company to work. One day he was feeling hungry, so he opened his Swiggy app. He selected whatever he wants. The Swiggy person came and delivered the food. Now if you look at it, this person had a business transaction with the company in which he is an auditor. That is what they are telling you, no. A person or a firm, whether directly or indirectly, has a business relationship with the company, associate, subsidiary or holding. It's a business relationship. Now you tell me, is the auditor disqualified? They are telling you, no, he is not disqualified. Why? Because this is entered in the ordinary course of business. Now the only important thing we need to check here is, at what price did this fellow get this food? Did he had any special coupon called as auditor? If answer is yes, he is disqualified. Arm's length price means how much ever you and me are paying. If he is also paying the same amount, then people, there is no restriction. He can be appointed as an auditor. Clear? Next one, a person whose relative is a director or is in the employment of the company as a director or KMP. What do I mean by that, sir? Let us imagine there is a person in Reliance Industries. There is Mukesh Ambani who is a director. Mukesh Ambani's relative, let us imagine anyone. Now if imagine, say for example his wife, if we want to appoint his wife as a CA, they are telling you it is not possible because her relative is a director. Her relative is a KMP and hence even she is also disqualified. Hello? Sir, what if Mukesh Ambani is not a MD? He is just a software engineer there. Then it's absolutely fine. This restriction applies only and only for a director or a KMP. If he is any other employee, then the relative is not disqualified. If such person or partner, what is this, sir? Remember people, the maximum number of audits that an auditor can undertake will not exceed 20. So one auditor can be an auditor of maximum 20 companies. However, in this 20, certain companies are not counted. Which is that company? dormant, not counted, OPC, small company, and private companies having a paid up share capital less than 100 crores. These companies are not counted in the limit of 20. So you can be an auditor of, imagine if there is a small company, you can be an auditor of even 200 small companies also, absolutely fine, because it is not counted in the limit. Hello? Okay. That's your auditor. What are the powers of auditor? Basically to ask for any information, get all the information, check all the records. He has a right to access all the documents, whether that company's branch, subsidiary companies, to prepare CFS. I can check everything. That's my right. Duties: I have to make sure all the accounts are prepared true and fair. The personal expenses are not recorded in business. So all those things I need to make sure. The main thing, go to audit of a government company. So remember, whenever an auditor submits his audit report to the Comptroller and Audit General of India, CAG, CAG can do three things. The first thing, if I think this person has done the audit properly or not, I'm not sure, I want to check. How will I check? I can conduct something called as test audit. What do I mean by test audit? That means I can randomly check it. Whatever you have done, you have already audited, no? That only I will randomly check it. Next one, I can also do something called as supplementary audit. That means I'm not happy with the audit you have done. I can appoint one more person. I can get the entire audit redone. That is called supplementary audit. And the third one, I can even pass comments. CAG can pass comments on whatever are the audits that it has done. It can pass its comment on it. That is the third thing that the CAG can do. Hello? Clear? Okay. Next one, reporting of fraud. Whenever an auditor is doing his job, he comes across a fraud. How will he report the fraud? The auditor will report the fraud in this way. If the fraud involved is rupees 1 crore or more, whatever is the amount of fraud, if it's 1 crore or more, within the 2 days of the auditor getting to know the fraud, he needs to immediately write a notice to the audit committee. If there is no audit committee, then to the company's directors, saying that people, I came across a fraud. This is what I was able to know. This is what I was able to make a note of. What is your opinion on this? The company has to reply within 45 days to the auditor. Now, once they reply within 15 days, the auditor will forward to the central government. The auditor's notice plus the reply given by the directors, both I will forward it to the central government. Sir, which central government? I will forward it to the Secretary of Ministry of Corporate Affairs. That, sir, we sense that there is some fraud that has taken place. And we report all of this in the format ADT4. Hello. Clear? Sir, what if the amount involved in the fraud is less than 1 crore? In such case, people, same thing, within 2 days, will report it. Now, what will the company do? In the report, people, I will clearly say what is the nature of fraud, who are the parties involved, what is the amount of fraud. I will clearly mention. Now, the reply for this, the company will give it in the director's report. They will clearly say what is the nature of fraud, what is the amount involved in the fraud, what are the parties involved in the fraud, and what was the remedial action taken, meaning what is the action taken by the company for whatever we have pointed out. So, they have to reply this 3 plus 4 in their board's report. Clear? Hello? Okay. So, the last part, sir, is your cost audit. Now, when is cost audit applicable, sir? Applicability. It is mandatory for companies engaged in the production or supply of goods and services like telecommunication, electricity, pharmaceuticals, fertilizers, steel, all these cases. Sorry, every company, all these companies having overall turnover of rupees 35 crore or more in the preceding financial year, they shall include cost records in their books of accounts. You remember books of accounts definition? So these industries having this turnover will also have to maintain an additional books of account that is only called as cost records. Now sir, what will I mention in the cost records? The format of cost records is CRA1. I will maintain the details of cost of operation, production, profits, sales as the case may be. Exception, all of this is not required for micro and small enterprises. The cost auditor, applicability, it is applicable to the companies covered in Rule 3 and 4. Which are the companies? Basically, there are two lists. One is called as regulated sector, one is called as non-regulated sector. Regulated and non-regulated sector. Regulated sector means people, you have some, I would say, you have a, regulator. Example is a telecom. Non-regulated sector, I can give you is, best example is steel, arms and ammunition. All of that, who is a regulator? So they will come here. So sir, when is cost audit applicable? Cost audit to be applicable, people, the overall turnover of the company of all the products and services put together should be 50 crore or more. Because a company can have multiple products, right? And aggregate turnover of individual products or services should be 25 crore or more. Now what do I mean by that? For example, let us imagine there is a pharmaceutical company. All the products and services put together, they have so many things, right? Pharmaceutical, there are operations, there are scannings, there are blood tests, they will have pharmacy, they have everything, right? So I'm telling you, everything put together should be 50 crore and aggregate turnover of individual product or service. Let us imagine only pharmaceutical, the medicines. That should be at least 25 crore. If both the conditions are satisfied, then yes, people, for you cost audit becomes applicable. Sir, what if I am a non-regulated sector? Same thing. Overall turnover of 100 crore, individual is 35 crore or more. Exception, the cost audit shall not apply to a company which is having revenue from exports in foreign exchange which exceeds 75% of its total revenue. Imagine there is a company who is just exporting and we earn 100 crore as revenue. In that, people, 75 crore we are earning from exports only. Then people, cost audit not required. Next one, a company which is operating from SEZ, Special Economic Zone. The third one, a company engaged in generation of electricity for captive consumption. That means what? Generally, a company which is involved in generation of electricity, for you cost audit becomes mandatory. But there are a few companies who generate electricity, but they do not make money out of it, but they use it for their own purpose. That is only called as captive consumption. So if anyone is generating electricity just for their internal purpose, they are not covered under this rule. Simple. Okay, next one is cost audit report. How do we do it? A cost auditor will submit a cost audit report in the format CRA3 when within 180 days of the closure of financial year. We submit it to the board of directors. They will forward it to the in the format CRA4XBRL to the central government. When do we appoint the cost auditor? We appoint the cost auditor within 30 days of the board meeting or within 180 days of commencement to the financial year, whichever is earlier. And whenever you appoint a cost auditor, you need to intimate it to the central government in the form CRA2. And remember, the cost auditor is always appointed by the directors. The remuneration can be ratified by the shareholders. The tenure of the cost auditor till expiry of 180 days from the closure of financial year or till he submits the cost audit report. Removal, see who can remove. Directors only can remove. That's what I told you. That's your cost audit. The last person, sir, secretarial audit. To check and report. What is the job people who do secretarial audit? Basically, a practicing company secretary conducts a secretarial audit. Your main scope is to make sure you check every applicability of the law, alert the company whenever there are any non-compliances, and yes, try to safeguard the company from any penalties, violations, as the case may be. When is the secretarial audit mandatory? If you are a listed company and if you are a public company having a paid up capital of 50 crore or more, public company having a turnover of 250 crore or more, or every company having outstanding loans, borrowings, or from any financial institutions of rupees 100 crore or more. Such companies have to mandatorily get their records audited by secretarial auditor. Secretarial audit is prepared in the format MR3. It is always addressed to the shareholders. Correct? There is some amendments there. What is that? The class only we would have done. Nothing new has come this time. Okay, what is the amendment, people? Amendment is, now whatever we saw is as per Companies Act. Now as per SEBI LODR, what is the condition? As per SEBI LODR, the secretarial audit is to be made compulsory for all listed companies. This is as per Companies Act. And not only that, people, the secretarial auditor should also be extended to all the material unlisted Indian subsidiaries. This is as per SEBI LODR. What do you mean by that? If at all there is a listed company and if they have the list of subsidiary companies, so for those subsidiary companies, in that whichever is the important subsidiary companies, that's why we are calling it as material subsidiary. We need to get even that company's records also secretarial audit done. Sir, what is a material subsidiary? It shall mean a subsidiary whose turnover or net worth exceeds 10% of the consolidated turnover or net worth respectively. What do I mean by that? Let us imagine, take a company A. Imagine company A has two subsidiaries, company B and company C. If I take all these three company ka turnover, imagine it is coming to 1000 crores. In that, there is one company called as company B. The company B is contributing people around, let us imagine 300 crores. Now we call company B as a material subsidiary. Why? Because if you take the overall turnover is 1000 crore, in that, people, 30% is generated by one of your subsidiary companies. That means it's very, very important. Look at the money coming and you logically try to think, people. We have given money to company A. Company A has given further money to company B. What if any frauds happen there? That is also important for us. That's why we are telling you need to get even those records also secretarial audit done. Is clear, sir? Is this the amendment? Hey, this was already there. Da? Okay. Next one. Secretarial compliance report. What is secretarial audit report? What is secretarial compliance report? Secretarial audit is, people, nothing but you will check whether a company has followed all the applicable laws or not. You will check. That is called as secretarial audit report. Secretarial compliance report is nothing but you will check whether the company has followed all the SEBI laws or not. Now, there are so many SEBI laws, right? So many acts, so many regulations. SEBI keeps issuing so many circulars, so many notifications. You will check whether the company has followed all of this or not in a year. That is only called as secretarial compliance report. Even that is also done by practicing company secretary only. Remember. Sir, when is this submitted? Secretarial compliance report is submitted within 60 days from the end of financial year. Sir, is that the amendment? No, that was also there. The only thing is that people, they have got it one condition. That condition is now, see, as per SEBI LODR, it says every listed entity and its material unlisted subsidiary incorporated in India shall undertake secretarial audit by a secretarial auditor who shall be a peer-reviewed company secretary. What do I mean by peer-reviewed company secretary? Peer review is nothing but people. Let us imagine now there are a group of company secretaries. Let us imagine there is a person, a different person, A. There is another company secretary, B. There is another company secretary, C. Imagine A is some 10-year experienced company secretary. B is also, let us imagine, some 11-year, 10 to 11-year company secretary. Now C is, say for example, 4-year experienced company secretary. Now what do I mean by peer reviewed? Peer reviewed means what, people? Remember, you as a professional, when will you grow big? You will grow big when whatever are the works you have done, it should always be free from defects. You need to know what you're exactly doing, right? So who will come and help you? Your fellow company secretary, that is in your industry only, someone who is equally experienced as you are. He will come and check your work and say, sir, based upon me checking your 2-year, 3 years works, these are the best practices you are doing and these are the areas which needs improvement. So what happens? You as a professional, you will grow. And even in the industry, you will have a very good, priority, preference. Why? Because remember, one of your competitor has told that you have done a great job. And remember, here no one will do it for sake of it, namesake. No one will do. They will give you a proper review. If not, they will challenge it. So if your firm is peer reviewed, you will get more clients also, big clients also you will get. Earlier this was optional, now they have made it mandatory. So for you to issue a secretarial audit report, you guys have to get it done only from the peer reviewed company secretary. Let us imagine Mr. C has not got his firm peer reviewed. No one has checked his work. He cannot take up secretarial audit of a listed company. Not possible. Is this clear? Okay, this is the amendment number 1. Amendment number 2 is that, people, earlier we did not had any restriction on our tenure. You could have appointed secretarial auditor for 5, 10, 15, 20 years also. Now there is a restriction. Whatever we saw for auditor, the same one term of 5 years for individual, and if you are a firm, then 2 terms of 5 years with a cool off of 5 years is applicable as it is. Hello, Clear? Yes, sir. I hope you understood that. So going forward, this is not applicable for an unlisted company because LODR, no? So it is only for listed companies. So what is a summary, sir? Remember, if at all you need to get a secretarial audit report or even secretarial compliance report going forward, you can only get it from a company secretary who is peer reviewed. Both audit report as well as compliance report. It is applicable for both of them. Remember. Clear? Yes, sir. Done. The last one, sir, is internal audit. What is internal audit, people? Nothing but whenever an audit is done on a regular basis, to avoid any bigger financial frauds, we check, we audit, we rectify the mistakes on a day-to-day basis. That is only called as internal audit. Sir, is internal audit mandatory? It is mandatory only for listed companies. Sir, what about other type of companies? If you are a public company, if you are having a, remember Deepika Padukone likes to work for L&T. Deepika stands for deposits, 25 crore. P, paid up capital 50 crore. L stands for loan 100 crore. T stands for turnover 200 crore. 25 into 50, 25 into 250, 50 into 200, 100 into 2, 200. Try to remember this in the same order. And here there is one specific point. See here, outstanding deposit 25 crore or more. Paid up capital 50 crore or more. Turnover 200 crore or more. But look at loan exceeding 100 crore. That means what? Exactly 100. The internal audit will not apply. It will apply only in the case of 101. Clear? So this is in the case of public company. What if it's a private company? So in private company, what happens, people? Only your L&T conditions are there. So Deepika Padukone does not work for private company. So D and P are not there for private company. Rest of it is there. So 200, 100 as it is. Hello. Clear? Pakka? Okay. Sir, now here they have given us some stars. What is this star, sir? In exams, we'll see stars, if these conditions come. Remember here, this is a maximum they can ask in exam, people. They'll not ask anything else in exam. What is that? Whenever there is 1 star, that means what? You will check it as on the end of the financial year. So let us imagine if I'm seeing if 26, 27 is internal audit applicable, I will just check for 25, 26 year end. That is 31st March 26. On that day, I will check paid up capital. Wherever there is a single star. But whenever there is a 2 star, you will check at any point of time during the preceding financial year. What do I mean by any point of time? Now check where the 2 stars are there. Let us imagine that 2 stars are there in the case of loans. There is 100 crore. Now let us imagine in the month in 25-26, in the month of 1st May 2025, our loans were 130 crore, which on 1st November 2025, we repaid 40 crore. So we have repaid 40 crore. So as on the end of the financial year, when we prepare the accounts, our total outstanding loan is 90 crore, which is less than 100 crore. Now the question is, should we appoint an internal auditor? Is internal audit applicable for us? Answer is yes, it is applicable for us, because what does the condition say? If these limits are touched any point of time during the preceding financial year, even for 1 day, then people, internal audit is applicable to you. That's the the power of 2 stars. Clear? Yes. Okay, next one. Who can be an internal auditor? It can be a CA. It can be a cost accountant. Can a CS be an internal auditor? According to the theory, yes. Practically, no, because it is not our subject, or it is not our area of expertise. But theoretically, you can. But practically, not really. So such other professional as may be decided by the board to conduct internal audit of the functions and activities of the company. Clear? Okay. And remember, internal auditor can be a firm, it can be a body corporate, it can be an employee, it can be a consultant. You can appoint internal auditor however you want. Past your questions, blah, 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 blah. That's all your accounts and auditors. I hope that was a really in-depth revision. We have tried to cover every point in our book, and yep, let's do the next chapter. You guys can go for a break and come. We can continue with the next chapter.